What's up, guys? Welcome back to Kitchen Court Cases, where we watch court in my kitchen. Thank you so much for being here. We have a mix of things to watch tonight, so I hope you are ready for some fun. If you are new here, my name is Kitchen, and this is one of the kitchens that I am in sometimes. And we like to watch court here. Tonight we're going to be watching. It is not a detention hearing in the sense that we normally see. It is a adjudication hearing, but it is with our favorite gang of characters, if you will. So, I'd like to remind everybody to please clock in for your shift. We need that. And please sit back, relax, and enjoy this adjudication hearing, which we will learn about together. I appreciate your patience.
Okay. All right. Are we ready to proceed?
Yes, sir.
Yes, sir.
Mr. Boneberg?
Yes, sir.
Okay, great. Kelly? So the court will call cause number 323-113125-20. This is styled in the matter of Angel Ramon Cuellar. We're here for adjudication on this matter. The court will take judicial notice of all the documents on file in the court's record, and included in the file specifically is a petition regarding the child engaged in delinquent conduct filed on February 11, 2020. On June 3rd, 2020, the grand jury approved this matter for determined sentencing punishment for the offense of aggravated robbery. The child was served with a summons on July 29th, 2020, and the child's parent was served with a summons on this matter, Jesus Cuellar, on August 31st of 2020. Also in the court's...
Also, Judge Kim, just before you even talk too much, I just want to jump right in here. So, first of all, folks, let me just pop myself right back up on the screen. I forgot to ask, what are you having for dinner tonight? And if you didn't like what you had for dinner, let me know what you wish you had for dinner. Anyways, let's do a little bit of learning because what we have here is different than our regular fare. So normally what we watch is called a detention hearing, and those are held as required by law on a very tight time frame and basis for each youth that's brought into detention in this facility. This hearing is something you'll sometimes hear Judge Kim refer to, which is called an adjudication hearing. So adjudication is, honestly, I should just watch this before I speak and insert the foot into my mouth. I'm going to make a pre-guess here. I think they're either determining whether or not to give up his jurisdiction. No, that's giving up his jurisdiction. Adjudication is just guilty or innocent, I think. But anyways, let's watch. We'll figure it out. Also, okay, so I see barbecue Pringles and Debbie cake, toasted cheese sandy with cookies, yummy, 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 ice cold brew, eggs Benedict. Those all sound yummy. Okay, can I make a hollandaise? Of course I can. I can make anything I put my mind to, even a mess.
File is a 3914 manifest for discovery, filed with this court, a stipulation of evidence, confession, and disposition agreement. Also filed with the court under seal is a victim's court report and a social history. The court has yet to review these documents and will not do so until the appropriate time.
But may I interrupt just one second?
Yes, sir.
On the dates, you had mentioned that the state's petition was filed on February 11th. I have February 14th.
Oh, yes, it's the timestamp from the clerk bled over to the letters.
Okay.
So all I saw was the 1-1, but yeah, on further review, it's February 14th.
Okay, thank you. Sorry to interrupt.
That's all right. Yes, February 14th, 1:26 p.m. Okay, so Angel, I have a couple things I want to go over with you. First of all, I need you, and is that your father, Jesus?
It is.
Okay, if you can both raise your right hands for me. Do each of you solemnly swear the testimony you're about to give at this cause currently at trial, that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Okay, please, you can lower your hands. Angel, I have a couple questions for you. First, can you tell me what your full legal name is?
Angel Ramon Cuella.
A little louder.
Angel Ramon Cuella,
Okay, and what is your date of birth?
January 22nd, 2004.
Blah, 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 blah. Sorry,
Angel and
live
Dad,
edits.
can you switch places? Because I have more questions for Angel than Dad. And maybe he needs to be closer to the microphone. All right, thank you. All right, are you an American citizen?
Yes.
So I do have to go over a couple things with you. First of all, I have to let you know the nature and possible consequences of these proceedings. This is a determinate sentence offense for aggravated robbery with a deadly weapon. A result of these proceedings could end up with a commitment for you into the Texas Juvenile Justice Department for a period of up to 40 years. And if you were not to complete your sentence by your 19th birthday, I could make a decision to transfer your commitment to a sentence into the institutional division of the Texas Department of Criminal Justice for you to serve the remainder of your sentence. Also want to let you know that these matters, if you do get committed, could be used against you in adult criminal proceedings, even though this is a juvenile case. Also want to let you know that these proceedings, to a limited extent, can be used against you in adult criminal proceedings. Do you understand?
Yes, sir.
You do have certain rights guaranteed to you by the Constitution of Texas and the Constitution of the United States. The Fifth Amendment guarantees the right to be silent. You do not have to say anything at all. However, it is my understanding that you wish to accept responsibility for your role in the offense of aggravated robbery with a deadly weapon in exchange for me following this agreement that your attorney worked out with the district attorney's office. Do you give up your right to remain silent?
Yes, sir.
You also have a right guaranteed under the 4th and 14th Amendments to what's called due process. You have a right to have a trial. You have the right to have me listen to the facts, the district attorney to prove everything. They would have to call their own witnesses, provide exhibits, and convince me beyond a reasonable doubt that you in fact committed the offense of aggravated robbery with a deadly weapon. Are you telling me that you do not need them to prove it up and you don't want to fight this case?
Yes, sir.
And also for any reason, if you decide you don't like me or for any reason at all, you wish to have a jury make this decision, you are entitled to have a jury listen to the same facts I would hear, and they would decide whether or not you committed the offense of aggravated robbery. Do you need a jury to make this decision?
No, sir.
You also have a right to confrontation. That means any witness that would testify against you, you have the right to look them in the eye as they are testifying, and if they are lying, they would have to look you in the eye as they are lying about you. Do you need to face your accusers?
No, sir.
You also have a right to appeal. However, if this is an agreed disposition on this case, if I follow this agreement, then you will not have a right to appeal. This will be final. Do you understand?
Yes, sir.
I also finally need to let you know that I am not required to follow this agreement. Now, I expect to follow this agreement, but I need you to understand that I do not have to. And if I choose not to follow this agreement, I will allow you, through your attorney, to withdraw your plea of true. So you understand I don't have to follow this?
Yes, sir.
Okay. All right, Dad, so I swore you in previously. Could you tell me what your legal name is?
Jesus Ramon Cuella.
Okay. And what is your relationship to Angel?
He's my son.
Thank you. Mr. Youngblood, is there any reason why your client will not understand the proceedings today?
No, sir.
Is he fit to proceed?
He seems so, Your Honor.
Angel, you are here today because the state of Texas has filed a petition alleging you have engaged in delinquent conduct, which, if committed by an adult, would constitute an offense against the laws of Texas. Namely, they are saying on or about February 14th, on or about December 31st, 2019, in Tarrant County, Texas, you intentionally or knowingly, while in the course of committing theft of property and with intent to obtain or maintain control of said property, threatened or placed Sabrina Chambers in fear of imminent bodily injury or death, and that you used or exhibited a deadly weapon, namely a firearm. Do you understand what they're saying that you did? Angel,
Yes, sir.
you understand what they're saying that you did?
The judge just read you what the charge was. I don't know if you zoned out or not. He can repeat it if you didn't hear him.
The connection is going in.
Okay, not a problem at all. Let me repeat that. Angel, you are here today because the state of Texas has filed a petition alleging that you have engaged in delinquent conduct, which, if committed by an adult, would constitute an offense against the laws of Texas, namely aggravated robbery with a deadly weapon. They are saying on or about December 31st, 2019, in Tarrant County, Texas, that you intentionally or knowingly, while in the course of committing theft of property and with intent to obtain or maintain control of said property, threatened or placed Sabrina Chambers in fear of imminent bodily injury or death, and that you used or exhibited a deadly weapon, namely a firearm. Do you understand what they're saying that you did?
Yes, sir.
State waive opening?
State waives opening,
Any exhibits from the state as to adjudication?
not as to adjudication, Judge.
Respondent, any exhibits or witnesses towards adjudication?
No, same response.
All right, so Angel, what I have here is a stipulation of evidence. Do you recall seeing this document?
Yes, sir.
Okay, did you go over this document with your attorney?
Angel, can you hear?
Yes, sir.
Okay, did you go over this document with your attorney?
Yes, sir.
All right, so do you understand what the word stipulation means?
No.
Okay, I don't expect you to. Stipulation is a legal term that means it's a fancy word for agreement. Okay? So in court, when two people stipulate to something, they're saying we agree, we're saying that we agree in front of a judge, and that forevermore we will never go back and argue whether we're in agreement. Right? So for example, if I was to say your dad is wearing a black shirt, is that something you'd agree with?
Yes, sir.
And so you understand that if we stipulate to this, that 50 years from now, we cannot go back and argue about what color his shirt was on this date. You get it?
Yes, sir.
Okay. However, if I was to say that Mr. Youngblood was wearing, let's say, a face mask, okay, is that something you could agree with right now?
No.
All right. And we could not stipulate because there may be an argument 50 years from now about whether he was wearing a face mask at 1:49 p.m. on January 25th. And if we had stipulated, we couldn't argue about it. But if we don't stipulate, that leaves it open for discussion. Do you understand? Angel, do you understand?
Yes, sir.
Okay. So what I have here, this document that you went over with your attorney, is called a stipulation. Everything in this document, if you stipulate to it, that means it will go down forever as you agreeing to it. Do you understand what I'm saying?
I guess they're having technical difficulties, Judge.
Yes, sir.
So
But
my question,
let me interrupt. I apologize, Your Honor. Did you hear every word the judge said, or is this cutting in and out?
It's only my audio that's cutting out.
Well, it's important that you be able to hear what the judge or anybody else says. So I'm asking you, are you able to clearly hear everything he's saying or not? Or since you're not answering, can you hear everything I'm saying?
Is the communication back to you guys. We can hear everything and we can see the judge. But as we speak, it's not communicating back properly.
So your audio is not working, your volume for your voice.
Correct.
Okay, so your audio, your
All of them seem to be coming through loud and clear to me. It's confusing what's going on here. But again, this was the earlier days of Zoom. Just as a reminder, if you're joining us here, this is an adjudication hearing held in the 323rd District Court of Tarrant County, Texas, in 2021, where the judge is making a determination about this kid and his aggravated robbery charge. So, this is not our usual fare, but because normally we watch a lot of kids get their hearings, but today we're just doing this one to start. I also think that again, I've said this before and I'll say it again. I'm surprised more people don't fake not being able to hear properly on Zoom court. I've seen it a few times done exceptionally well, but for the most part, people give up. They like try and then they give up. They lose their sort of balls. But anyways, okay, let's continue. Also, please go ahead and hit that like or dislike button. That's how we take attendance here. And if you're not already subscribed, subscribe. Also, ask any questions you like. We've been watching court for a long time. So, we know lots. And if we don't know, we'll tell you.
speakers are working and your microphone is not?
Yes, sir.
Well, Mr. Youngblood, do you still wish to proceed?
Mr. Lewis, how far away are you from there?
Approximately 50 feet. Let me run over there and see if I can't troubleshoot.
Could we stop for a second, Your Honor?
Sure, we'll go ahead. We're in recess.
Did you guys hear that? It's recess time. Go ahead and go play. Hurry up, Judge Kimmy Kim. For Judge McNally, Charles Blake, that's a great question. Don't know exactly. The reality about court is that it is touch and go in a lot of the times. And so what that means is that we don't always seem or see everything that we would like, even though we want to. And the only reason that is because, like, it can be as simple as somebody's computer breaking at the office. It could be it could be many things. Could be judges are on vacation. When you think about it, you have to think about something like judges don't just get, I know Americans, for anybody new, I'm Canadian, and in Canada, vacation time isn't as great as it is in European countries, but it's not that, um, oh my gosh, yeah, Gracie, we could use you. But it's not that, anyways, sorry, my brain's going all over the place as I read the chat. The case for Judge Middleton that I'm looking for is oh, hold on, guys. Is the original one where they had the guy in the house at the same time as the other girl. It was like March 4th, 2021, I believe. I think it's like a 2-hour video, hour and a half video. Oh, I was talking about the states. Right. What was I saying though? Anyways. Oh, vacation time, the judges. Okay, so the judges obviously get more vacation than like the average bear. And so like you're gonna have to find like 6 weeks, probably a year, that each of these judges are not gonna be watching it or not gonna be on. Yes, it is an old one, Charles, and I'm just trying to find some old stuff because I really, really like watching the whole. Oh, okay. The whole hearing, not just the little like sort of snippet part, and I just can't find the full thing. Canadian vacation time versus American vacation time. I think it's well known that Americans, I think the way you guys put it is that you work really hard, but in reality, we, yeah, you don't have as much vacation time at all. Sorry, just saying. Hi, people in court. I'm glad you're here. Yeah, we're just getting started tonight. Appreciate that, Charles. But yeah, anyways, we in Canada, basically, I think you're automatically entitled to like 2 weeks when you first start, and then it goes up and up and up from there. And so there are some people that have easily 8 to 10 weeks of vacation a year as not skilled. I'm not talking about unskilled, but like not university educated jobs. Like that can just be a regular job and get 8 to 10 weeks of vacation, paid vacation per year. Um, so, that's a lot of time. So if you imagine that judges are pretty good negotiators, you'd hope that they can actually fix the possible, like fix their vacation so that they get a good deal. They may end up having way more than that. Anyways, if anybody wants to send me an email, my email is adhdandeye@gmail.com. That's ADHD and I at gmail.com. Thank you so much, Chris, for distracting you with my nonsense and whatnot. Never. Didn't you see the rules? Random thoughts and off topicness is encouraged here. It's just the way it's going to be, folks. Natalie did feature the whole video, I know, and that's why I know it exists, but I just don't know where it is. Anyways, GOAT stands for GOAT, greatest of all time. 10 weeks of vacation in the US would be unheard of, really? Yeah, that's hi Orlando. Um, yeah, well, for having a baby, you get a year. Like I get a full year paid vacation, not vacation. It's not a vacation. Parental leave. Um, so yeah, it's a little shocking. And then when you're in the government, or certain professions that have different arrangements, you can take an extra year off at a reduced amount of pay as well. So you can do like two days or 2 years. Sorry. That would be great, Lucy. Erica, I have ADHD and med check, guys. Med check for anybody listening. Detective Rachel, thank you so much. I appreciate hearing that. Um, I Yeah, so maternity leave, or they call it parental leave. In fact, it's both. So what happens is, as a mother who's had a child, you're entitled to maternity leave, and that maternity leave lasts 18 weeks. That maternity leave then transitions into something called parental leave, and parental leave can be taken by either parent, the dad or the mom or the other parent who may not have given birth to the child. You can also have parental leave for adoptions as well. And so that is handled through our EI system, employment insurance system, which is part of payroll taxes that you pay always when you work. So when you are working so many, like everywhere you live in the country has a different number of hours you have to hit before you get the full payment of your EI check. And so for maternity leave, anyways. So I luckily was working full time before I started and went off on maternity leave. So I got my full time, and it is paid. Yeah, it's fully paid for that 18 weeks. And then the next, like, I guess 36 weeks or something like that is either parent can take those. And by law, your work has to accommodate that and hold your position with no sort of penalizing. So it's good and bad, right? For somebody like me, I was 19 when I got pregnant. I was, 20 when I had my daughter. I was very young. I didn't have a career set yet. And so to me, it was great to get a paycheck, but it wasn't anything concerning. After my year of maternity leave, I didn't go back to work because I wanted to stay home with my daughter. And so that was just the way it was. But if, let's say, you are in your mid 30s and you've waited to have babies because you're having a career, you have this pretty tight time frame to get back to work after your baby's born. So, is labor fun? You know what? Labor is very different for many, many people. I used to run, so twins is very interesting. Love that question. Twins, you do not get double time for. Um, it's basically a pregnancy or a um, gestational calculation that they do in essence. Um, I've delivered one baby, but I've told people this before. When I first started and I had my daughter, I started a mommy group in our area. We started with 5 local moms, and by the end we had 500 local moms, and we did events every day of the week, and I facilitated all the different events. And so I've actually seen a lot of labors, a lot of births, and a lot of babies, and I love them very much. It's one of my passions. And I will tell you guys one story before we get back to it. Uh, Only one time. So you have to understand, I had 500 people in my area to get a vibe from if they were going to take maternity leave or not. And so I can tell you the answer is yeah, everybody takes it. There's literally no downside whatsoever. And you get paid. So it's just the way that it is. So I I never came across anybody that wasn't taking their maternity leave. I came across some professional women who would take the maternity part of the leave, and then the the father might take the rest of the leave. But really, I've never met anybody that didn't take the beginning part of the leave, except for one lady. Gracie, you're saying I should be a doula. I've done the sort of work behind being a doula, and I'm Lamaze certified, or I was Lamaze certified to teach Lamaze classes. But anyways, so um, I love babies. But here's the thing. I don't know if this lady was American. I don't know. I don't know. Like I'm telling you, it's just nobody doesn't take this maternity leave. Like there's just no reason not to. Well, Charles, I'll tell you something. I did something called olive oil knuckling. So I knuckled with olive oil the opening of the a vagina so that it would not tear upon opening to the 10 centimeters that it dilates to. And I was successful in that, even though I had like a 36-hour labor. So I don't, I know many women that have torn, and I know many women that have had stitches, and I have a few horror stories of, oh, worse than a fist. But I've heard a few horror stories. At the beginning, so when I was 19 and I first got pregnant, they asked me, "Do you want a doctor or a midwife?" Because here you can choose. It either is covered by our plan, and I was like, a doctor, obviously. Didn't know what I was doing at that point in time. And I had a good doctor, and she was nice and kind and all that kind of stuff. But anybody after in the mommy group, I always recommended a midwife for. The midwives would come to your house after the birth. They're checking into different things for you. Like, it's way different of an experience. And this is what I always remind people. Midwives don't care. There's no midwife that is going to be like, yeah, no, you can't go to the hospital. We're going to make this baby happen here. Like, never happens. If you need better or more expertise care from an OBGYN, they automatically transfer you immediately. So there's literally no downside to it whatsoever. There's only an upside. And basically the reality is that medical intervention in birth is a huge problem. And a lot of the best way that I used to help people avoid that would be avoiding the hospital as long as you can before you get pregnant, or not before you get pregnant, but before you give birth when you're in labor. However, here's the thing. My water broke and I was like, oh, we need to go to the hospital right now. And they're like, oh, don't you want to wait? I was like, no, I don't want to wait at all. This is insane. We need to get this baby out of me. I think this is happening immediately. And I got there and they sent me home. And I was like, no, I'm not going home at all. I'm going to the doctor's office then. And I like went into that doctor's office and there's all these like pregnant women sitting there and I'm like, and they're laughing sort of at me, but looking a little strange. And I'm like, get me in to the back. And they like bring me into the back of the room. And she's like, I'm like, it's crazy. Like, and she's just like, okay. Well, I'll call them and let you go back. And I was like, okay. And I'm not talking about a home delivery. Midwives deliver in the hospital in our area too. You don't do a home birth with a midwife necessarily. You can, but you don't have to. Thank you, Toby. Sympathy pains. But anyways, so I went to the hospital again, like right away. And so how it works is your cervix, which is the part that opens to the uterus, is normally very, very closed tight. And your contractions are actually the dilation or the opening of your cervix from tightly closed to 10 centimeters dilated. Now, here's the funny thing about that, right? Like, 10 centimeters, everyone sort of jokes about it, and people are sticking their hands down there and checking your dilation and all that kind of stuff. But what you don't realize is that nobody ever mentions the shoulders, which are a lot bigger than the head when you start to think about it. But there is this like sort of twisting maneuver that they do to get the baby sort of out. Anyways, so luckily I was very, very lucky. I labored for like 24 hours with no epidural. In Canada, we use something called gas and air. It is the same thing you get at the dentist. It's like laughing gas, basically. It doesn't transfer through the blood barrier to the womb, so it's a great choice to use in active labor. Thank you, Chris. But basically, it's a good choice to use in active labor because it's not a narcotic, so there's not going to be a transfer through to the baby's bloodstream or effect there, but it is extremely effective in the sense of giving you immediate pain relief that you can meter yourself. It's not pure nitrous oxide. They call it gas and air for a reason. So it's mixed with oxygen at a level that allows you to breathe it in safely, and you have control of the mask, and it's actually built into the wall in most hospital rooms for women in Canada. And the thing about it is that you can use it when you are having a contraction and get through a lot. I was 24 hours. So my water broke spontaneously, which is sort of weird. That never really happens except in the movies. But oh, you're hilarious, Lucy. But basically, after 24 hours with your water broken already, you're on a time limit because that's now like open to the outside. And so, they were checking me, and honestly, after 24 hours, I was only like 2 centimeters dilated, which is not enough. And so they had to give me Pitocin, which is a stimulant, and then they they gave me the Pitocin, and immediately I was like, I'm gonna need that epidural. And they're like, yeah, she's gonna be a minute. I was like, she needs to like be a minute now. Like, come in here right now. And then we learned that I have a curved spine and they couldn't get the epidural in properly. Anyways, but they did get it in. So, yeah, nitrous oxide is very dangerous. It's not to be played with and it's not something to use by yourself at home or anything like that. Please keep that in mind. This is absolutely medically supervised and is something that they use as actually the C-section rates are a lot lower because of that. It is a very effective method of reducing medical intervention in birth for women. However, in the United States, that is not the business of birth. That's making money. So that's why it's not big there. However, in socialized medical systems, Canada, the United States, Australia, it absolutely is. It's cheap, effective, and works perfectly. So here we go. We are going to go back to this hearing as I finish my last tangent for the last 2 minutes.
I don't know how we found each other, but I'm glad we did. That's the best thing Tim did for me. Left me you and I. Yeah. Santora and Milbers was not a deal. Wiseman and Peltier? Yes. Marion King. Okay, so we're back on the record after a short recess to deal with whether we can proceed through Zoom or in person. Ms. Youngblood, any objections to continue through Zoom?
No, sir. It looks like the audio issues are resolved.
So, Angel, back to the stipulation that I'm holding up in front of your screen. My question for you is, everything in this document, is it true or not true?
True.
Is the enhancement that there was a deadly weapon used in the offense, is that true or not true?
True.
Are you saying true voluntarily?
Yes.
What does voluntary mean to you?
Of my own will.
Of your own will. And you were saying true of your own will?
Yes.
Did anybody threaten you to say true?
I'm sorry?
Did anybody threaten you to say true?
No, sir.
Did anybody coerce you, like force you to say true?
No, sir.
Did anybody induce you to say true, like offer you any kind of reward or money for you to say true?
No, sir.
Are you saying true because it is true and for no other reason?
Yes, sir.
All right, closing arguments from the state?
Sorry, Judge, we'll waive.
Closing arguments for the respondent.
No, sir, we have none.
So based on the competent evidence from this hearing, the court will make a finding of delinquency. Specifically, the court will find the allegations in the petition in paragraph 1 was established by the evidence, and the court will make an affirmative finding that a deadly weapon was used. That will conclude adjudication for this matter. Are we ready to proceed to disposition?
Yes.
Yes, sir.
All right. So the court will call cause number 323-113-125-20. This is styled in the matter of Angel Ramon Quillar. We are here with the court having previously adjudicated this child as delinquent for the offense of aggravated robbery, finding it true that a deadly weapon was used for the offense on the date of December 31st, 2019. Opening arguments from the state.
None from the state.
Okay, so we'll do allocution after exhibits. Any exhibits or witnesses from the state for disposition?
Yes, Your Honor.
Right. So which one?
Okay, we have, of course, you've already taken under seal the social history and the victim court report, but we would additionally call just briefly Miss Sabrina Chambers here on Zoom.
All right, Ms. Chambers, if you could please raise your right hand. You solemnly swear the testimony you're about to give at this cause currently a trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. You may lower your hand. Mr. Boneberg, please proceed.
Thank you. Ms. Chambers, could you just tell the court how you are involved in this offense?
I worked at 7-Eleven overnight. I guess I'd worked there for about 8 months almost. And on New Year's Eve, I was cleaning the front glass, and some young gentlemen at the time, I didn't know they were covered, their face was covered, came in with a gun at my head and took some money, I think some jewel pods and cigarettes. So
let me ask you another question. You were working overnight that particular night for 7-Eleven,
yes.
correct?
Yes, sir.
Okay. And you were the clerk on
Yes,
duty
sir.
at the time.
Yes, sir.
As a result of this offense, you know that there was another individual charged, a man by the name of Adil Sayani, correct?
You cut out.
Sorry, you know there was
Yes,
another individual charged, juvenile by the name of Adil Sayani.
Yes, sir.
Okay, and you were present at that disposition hearing last month, I believe, correct?
Yes, sir.
Okay, and then there was a third individual who, subsequent to this, committed suicide, but he was also involved in this offense too, correct? I'm sorry, I missed your answer.
Yes, sir.
Okay, thank you.
Um,
All right, and so there being 3 individuals involved in the offense, we have 2 here now being held responsible for that offense. I want to ask you about any loss that you've suffered as a result of this, meaning right now limited to monetary loss. Okay. First off, you had sent in a form which the judge has a copy of. It's called, in our verbiage, a victim court report, but it detailed on there in your writing, I believe, income loss from work of $600 and other expenses, another category of $1,000. Could you just tell the court briefly what that, how you can back up those losses, what they're from, please?
So the $600 was the 2 days that I took off after it happened. I went back to work for about 2 weeks, and just the anxiety of the door at night, I just couldn't do it. And so I told my employer that I was going to be looking for another job, and he just let me go. So I was off work for 3 weeks before I found another job, and then found another job, and it took 2 weeks to get paid. So I got behind on rent, and that's where the $1,000 comes in with late fees.
Okay. So the $600 is from the 2 days that you took off directly after this happened on December 31st, correct?
Yes, sir.
Okay, and then the $1,000 would be rent for which month?
for February.
Is that rent for an apartment or a house or something else?
It's for a house.
Okay. All right. Do you share that rent with anyone else?
No.
Okay. So you are responsible for that full amount.
Yes.
And did you in fact how did you end up paying for that $1,000 you were out? What happened?
My mom, and then I repaid my mom.
Okay. All right. Now, there's been some discussion prior to getting on the record today that you were going to get documentation for that month's worth of rent. That'd be February of 2020. Is that correct?
Yes. Yes.
And have you made any headway since we recessed the hearing from this morning, or do you still need?
Yeah, I'll be picking up that documentation as soon as I get off work. I'm currently at work right now.
Yes, ma'am. Okay. And you'll be able to provide that to Ms. Navarro with Victims Assistance either later on today or tomorrow?
Yes. Yes. By 8 a.m. tomorrow.
Yes, ma'am. Sorry, Judge, if you'll
Sorry, Judge. I just have to step in here for a quick infomercial announcement. Here's the thing. In the chat, if you're watching this later and not reading the chat, this is going to sound really weird, but we're talking about yeast infections and how to clear them up naturally. And one of the ways to do that is using garlic. Now, you need to use as much as organic as garlic you can get, and you want to basically peel it, but don't pierce the skin. So you want to have it just like in its clove form. Then what you do is you take a needle and thread and you poke it through and you actually tie it around the garlic so that it's on a string like a tampon. Then you would insert that, and I'm not kidding, you are going to taste garlic pretty much immediately in your mouth, even though you're inserting this downstairs. And seriously, you will it will probably be cleared up by the next day. If it's not, what you do is you start with a new piece of garlic and you poke a few more holes in the garlic to make sure that more of the allicin, allicin, is what is going to be active. Also, if you know somebody in your if you know somebody in your life that has MRSA, which is a antibiotic resistant staph infection. Garlic also can treat that. And I know people will sort of laugh at that and think, oh, whatever. But the reality is an antibiotic resistant infection is resistant to antibiotics. But the compound in garlic that attacks the bacteria is a physical compound that attacks it physically. And so it actually can't develop an immunity to it. And so I read a study once about a surgeon, in fact, who had basically his patients do a garlic bath the night before surgery because most people have MRSA on their skin. This is the issue. And so what he would have them do is take like 3 cloves of garlic and crush them into his bath water before before the bath, the night before surgery, and his post-operative MRSA infection rates went down to almost 0%. I'm not even joking you. And the reality is that garlic is not something that you can make money off of. But if you are in a position to know somebody going in for surgery, can't hurt and can help. And I have definitely treated a MRSA infection of somebody's and had it cleared up within like a week and a half, which is pretty much unheard of without antibiotics. So I'm not saying that you shouldn't see a doctor. You absolutely should. But in conjunction with that, garlic in its raw form, as good quality and organic as you can, it will really help. What you want to do is like make a poultice of it and then put it nearby. You don't inject it into your veins. But also a toothache. Let's say you have a toothache and you can't get to the dentist right away. You take a garlic clove and you slice it in half almost the whole way so that it's like split open, and you put that on top of the tooth area, and that can draw out an infection as well. So does garlic give you bad breath? Maybe. Yeah, and Rachel, that's the issue is like I had a friend who basically got MRSA at the hospital. They were giving him so many antibiotics, and I literally was able to get him cleared up within like 2 weeks. So I just ruined garlic for you. Sorry. Um, anyways. And the other thing is the reason I say that about yeast infections, of course, the diclofan or whatever it's called works, but that is freaking $30 in Canada, like for one tablet for a yeast infection. And that's a joke. Um, it's no, MRSA is no joke at all. It's very, very serious, and that's why I'm not joking. Like I'll find the study where this doctor did this in his surgical practice. And again, it's not the type of thing to easily implement in a hospital. However, uh, I don't know why you wouldn't if you can do something really simple like that. So, anyways, but remember, you can't cook the garlic. As soon as you heat it up, you basically break down the compound, and that's gonna not work as well anymore. And I do believe Italians have 75% garlic blood. That's true.
Just give me 2 seconds here. Okay, Ms. Chambers, the court will give you a chance to address the respondent in a few minutes here regarding your allocution. At this time, regarding the loss of time from work and rent and the restitution, judge will pass witness.
Mr. Youngblood, Cross?
Thank you, Judge. Yes. Ms. Chambers, it was made clear to me by Mr. Bonebarg on phone conversations that the 2 days that you missed work were because you were just too upset to work. Is that hasn't really been said on the record? Is that why you missed the work?
Yes.
That's all I have, Judge.
Okay, so Mr. Boneberg, redirect?
None, Judge.
So Ms. Chambers, I'm trying to understand. So you made approximately $300 a day?
Yeah, I worked 12-hour shifts at like $12.50 an hour, I believe.
Okay. So this is, okay, I think it's my math. Trying to figure out, so you lost $600 because you could not work for 2 days after this, after you were the victim of the robbery, right?
Yes, sir. Sorry.
Okay. And then what I'm trying to figure out is how much was your rent?
$725, and then I accrued late fees after 5 days. It didn't get paid till like February 15th, I think. I'll have to go back and look. I'm not, it's been almost a year.
So you had to pay $275 in late fees?
Approximately, yes.
So this is where I'm trying to calculate the math. So, but your rent was due January 1st, right?
My rent was paid for January. It was due February 1st when I had quit working to find another job in January.
You were let go.
Yes. And I was off work for 3 weeks and then didn't get paid for 2 after I found a job. So 5 weeks of being able to get paid. I wasn't able to make the rent on the 1st of February.
right, Mr. Bumberg, your next witness.
Oh, Your Honor, may I interject? Because you made me think about it, I got my calculator out. So $12.50 times 12 hours is 150. And I think it was 2 days missed, and so
Yeah.
that should be 300. Is that, Mr. Baumberg, is that what you are asking for?
Well, she said she works 12-hour shifts.
Yeah, but 1250 times 12 hours is $150. So 2 days would be 300.
I was going to ask Ms. Chambers an additional question based off
Yes.
this question.
Please do.
Okay. Ms. Chambers,
Yes.
yes, the defense attorney is correct in doing the math. It looks like that 1250 times
Yes.
12 would be $150 times the 2 days would be $300. Where are you getting the $600?
I don't know. When I filled out that paperwork, it was probably, I don't know. I'm not good at math, obviously. So
Okay. So,
Just- work at 1250.
all right. So the $600 should say $300
Yes.
because you understand that there is a co-respondent that is paying restitution now based on these figures that you gave us. Okay.
Yes.
Okay, so we'll need to correct that. All right. So then, Judge, it does look like that should be corrected to 300, and we are asking for joint and several between the two living respondents, but that would take that down from $800 to, I believe, what would end up being $750, I guess. Let me see.
675 or 650.
Right, 650. Sorry, you're right. You're correct. 650.
Anything further from this witness, Mr. Youngblood?
No, thank you for letting me clarify that, Your Honor.
Mr. Bumberg, anything further from this witness?
No, thank you, Judge.
Call your next witness.
State has no further witnesses.
Respondent have any witnesses or exhibits?
No, sir.
All right. Allocution.
Yes. Ms. Chambers, at this time, you can go ahead and give your allocution, please.
Yes. I don't have anything written down. I'm just gonna say it from my head and from my mother's point, and somebody that's also been on the wrong side of the law at one point. I have since turned my life around, and I hope that you take away from this something good and know that what you're getting as consequences is really a slap on the hand for the crime that you committed. I do have 2 children that the scenario could have went all different kind of ways. Somebody lost their life. I could have lost mine. And I work with I do a lot of service work now. And I just hope that you take some good from what's happening right now. That's all I got.
Thank you. All right, closing arguments.
Judge, we would ask that you follow the plea agreement as detailed in the stipulation document there. We would ask that you reform that restitution amount to $650. And as I understand it, we're waiting on some additional documentation anyway, but otherwise would ask that the court follow the plea agreement detailed there on the stipulation under the determinant sentence approval. Thank you, Your Honor.
Mr. Youngblood.
We also ask you to follow the plea bargain, which is why we signed it. And we understand the court will wait 30 days. And if the state hasn't responded on the matter of the rent, that will just simply not be part of the restitution. But we expect from what we hear that will be no problem for the state.
So
And
then,
I assume they'll let me know so I can review that and object if I have an objection.
so at this point, we are the parties are asking me to order restitution at $150, and that part of the disposition can be modified within the next 30 days, just by agreement.
Yes, sir.
Is that correct, Mr. Blumberg?
Yes, sir. Going, it looks like to a maximum of $650. But right now, $150. Yes, sir.
So the court, having considered all the competent evidence provided at this trial, will find that there is a need of rehabilitation and that protection of the public as well as the child requires disposition to be made. The court will follow the disposition agreement. However, the court at this rendition will vary on two matters. One is the agreed amount of restitution of $800. The court is not following that, which doesn't bounce a plea. Simply, restitution is ordered at $150 at this hearing. And so the other change is, Mr. Quiller, I am committing you to the Texas Juvenile Justice Department for a period of 5 years. Right? That means I've actually sentenced you, and that before your 19th birthday, I could decide to transfer you to the adult prison. However, I'm going to probate this sentence, which is agreeing with, this is following the agreement that your attorney and the district attorney made. However, I'm going to vary from the 2 years, and I'm going to put that at 3 years. Right? And the reason why is because I want to have a hearing before your 19th birthday to determine whether I transfer you to the institutional division, or I'm sorry, transfer you to the adult courts for adult probation supervision. A large part of you not being transferred to the adult courts is going to be whether or not you follow these terms, including the restitution. This is really the only way I can assure Ms. Chambers that you will receive, or she will receive, all the restitution, is the specter of prison being over your head. This is also to ensure that you're taking the counseling programs and that you are making better decisions in your life, including the no contact order. But in essence, the agreement is for probation, and I am giving you probation. I'm actually going to make an entry in here. That I am not opposed to discharging you at 2 years of probation if the restitution is paid in full. So I'll let you off probation early.
Woo! Excellent. Yes, I'm ready. I'm absolutely ready. The dog is ready too. Cachette has joined the crew. She's in the club. She's in the club. She's joining the kitchen crew. Woohoo! Woohoo! Yeah. Now, please don't be late for your shifts. No, I'm just kidding. You can be late whenever you guys want. I love y'all. Thank you so much, Cachette. I love hanging out with all of you guys. Seriously, if you want to become a member just like Cachette did, you can do that down below. And if you don't want to be a member, that's okay too, boo. You be you. I'm going to be me. And it might be just me being loud. That's the way I see it. I don't know. Anyways, Judge Kim, fine, continue on. Cool. Stayed on my ribs. Seems like 100% better. Tupac, I'm gonna have to write my comment to that. Anyways, okay, let's continue.
As long as the restitution is paid in full, then Ms. Chambers deserves this at the very least. Right? I'm also going to assess community service at the amount of 80 hours. So you will have to do community service. For this case, you are to have no contact with the co-respondent. You're supposed to take the required counseling and assessments that's required. I do believe that you do have to, so remember, I think he requires a DNA sample on this one because of the level of offense. Right. Okay, so Mr. Quiller, you will be required to provide a DNA sample that goes into the state database, and that's because you were involved with a crime involving a deadly weapon. If you do not pay restitution or you have problems on probation, we will have a hearing before your 19th birthday for me to decide whether to transfer you to the adult courts for the remainder of your supervision. If you get your probation revoked before your 19th birthday and I commit you to the Texas Juvenile Justice Department, we will have a hearing before your 19th birthday for me to determine whether I transfer you to the adult prison system to complete the remainder of your sentence. If you end up going to TJJD, your case in its entirety can be used against you in adult criminal courts. Furthermore, the court will make a finding under Chapter 54 of the Texas Family Code that the child's parent or guardian.
The parent or guardian can get sucking whatever, because Cachette. Oh, thank you so much. Oh my gosh. If I get hyped up, this dog comes right over. That's amazing. Thank you so much for memberships. Who do we got? We got Celestia, we got Joey Tinkar, and we got Matthew Perry, we got Angel Rayburn, we got Jim Miner, and Mikey Mike. By that is the way I see it. Thank you so much. Oh my God. You guys are amazing. I love you being here, and I love the lurkers too, guys. Don't you worry. We know you're there. It's okay. You'll come out when you feel comfortable, okay? Credence and Mikey. Hi, Mikey. I hope you're well today. What a day it has been. And thank you all again. Okay, what? Come here. Say hello. Hi. This is Bluebell. Anyways. Mwah. Okay, let's finish this up. But thank you guys so much. I am so thankful and happy. Appreciate it all the way. You guys are my family. That's how it goes. Most dangerous family in the world.
Made a reasonable good faith effort to prevent the child from engaging in delinquent conduct, and that despite the parents' efforts, the child continued to engage in such conduct, this court will waive any requirement for community service that may be imposed on a parent under this section of the code. Restitution is ordered at $150. Specifically, the reason for this disposition, Mr. Quiller, is that I am deeply concerned about children that are involved with guns, around guns at all. That gives me great concern. And you do need supervision to make sure the rehabilitation is concluded. In conclusion, Mr. Quiller, I'm letting you know that your case could potentially be transferred to adult criminal court for supervision, that I follow this agreement so you do not have a right to appeal. Depending on your case, you possibly have a right to seal your records. That is something to consult your attorney about. And Mr. Boneberg, there's nothing in the record to indicate the victim or intended victim was under 17 years old, so the court cannot make such a finding.
Yes, sir.
So Mr. Lewis, you can come by and make sure you get copies. I have the judgment entered into the docket. I do have the certification of right to appeal. Please provide a yellow copy to the child and the green copy to the father.
Yes, sir.
Is there anything that I missed, Mr. Youngblood?
No, sir. I do have one question of the court, and this is not due to delay on the part of the prosecution or the defense. It's mostly just COVID and the general nature of the beast with this type of case. He's been on what amounts to a probation for a year now. And so I wondered if the court could consider go ahead and just make his probationary period 2 years with the understanding that he does pay the restitution. And
So the idea is if Ms. Chambers is not made whole, then I will transfer him to adult criminal court.
I get what the court's saying.
Yeah, if he does make it whole, I've actually made a docket entry that I'm okay early discharge from probation at 2 years. Like so it's everything that he's done. But no, I want the specter of going to adult prison to weigh over his head to make sure that the restitution is paid. That's all I can do to guarantee, because once I just place him on supervision, juvenile probation isn't that diligent in making sure restitution is paid. That's the only way I can personally get involved in it. Okay.
Yes, sir.
All right. All right. That'll be the order. Mr. Bloomberg, have I missed anything?
No, but on that point, Judge, then to clarify, she must also follow all the other terms and conditions of probation, correct?
Oh, yes. So if he's picked up a new offense, if you've got other issues with probation, but if he's doing everything right at 2 years and restitution is paid, I'll cut him off early.
Yes, sir.
It's the only, I could have done 2 years and 6 months as far as that's concerned, but I wanted the specter of him being revoked or going to adult criminal court and it's not that much of a restitution amount. Hopefully he pays this within the next 6 months. Right.
Yes, sir. Then nothing
Okay.
further from the state.
All right, Mr. Youngblood.
No, that's it, Judge.
All right. Thank you, everyone. That'll be the order of the court.
Yes, sir.
Thank you, Judge.
Good luck, Ms. Chambers.
Okay, so let's see what this poll is going to say while I take a look at a few things that we've got going on here. What I also wanted to say, guys, is what did I want to say? Oh, Stephen Rosen, thank you so much for your good comments last night and then also tonight. Says you're strumming your banjo. Was that what you said? Just saying eastbound and down for some reason. Maybe it should be traffic court in Kansas. That's a good option, but I have a song that I have done a little bit of a court rewrite for that maybe you should start strumming so that you can get it in your head. I'll tell you what it is. I can't play it because obviously I will mess it up for monetization. But thank you, Doc BBQ. Thank you so much. I appreciate that lovely Mother's Day gift after my weird rant about birth and knuckling vajayjays. So the song I want you to look into there, Stephen, is called The Mull River Shuffle by the Rankin Family. And the reason I say that is because the intro to it is so great and I rewrote it in a really fun court way. And so I just need you to know the song first so that I can impress you with my little rewrites. Anyways, okay, let's see. What do we got? I'm going to close this poll in the next 30 seconds. So you need to get your votes in now. This is the last 30-second call for getting your votes in. This is also a time that you can clock in without penalty. If you forgot to clock in earlier, that's okay at this point as well. And at this point, too, there's a few people in the chat. We have That Is the Way I See It and Credence and Mikey. Both of those guys have amazing channels that you absolutely must be already subscribed to. But if you're not, by a random chance, please do that. It makes me happy when my friends are happy, and I really enjoy it. So let me just take a look here. We will see. Here's the thing. I used to watch Manning live. I know we missed the TPO stuff. I'm working on it. I'm not going to let too many details out on that, but I'm working. What I am going to say is hold on. I'm being sort of country right now because I'm holding a giant thing of lemonade in my hand. Oh, something's playing. Something already decided that it was going to.
Yes.
Wow. Wow, that judge is forward. Interesting. Okay, let's close this poll and see what the answers were because that's where we're going next. Into the poll. Of course, my friends. So I understand TPO Fridays, but we'll get there. No, you do not get detention with Molly Ringwald if you clock in late. Is it really a tie between a new judge and Judge Manning? Well, I have to tell you guys something. That judge just My face is gone still? Am I back now? Back? Anyways, let's just do both. But what we'll do is, who should we go first? That's the question. And this one I'm not going to write in the poll because obviously it breaks things. Um, let's go ahead and who should we start with? I think this new judge wants to talk. I know pre-trial. Trial. I have a theory on why Judge Manning says pre-trial like that, by the way. I really do. Michael Page didn't get any votes, is that right? Okay, pre-trial. Um, the god herself. We all know her. I know I've already written like a few short stories about Judge Manning. I'm not gonna lie. For us to enjoy one day, but I want to run it past her before I put them out there so that she's not like creeped out. But also, she's going to be creeped out by me writing to her and asking to write stories about her. So, also name your strain that you're using tonight, or your drink, or your dinner, or whatever you're enjoying. Phil's talking about getting a new computer for himself. I need his old computer because this computer's clawing along at the pace of a, I don't know, geriatric three-legged race. There it is. Okay. So anyways, this is just today's Manning here. Excuse me, did you just throw that ball at me? This is today's Manning hearing, and honestly, I'm just going to play it. I haven't been able to watch these that much lately because I've been working most of the time, so I hope we get to enjoy these very similarly to detention dockets in a way. These are bond hearings in Fulton County, Georgia, with the wonderful, the one, the only, the amazing Judge Alex Manning, ladies and
All
gentlemen.
right, gentlemen, here we go. Come on in, have a seat. Have a seat, shut the door behind you so that you can hear. Everybody, have a seat, shut the door behind you so you can hear, okay? We're going to go one by one, gentlemen. We're going to go as quickly as possible. You need to stay in your seat. Don't pick your hair. Don't twist your hair. Don't mess your zits. Don't fix your face. It's not a mirror, okay? Gentlemen, just sit there and be still. Don't get up and walk out. If you get up and walk out, could miss your case. So if you need to get meds or they're serving you dinner, please, you can hear them. Step out, grab it, and leave, all right? No twisting your hair. Don't fall asleep. Don't put your head down. Don't sit on the floor. Pay attention. Sit up. If I see you sitting down or putting your head down, I'm going to call you out. So let's get through this as quickly as possible. Today is much like first appearance, gentlemen. We're going to address bond only. Everybody in here has been in more than 90 days. So statutorily, you are required to have a bond. So everybody today will get a bond. However, I do call this a you problem. This means you need to pay attention. You need to pay attention to what I say, how much your bond is, what the conditions are. 5 South, booth 4. If you're looking away, you're not paying attention. All right? Keep looking at me. You need to pay attention. There's going to be conditions. I may tell you to stay away from somebody, not have any contact, don't go back to a certain place. You may have an ankle monitor. You may have curfews. There's things you can and cannot do. That's why you need to listen. That's why you need to stay here and not, jump out of your seat and go somewhere else, okay? Pay attention. I'm going to sign your bond order at the end of the evening today, and all your public defenders are going to attempt to mail you a copy of it. If you're not there and you've already bonded out, you won't get a copy of your bond order, which means you need to call your public defender and say, hey, I need a copy of my bond order so that you know what you're doing, because if you violate it, your public defender, your mother, no one else will get revoked and have to go to jail but you. So that's why it's a you problem, gentlemen, okay? You keep up with it. We're also going to ask for your address. If you're going to be at an address, you change your address, you need to let your attorney know that you've changed your address. You're all on mute. That means you don't get to talk back and forth to me. So make sure that you give, if I ask you a question, it's going to be a thumbs up or a thumbs down. So we're obviously having some problems with 5 South, the booth. All right. So if I ask you a question and it's a yes, give me a thumbs up. If I ask you a question, it's a no, give me a thumbs down. I can't hear you. I don't know you, gentlemen. So if I call your name, wave so that I can see who you are. All right. So that I'll know that you're in the booth. If everybody can hear me right now, give me a thumbs up. Nice. So he can hear. All right. So, sir, in 5 South booth 3, can you let the other 2 gentlemen know in 5 South that those may not be working, and after we get you, they can just come in the booth where you're at? Do you mind, sir? Thank you, sir. All right, everybody else can hear. So when I call your name, just wave at me so I know you got me. Miss Watson, if you take yourself off mute.
Yes, I did.
Okay, so give me one more time. Pronounce the language that you're interpreting for.
Punjabi.
Punjabi. Okay. All right. If you raise your right hand, do you swear or affirm you'll translate from English to Punjabi, Punjabi to English to the best of your knowledge, skills, and abilities?
I do.
All right. So Bostic, you on here yet? Where's Bostic? Yep. All right, Bostic. So everybody just remember that she's got to interpret. So make sure you speak slow enough for the interpreter. All right, Madam Interpreter, this case number is 22 CP 205888.
Case number 22 CP 205.
All right, it's Avtar Singh.
Avtar Singh.
All right, 479 days without indictment.
471 दिन जेल दे.
There's a $25,000 good bond.
50,000 bond है ओदे. $50,000 दा bond.
As of August the 31st, 2022.
August 2026, you said?
August the 31st, 2022.
All ਜਿਹੜਾ ਹੈਗਾ ਹੈ August 21 ਤੋਂ 23 ਤੱਕ.
And he's charged with aggravated assault with a deadly weapon.
ਜਿਹੜਾ ਕਸੂਰ ਹੈਗਾ ਤੁਹਾਡਾ ਉਹ ਜਿਹੜਾ ਗੁੱਸੇ ਨਾਲ ਜਿਹੜਾ ਤੁਸੀਂ ਜ਼ਿਆਦਾ ਅਗਲੇ ਨੂੰ ਮਾਰਨ ਦੀ ਕੋਸ਼ਿਸ਼ ਕੀਤੀ ਹੈ ਉਹਦੇ ਪਿੱਛੇ ਹੈਗਾ.
Mr. Cho, I'm sorry, pre-trial.
Whoa.
3 prior arrests, conviction 2012, damaging, injuring, or interfering with property of public utility companies. Nothing further.
Go ahead, Madam Interpreter.
212 ਚ ਜਿਹੜੀ ਤੁਸੀਂ ਬਿਨਾ ਪੁੱਛੇ ਜਾਂ ਕਿਸੇ ਕੋਲੋਂ ਪਰਮਿਸ਼ਨ ਲਿੱਤੇ ਅੰਦਰ ਵੜੇ ਸੀ ਜਗ੍ਹਾ ਦੇ ਉਹਦੇ ਪਿੱਛੇ ਐ ਲੱਗਾ ਹੈ ਤੁਹਾਨੂੰ ਚਾਰਜ.
Mr. Cho.
Thank you, Your Honor. Judge, we are requesting a reasonable bond in this case. Mr. Singh maintains his innocence. The address on file is not current based on the length of incarceration at this point. He's been in jail a long time, Your Honor. And he would like his day in court. There has been a probable cause hearing already on this case. And he does have a mailing address. It's on Washington Street, Judge, just so the court knows. There's no family in Georgia currently, but he does not have a serious criminal arrest history. There's not a bond he can afford. So, Judge, we'd ask the court to consider a reduction at this time and request the court place this case on the list. And if possible, can I have a breakout session with Ms. Wilson and Mr. Singh after the bond hearing, please? Nothing further.
Go ahead, Madam Interpreter.
ਤੁਹਾਡੇ ਜਿਹੜੇ ਕੇਸ ਦੇ ਬਾਰੇ ਚ ਤੁਹਾਡਾ ਜਿਹੜਾ ਅਟਰਨੀ ਹੈ ਉਹਨਾਂ ਨੇ ਜੱਜ ਜੀ ਨੂੰ ਕਿਹਾ ਹੈ ਕਿ ਤੁਸੀਂ ਨਹੀਂ ਕਰ ਸਕਦੇ, ਪੈਸੇ ਨਹੀਂ ਕਰ ਸਕਦੇ, ਬੌਂਡ ਨਹੀਂ ਲੈ ਸਕਦੇ ਜਿਹੜਾ ਤੁਸੀਂ ਲੈਣਾ ਹੈ, ਔਰ ਤੁਹਾਡੀ ਐਡਰੈਸ ਜਿਹੜਾ ਹੈ ਉਹ ਵਾਸ਼ਿੰਗਟਨ ਡੀਸੀ ਦਾ ਹੈਗਾ, ਔਰ ਤੁਸੀਂ ਕਦੀ ਤੁਹਾਡਾ ਕੋਈ ਪੁਰਾਣਾ ਕੋਈ ਇਹੋ ਜਿਹਾ ਰੈਕਡ ਨਹੀਂ ਹੈਗਾ ਕਿ ਜਦ ਤੁਸੀਂ ਕੋਈ ਕ੍ਰਾਈਮ ਕੀਤਾ ਹੈ ਜਾਂ ਕੋਈ ਕਸੂਰ ਕੀਤਾ ਹੋਏ, ਤੇ ਉਹ ਟਾਈਮ ਚਾਹੁੰਦੇ ਨੇ ਤੁਹਾਡੇ ਲਈ ਜੱਜ ਕੋਲੋਂ, ਉਹ ਫਿਰ ਤੁਹਾਨੂੰ ਦੱਸਣਗੇ। Yes, ma'am.
Mr. Cho, so he doesn't have an address where he's going to be living?
There's a mailing address, but not a stable address. There is an address listed in Odyssey, but it's no longer current.
Okay.
ਉਹ ਤੁਹਾਡਾ ਪੁਰਾਣਾ ਐਡਰੈਸ ਉਹ ਜਿਹੜਾ ਹੈਗਾ ਬਸ ਉਹੀ ਹੈਗਾ, ਨਵਾਂ ਵਾਲਾ ਐਡਰੈਸ ਉਹਨਾਂ ਕੋਲ ਨਹੀਂ ਹੈਗਾ।
What says the state?
Good evening, Your Honor. The state notes that Mr. Singh does not have an address. It does not appear that he has any significant roots in the community, and it appears that he poses a danger to the victim in the case, as well as a risk of intimidation and risk of not coming back to court due to having no address. The state would request that the bond remain the same, and of course that he have no contact and stay away from the victim and wear an ankle monitor upon his release. Thank you.
Go ahead, Madam Interpreter.
ਇਹਨਾਂ ਦਾ ਤੁਹਾਡਾ ਜਿਹੜਾ ਹੈਗਾ ਕਮਿਊਨਿਟੀ ਚ ਜਿਸ ਤਰ੍ਹਾਂ ਤੁਸੀਂ ਉੱਥੇ ਰਹਿੰਦੇ ਹੋ ਉਹਨਾਂ ਦਾ ਵਿੱਚ ਤੁਹਾਡਾ ਕੋਈ ਲੈਣਾ ਦੇਣਾ ਨਹੀਂ ਹੈ, ਕਿਸੇ ਨਾਲ ਮਿਲਣਾ ਜੁਲਣਾ ਨਹੀਂ ਹੈ, ਔਰ ਨਾ ਹੀ ਤੁਹਾਡਾ ਕੋਈ ਪਰਮਾਨੈਂਟ ਐਡਰੈਸ ਹੈਗਾ ਹੈ, ਤੇ ਉਹ ਨਹੀਂ ਚਾਹੁੰਦੇ ਨੇ ਕਿ ਤੁਹਾਨੂੰ ਉਹਦੇ ਚ ਕੁਝ ਸਹੂਲੀਅਤ ਦਿੱਤੀ ਜਾਏ ਬੌਂਡ ਚ, ਉਹ ਚਾਹੁੰਦੇ ਨੇ ਕਿ ਤੁਹਾਨੂੰ ਬੌਂਡ ਭਰਨਾ ਪਏ। Yes, ma'am.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 480 Peachtree Hills Avenue. No further contact with Joe Robinson. You have an ankle monitor paid for by the county with a 24-hour curfew. Go ahead, Madam Interpreter.
The Peachtree ਦਾ ਜਿਹੜਾ ਐਡਰੈਸ ਹੈਗਾ ਉਹ ਦਿੱਤਾ, ਉਹ ਤਾਂ ਤੁਸੀਂ ਦੂਰ ਰਹੋਗੇ, ਔਰ ਤੁਹਾਡੇ ਲਈ 24 ਘੰਟੇ ਦਾ ਕਰਫਿਊ ਹੈਗਾ। Yes, ma'am.
With that curfew, he can leave for court to see his lawyer, seek medical attention, and to go find employment.
ਤੁਸੀਂ 24 ਘੰਟੇ ਦਾ ਜਿਹੜਾ ਕਰਫਿਊ ਉਹਦੇ ਵਿੱਚ ਤੁਸੀਂ ਆਪਣਾ ਨੌਕਰੀ ਵਾਸਤੇ ਜਾ ਸਕਦੇ ਹੋ ਔਰ ਆਪਣੇ ਲਾਇਰ ਨੂੰ ਮਿਲਣ ਜਾ ਸਕਦੇ ਹੋ, ਬਸ ਇਸ ਵਾਸਤੇ।
Go ahead, sorry.
I'm sorry.
He has to supply the name of his employer.
ਨੌਕਰੀ ਮਿਲਣ ਤੋਂ ਬਾਅਦ ਤੁਹਾਨੂੰ ਆਪਣੇ ਜਿਹੜੇ ਜਿੱਥੇ ਵੀ ਮਿਲੇਗੀ ਨੌਕਰੀ ਉਹ ਮਾਲਿਕਾਂ ਦਾ ਨਾਮ ਤੇ ਐਡਰੈਸ ਵਗੈਰਾ ਤੇ ਕੰਪਨੀ ਦਾ ਨਾਮ ਵਗੈਰਾ ਚਾਹੀਦਾ ਹੋਏਗਾ ਸਾਰਾ ਕੁਝ। Yes, ma'am.
Proof of employment.
ਉਹਦਾ ਪ੍ਰੂਫ ਵੀ ਚਾਹੀਦਾ ਹੋਏਗਾ ਜਿੱਥੇ ਤੁਹਾਨੂੰ ਕੰਮ ਮਿਲੇਗਾ।
A schedule in the exact location he's going to be working.
ਔਰ ਟਾਈਮ ਟੇਬਲ ਜਿਹੜਾ ਤੁਹਾਨੂੰ ਜਿਸ ਟਾਈਮ ਤੇ ਤੁਹਾਨੂੰ ਨੌਕਰੀ ਮਿਲੇਗੀ, ਜਿਸ ਟਾਈਮ ਤੇ ਤੁਸੀਂ ਕੰਮ ਕਰੋਗੇ, ਉਹ ਬਿਲਕੁਲ ਉਹੀ ਚਾਹੀਦਾ ਉਹਨਾਂ ਨੂੰ। Yes, ma'am.
He needs to supply that to his lawyer and to the ankle monitoring company.
ਜਿਹੜਾ ਹੋਏਗੀ ਇਸ ਗੱਲ ਜਿਹੜਾ ਹੋਏਗਾ ਤੁਸੀਂ ਤੇ ਇੱਕ ਆਪਣੇ ਲਾਇਰ ਨੂੰ ਦੋਗੇ, ਦੂਜਾ ਉਸ ਕੰਪਨੀ ਨੂੰ ਦੋਗੇ।
He'll also need to supply an address where he'll be living once he gets an address.
ਨਾਲੇ ਤੁਹਾਡਾ ਐਡਰੈਸ ਚਾਹੀਦਾ ਹੈ ਜਿੱਥੇ ਤੁਸੀਂ ਹੁਣ ਰਹਿ ਰਹੇ ਹੋ, ਉਹ ਜ਼ਰੂਰੀ ਚਾਹੀਦਾ ਹੈ। Yes, ma'am.
$15,000. Best of luck to you, sir.
$15,000 ਦਾ ਉਹ ਕਹਿੰਦੇ ਪਏ ਨੇ।
Thank you, Madam Interpreter.
You're welcome.
Let me put you in a breakout room with Mr. Cho and Miss Robinson. Can you? Cobb has
the Zoom controller won't work for me.
Yeah.
For me to unmute them. I don't know if Miss Mabry Collins is able to assist.
Are you able to, Miss Mabry Collins? I don't know. I think
they won't let me unmute the. Remember, you had to do it for some reason. I don't know.
Do I need to unmute who now? I'm sorry.
Cobb booth 2.
Cobb booth 2. Okay.
Should I mute myself?
I'm going to move you into a breakout room, ma'am.
Oh, okay.
Thank you, Your Honor.
Okay.
You want me to put him in a waiting room too?
In that breakout room? Yeah, I just put him in breakout room 1. If you got him, once you get him unmuted.
Okay. It's not letting me. It's, that's weird.
Won't let you do it?
No, it's saying when I'm hitting ask to unmute, that's all it's doing. It's not.
So, gentlemen, one of you at Cobb, can you turn around and ask the deputy to go to booth 2? Thank you so much, sir. Deputy, can you unmute booth 2? I need you to, can you unmute booth 2 where Mr. Singh is? Not that one, the other one. The other one. The unmute booth 2. Not that one, booth 2. Thank you. Thank you, sir, in booth 3.
Okay.
I'm telling you, something has been going on with the Zoom controller this week.
Yeah, I'm looking now. You don't see the unmute.
Now we just have to move when it's not unmuted yet, deputy. Whenever it gets unmuted, can you move him to that breakout room 1? I don't even see them on the list. All right, we'll go to the next one. She's trying to deal with that one. What about Mr. Dequame Jones? All right, thank you, sir. All right, Ms. Rosenhoover. This is position 19, Bostic 23, CP 215967, Dequame Smigaliski. Sorry, how about Jones? 98 days without indictment. There is a $26,000 good bond as of February the 4th, 2023.
I'm sorry, are we going to hear about Smigaliski or are we just, I don't understand. Did she just replace his name with Jones? And Credence and Mikey, I will, absolutely. You know me, I'm up very late and I feel very bad messaging all you East Coast people when it's so late out. But I will.
Burglary in the 2nd degree and criminal trespass. Pre-trial.
Pre-trial.
Who did you say?
Position 19. Position 19.
It's not my 19. Dequame Jones.
Okay, whatever number it is, this is Dequame Smiggle something Jones. I can't pronounce his other name. Whatever number it is, that's what it is.
I'm trying to find it. Give me just a moment, please.
Here's number 2 on the add-on.
Huh?
Number
I don't
2
know,
on
but
the
he's
add-on.
number 19 on my original calendar. So let's not worry about the numbers. Just get the names.
I don't have him. Somebody said something about an add-on.
He was on Tuesday. He was number 19 on Tuesday. Today he's an add-on number 2.
Gotcha. Only prior arrest.
Go ahead, Ms. Rosenhoover.
Thank you, Judge. Mr. Jones is 27 years old. His mother, his sisters, and his stepfather all reside in the Atlanta area. He graduated high school in 2014, and most recently, he just started a job at PetSmart. Prior to that, he was working at various fast food restaurants. While he hasn't lived here in Georgia for very long, he does have strong ties here. And I do want to acknowledge that the address on file is also the same apartment complex where the alleged incident took place. He has advised me that he would be able to stay elsewhere with his stepfather, also here in Atlanta, but he does not have that address for us today. I'm going to be working with him to get that. But at this time, the $26,000 bond is unreachable for him, and we're requesting a total of a $5,000 bond, given the 98 days he's been in custody without indictment. Thank you.
All right, go ahead, Mr. Malkin.
Thank you, Your Honor. The state can agree to the $5,000 request.
All right, $5,000 total?
Yeah, yes.
Okay.
Judge, I'm sorry, she got the booth unmuted.
Right. Can you move it now to breakout room 1? Or Tony, can you move it to breakout room 1?
Okay,
all right.
Stay right there. Okay.
All right, that's no drugs unless prescribed, no alcohol, no weapons, no further contact with Tony Jones. Stay away from 2165 Rugby Avenue in College Park. No further contact with Danielle, Danyell, Lynn, Lynn. Gonna have an ankle monitor paid for by the county with a 24-hour curfew. This will be one of those, Miss Rosenhoover, will probably be like 6 months. So everything except for court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. 4,000 count 1, 1,000 count 2. Best of luck to you, sir.
Thank you, Judge, and that was all I have, if I may be excused.
Yes, ma'am. Thank you. All right, I've got Amira Madian.
Yes, Your Honor, that is Amaria Madian. She would be at ACDC.
Okay.
Mr. Jones, you can lead the booth.
This is, the people versus
So we got
Davis, Daniel.
Travell McCray.
Okay, Judge, that's the
All
second
right,
time
thank
that
you.
judge has just
Okay.
burst into Judge Manning's
Hassan, you
show.
can't get the.
And maybe you didn't know this, Judge, but Judge Manning rules this roost. So we will let her finish first. Thank you.
Moved. We're trying, Mr. Joe sending a message. Can you not move Cobb booth too? Oh, no.
I don't know what's going on with the Zoom controllers this week. They have been hard to
Mr.
try.
Joe, we're trying, Mr. Joe. That's all we can. I mean, we got it unmuted. I don't even see Cobb on my list of things in unassigned booths. Do you?
I don't. It wouldn't even let me do the Zoom control.
Miss Mabry Collins, do you see it in there? All right, anyway, let's go. All right, Travell McCray, 22 CP 213756, 188 days without indictment. There's a $60,000 good bond as of February the 3rd, 2023. Terroristic threats and acts, simple battery, family violence, willful obstruction or hindrance of a firefighter, ag assault, and terroristic threats and acts.
Only prior arrest.
All right, go ahead, Ms. Safarasi.
Thank you, Your Honor. Mr. McCray, as you said, Your Honor, he's been incarcerated 180 days. That's without an indictment. This is an incident stemming from August of last year. He had first appearance back in November, and then we had a prelim back in February, Your Honor, of this year. A little bit about this case, Your Honor, is one of the complaining witness in this case. We do believe that there's some credibility issues with her, and a lot of the preliminary hearing was determined on what she had advised to law enforcement.
Just take a quick glance up here. What I'll do is I'll flash a beaver where I'm talking about here, just above the beaver. Just above the beaver here. Doesn't that guy look like he is not wearing a shirt and that his big boobies are over his tummy? Right above the beaver here. Anyways. This video is not on any faster speed. This is on normal speed. This is how they talk in Georgia.
Some of the issues we want to bring to the court's attention was that Ms. Kendrick actually has an open case. It's 22 CR 00320-3C of making a false report against Mr. McCray. She made a false 911 call and report against Mr. McCray, as well as she actually has an open felony case connecting to tampering evidence and with a with possessions of controlled substance with intent to distribute. And that case number is 23 CP 217081. So, Your Honor, based on the fact that of her own history of making false reports and hiding evidence to law enforcement, we do believe there are credibility issues. Much of the preliminary hearing was based on information she had reported to law enforcement. So we want to put that on the record, Your Honor. A little bit about Mr. McCray is that he is 29 years old. He spent his entire life here in Georgia. He grew up in the foster care system. He does have 3 children, Your Honor, a 5-year-old, a 4-year-old, and 3-year-old. One of his daughters is with his aunt, who is actually on the Zoom today in his support. One of his other daughters is in foster care. So Mr. McCray is trying to get out of the jail so he can go get proper custody of his daughter. The mother of that child released or was taken away by DFACS. And so Mr. McCray wants to get out there so he can get his daughter back. He is a high school graduate. He's employed, at the time of his arrest, he was employed at Popeyes on Roswell Road, and he can return to that job. He does have some mental health issues, Your Honor, but he is currently taking his medication and is committed to staying on his medication. He also has some medical issues, Your Honor. He has brain damage, and he also is blind in one of his eyes. And so that's been a difficulty in the jail with having those hindrances on him. Particularly, he has been robbed and drunk several times in the jail. And so because of that, Your Honor, we are asking you to significantly reduce his bond. He cannot make the bond as it is set. So we are asking for the bond not to exceed $15,000. That will give him a chance to post that bond, and so he can get out and get to his family. Thank you.
All right, what says the state?
Thank you, Your Honor. The state would request a $30,000 bond and that it not be less than that. No contact, stay away from the victims, and that he wear an ankle monitor with the 24/7 conditions. Thank you.
All right, so we got 5,000, 10,000, 5,000, 5,000, 5,000. You got that, Miss Tracy? 5,000 on each count. No drugs unless no alcohol, no weapons. No further contact with Demetria Kendrick or Tiffany Larkin. Stay away from 50 Alabama Street. You're going to have, like Judge Dallas ordered before, you're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, medical, attorney visits, and employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working, sir. So it'll be a total of a $30,000 good bond. Best of luck to you, sir. You can leave the booth. Torres Williams. Mr. Joe, I don't know what to, let's see, hold on. Miss Tanya Mabry Collins. Miss Mabry Collins. Mr. Joe, here's the thing is I don't even, when I click on trying to move it, Cobb doesn't even show up in there for me to be able to move those booths.
What I'm doing, Judge, I'm trying to remove them and then add them back in there. So I'm having to manually do him because again, he's not even on the list at all.
Do you mean to remove it?
Will you please? And then we're gonna add them back.
I'm sorry, we're gonna have to just go back a moment here. What did you say you have to do?
Cobb doesn't even show up in there for me to be able to move those booths.
What I'm doing, Judge, I'm trying to remove them and then add them back in there. So I'm having to manually do him because again, he's not even on the list at all.
Do you mean to remove it?
Will you please? And then we're gonna add him back in there and see if he'll come in the list because he's not in the list.
Yeah, okay, here you go. I just removed Cobb booth 2.
All right, and then we just need to put him back in there. That's it.
Right.
Thank you guys so much.
Thank you.
Your Honor, before moving.
Judge, you want me to invite it back?
I don't know.
Yes.
Torres Williams. Who do we need? Yeah, invite booth 2 back for Mr. Singh.
That'd be great, Ms.
Yes,
Robinson.
Ms. Rossi.
Your Honor, I saw that my client, Mr. McCray, wanted to say something, but he looks like he's gone now from Cobb, so never mind.
You sure?
I don't see him anymore. He had his hand up.
Because all the Cobb booths have been removed because she's trying to fix it so Mr. Singh can get back in.
Okay, well, I think he wanted
Hold
to
on.
say something, so I guess I'll just stay on in case they come back and he's still there.
Let's see. All right, let's go.
So Kabu 2 is back on, but it came back on muted.
Yeah, he's back now. Is he on the list now?
I'm checking right now. Hold on 1 second.
There's a different person in booth 2 now, Your Honor. I think.
No, that's Mr. Singh.
Oh, okay.
That's who we're looking for. Yeah, it's still not on the list though, Tanya. And it's not sure. I don't see it on the list. All right.
I really appreciate it, y'all. If I could just be put in the breakout session and
All you gotta do is go back, but we can't get him in there.
understood. I really appreciate y'all working so hard on this.
All right, yeah. You could go back in the breakout room. If you go back downward the breakout, you could just rejoin the one you're in. That's where Miss Watson is. All right, position 16, 23 CP 216137. 91 days without indictment. This is aggravated stalking for Taurus Williams. There's no bond as of February the 10th. Pre-trial.
Judge, man, I don't mean to interrupt, but he's been indicted.
Oh yeah, got it, buddy. I picked up the wrong one. Thank you. All right, yeah, we're back to Amari Madian. Sorry, that one I picked up that out of my other stack. Okay, Amari Madian.
Your Honor, Miss Madian is housed at ACDC, and that is not
I've heard they got the men first. What about, let's see, Robert Glass. Are you Robert Glass? Okay. All right, 1723 CP 216143, 92 days without indictment as of February the 10th. There's a $50,000 good bond, aggravated assault, possession of firearm during the commission of a felony. Pre-trial.
21 prior arrests, 7 misdemeanors, history of DUIs, felony, CWAC charge in 2016, nothing further.
All right. It's Pinto.
Judge, as an announcement, I'll be handling all of Ms. Pinto's cases today.
Okay, go ahead.
Yes, Judge. Mr. Glass is 78 years old. The only income that he has is through Social Security and disability. He wouldn't be able to afford any bond at this point. He was living, and maybe hopefully still is living, at Mount Zion Road in Atlanta. That is his apartment, but because he's been in jail the past 3 months, no one's been paying any rent. We don't know where he might be living, hopefully still at the same place, but we just don't know, Judge. He doesn't have a serious criminal history as far as I know throughout his 78 years. Just a misdemeanor, I believe, CWAC charge from 2017. Judge, we would be asking, again, also, he is from Atlanta. He has family here, 7 adult children. But still, Judge, he's not able to make any bond. We would just ask that bond be set at $5,000 or less.
What says the state?
The state would agree to a $25,000 bond with a 24/7 ankle monitor, stay away and no contact.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 85 Mount Zion Road. No further contact with GANELL, last name Webb, WEBB. Let's see, you're going to have to supply an address where you're going to be living before you get out. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. 20,000 on count 1, 5,000 on count 2. Best of luck to you, sir. You can leave the booth.
Judge, can I hear that amount again? I'm sorry.
20 on 5, 20, and then 5.
Thank you.
Okay, you got it. All right, what about Giovanni Scrine? All right, Mr. Scrine, 22. We got Miss Eustace on here. All right, we got Giovanni Scrine, 22 CP 210326, 92 days without indictment. There's a $5,000 good bond, which was posted by the Bell Project. I'm assuming they came off of it, Miss Eustace?
They did, Your Honor.
All right, for aggravated assault. Pre-trial.
23 prior arrests, misdemeanor, prior battery in 2017, 3 felonies, false imprisonment, aggravated assault in 2015, theft, prior receiving stolen property in 17, forgery in the first and 18, 2 arrests for probation violation, 1 FTA in 2017. Nothing further.
Go ahead, Miss Eustace.
Yes, Your Honor. As you heard, there is some history for Giovanni. We can't get past that. Giovanni has been in for going about plus 90 days now with this $5,000 bond that cannot be made. I have spoken to PAD. Tracy Crawford, I anticipated being on behalf of PAD because they have accepted Giovanni. Having been back in now, Giovanni is very adamant on getting back with them, getting housing, getting job employment opportunities, and really working the program with them. The only hindrance to that is the $5,000 bond that cannot be made right now. This is the first time that Giovanni really has been wanting to work a program and get help. I think going back in after being out for a few months has really changed that. If you look at the facts, this seems to be a situation in which—
Hold on 1 second. 5 South, booth 3, 5 South. No, turn around. No talking to him behind you. Keep facing forward. No turning around. No giving signals or signs or whatever. Stay facing forward. Go ahead, Miss Eustace.
Yes, Your Honor. Giovanni has been clean now for going over 8 months at this point, was working on getting a GED, wants PAD, as I mentioned before, and actually just had a 27th birthday, I believe, on May 7th, so just earlier last week. So we would be asking at this point, Giovanni's mother lives here. We do have ties to the community.
And we would really appreciate if everybody would sing him happy birthday since he was in jail during his birthday, Your Honor. That is why we have hired the stripper in Cobb booth 2 down in the bottom center, and he will be starting soon.
And we have a program set in place where PAD will come pick Giovanni up, and start the program. So we would be asking for this to be converted to a UJR, just so that we can get to the program instead of having Giovanni sit there and wait for potential indictment.
Mr. Malkin?
We'd ask that the bond remain the same at $5,000, given Mr. Skrine's criminal history, the failure to appear, and multiple felony convictions. Thank you.
Right. Yeah, no drugs unless prescribed, no alcohol, no weapons. Stay away from 2788 Forest Hills Drive Southwest. Not able to use any ride share. If picked up on a hold, you're going to have 48 hours to have an ankle monitor placed on your ankle. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. And you can also go and see your lawyer. Once again, no further contact with Avon, AAVEN Douglas, and do not use rideshare, Lyft, Uber, anything else. You cannot use those. $4,500 good bond. Best of luck to you, sir. You can leave the booth. You also need to provide an address where you'll be living. Put that on there, Miss Tracy. All right, let's go. What about Jimmy Bannister? All right.
Judge, before you go to him, the interpreter wants to know, does she still needs to stay on to see if Miss Mabry Collins is able to get him in a Zoom? Or
all right, Miss Mabry Collins, what does it look like? I mean, it's not popping up. I don't know what to do. I'm all out of IT ideas.
Judge, I will try to coordinate with Ms. Robinson in the future.
Judge. Okay, Judge, we almost there. Give me like, if Mr. Charles, you have like 2 minutes, okay? Give me 2 minutes, okay? All right.
That's because her husband's there helping him, you know. All right, but go ahead.
2 minutes, all right.
All right, let's see. So, Madam Interpreter, you just need to hold on another couple of minutes. They're trying. We have no control over the rooms, okay? All right. 23 CP 216151, Jimmy Ray Bannister, 91 days without indictment. There is no bond as of February the 13th. We got aggravated assault, criminal trespass, family violence, battery, pre-trial.
Bannister, 1 felony of terrorist offense in 2010. Open case 23 CR 0000869C, battery, family violence. Nothing further.
All right. Go ahead, Ms. Correa.
Thank you, Your Honor. As you noted, Mr. Bannister has now been in custody for over 90 days, which means he is statutorily entitled for a bond at this time. Mr. Bannister is 57 years old. He did have his birthday while in custody a few months ago. I'll be filing a change of address on his behalf. We do have an updated address for him that does not include the incident location. That updated address is with his brother, Bobby Bannister.
Damn, I wish I had Mikey's skills right now because I would immediately draw Bobby Bannister. Anyways, good night, Credence and Mikey. Please, everybody, if you are just hearing this, please go check them out. I believe that Carrie was dropping the link earlier in the chat. They have an amazing channel, amazing content, amazing guys, and I hang out there all the time. So please make sure to check in with them tomorrow. They're on the East Coast, and they are so on time, usually, like way better than I am at planning things like that. So anyways, please check them out. And Mikey, have a good sleep. I hope you sleep well and dream of many, many courts and pretrials and whatever you like to dream of. And also hit that like button. Okay.
Mr. Bannister is a lifelong resident of Georgia. He does have ample family members here in the Metro Atlanta area as well. And at the time of his arrest was receiving disability for some ongoing health concerns that he is facing, which do include high blood pressure as well as some thyroid concerns. At this time, so that way Mr. Bannister can, even regardless whatever amount you set today, he does still have, he was arrested at the same time for the other case for which pretrial did announce earlier. He does also have a probation case holding him in, which is why I'll be asking for a lower number, because at this stage, it's unclear as to when that probation matter is going to be resolved. So at this time, I'm asking Your Honor to consider setting a $6,000 bond, that would be $2,000 on each count before you today.
All right, is it gonna be in Fulton County where he's living with his brother?
Your Honor, it's in Yatesville, Georgia.
Okay.
Yatesville.
I don't know, but that's not in Fulton County for sure. All right.
It's in Upson County.
Okay, go ahead, Mr. Malcolm.
Ms. Korea Jameson, do you know if the victim in the open family violence battery is the same victim in this case?
They're actually from the same date. I'm not sure why they were separated.
Okay.
But I guess
Okay.
that is my answer to this question.
Okay, all right. So it looks like maybe there's another warrant for family violence battery. Anyway,
It's open in state court. He was arrested and charged for that at the same time when he was arrested by police officers, and there's currently a $5,000 bond on that one.
Gotcha.
I'm just saying, I don't know why that case didn't accompany this one, because they stem from the same
situation. Okay, thank you. The state would request a total bond of $50,000. Stay away, no contact.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 2883 South Clark Drive in East Point. No further contact with Michael, last name Sorrells. Have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment. As long as you supply the name of your employer, place of employment, schedule, and the exact location you're going to be working. Supply that to the ankle monitoring company and to Miss Korea Jameson. Also, sir, you're going to stay out of Fulton County. The only reason you come to Fulton County is court or to see your lawyer. Don't get gas. Don't get air in your tires. Don't get any snacks. Throw snacks in your car. That way that all you do is you go straight to the courthouse, go in the courthouse, handle your case, go back out, get in the parking deck, and leave. 15,000, 15,000, and 5,000. 15, 10, I'm sorry, 15, 10, and 5. 15, 10, and 5. Best of luck to you, sir. You can leave the booth. All right, got Hiffon Smith. Or Hiffon, sorry, sir, I mispronounced it. 21, Bostic, 22, CP 212877. 222 days without indictment. There's a $40,000 judge bond as of January the 14th, 2023. Criminal attempt to commit armed robbery, aggravated assault with intent to rob, kidnapping, possession of a firearm or a knife during the commission of or attempt to commit certain felonies.
Your Honor, I apologize, Your Honor. Mr. Smith's case should actually be represented by Hannah Rhonda. And this case has been, I didn't realize he was on this calendar, but he has been referred to the conflict defender's office.
Okay.
Judge, I'll reset the case to a conflict defender case, conflict attorney case, a calendar.
All right, sir. Obviously, there's a conflict attorney. It's Miss Hannah Rondon that's been assigned to it. So Miss Korea Jameson can't represent you anymore because there's some sort of conflict. But we'll get you back on in another, week or so, I guess?
In about 2 weeks, we'll put it back on.
We'll get you back on another 2 weeks to address your bond again. Thank you, sir. You can leave the booth.
Which I apologize, Your Honor. I didn't know
okay.
he was on the calendar.
All right. We got Jamel Francis. All right. Mr. Singleton. A man we rarely see, but I heard he's a great lawyer. Rarely does he surface. All right. 22 CP 215038. Jamel William Francis, 133 days without indictment. Aggravated assault and cruelty in the third. There's a $16,000 good bond as of February the 6th, 2023. Pre-trial.
Just a moment.
Judge, they're actually in there, all three of them.
Oh, thank you so much. Well, where did
thank Dana. We had to go all the way out and grab them and reassign them and do all kind of crazy stuff.
Well,
his
booth
is
back in the here.
Yeah, he's in there in the empty now. Joe,
no, it says that he joined room number 1.
Oh, no, room 2. But you see the booth on the screen?
Oh, y'all want him in room 2 now?
No, look.
I see him.
Oh, no. Cobb booth 2 is still on the screen.
He's still on the screen? Hold on one second.
Okay, hold on. But he's not in the room.
Oh,
he's not physically in Cobb booth 2.
I see now.
Yeah.
So he don't laugh.
That's it. I don't know what to do. But besides, Bostic, go for it, Bostic. Pre-trial.
Francis, 11 prior arrests, 7 misdemeanors, 1 FTA. 1 felony entering auto in 2016.
All right, go ahead, Mr. Singleton.
Thank you, Your Honor. At this point, Mr. Francis has been in custody for 133 days with no indictment. His address on file is a valid address. It is located here in Fulton County, Your Honor. He had a preliminary hearing on February 6th of this year. In that hearing, in terms to the cruelty to children in the 3rd-degree charge, Your Honor, there is a lot of questions about whether the child was even present at the time of this alleged incident. That was by the testimony of the officer that day, and the officer testified that there were no bruises or any type of physical injury done to the complainant in this case, Your Honor. He is in on a $16,000 bond that he nor his family have been able to make. He does not live at the incident location. And at this time, we are asking for the bond to be significantly reduced. We are asking for a split bond, a UJR on the misdemeanor charge, and for a bond not to exceed $7,500 on the felony charge, as we heard from pretrial. You heard no type of violent history from him, Your Honor. And I think that weighs heavily in his favor. Plus, he is innocent until proven guilty. So we would ask for that bond reduction. And
hey, 5 South, booth 3, where is he going? Sorry, Mr. Singleton. I can't hear you. Sit down. Go ahead.
Okay. And we would just ask that the conditions to bond not be excessive, because he does work and has to support his child. The child that was allegedly there is his child, so he would need to work in order to support his child, Your Honor. So we ask for that bond reduction and limited conditions on the bond release. Thank you.
Mr. Singleton, is there an open juvenile case or anything?
No, Your Honor.
Okay. All right, go ahead, Mr. Malcolm.
Thank you. The state requests a bond of $15,500 total on both charges: stay away, no contact, 24/7 ankle monitor. Thank you.
All right. No drugs unless prescribed, no alcohol, no weapons, except an ankle monitor paid for by the county with a 24-hour curfew. Work, attorney visits, court. Also, what else? Medical. As long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. Stay away from 294 Brownlee Road, Atlanta. This says must, and this is what the judge put on there before, must reside at 204 Sandalwood Drive, Atlanta 30350. No further contact with Nia Fletcher. No further contact with Alicia Fletcher. I'm assuming one of those may be the minor child, so.
No, Your Honor.
No,
Neither
okay.
of the child. That is his cousin and his aunt.
Okay, so it shouldn't matter about any, don't need to put anything in there about the minor child. Do one of them have custody of the child?
No, Your Honor.
Okay. So I'll do 10,000 count 1, 500 count 2. Best of luck to you, sir. You can leave the booth.
Thank you, Your Honor. That actually concludes my business with the court today. May I be excused?
Yeah, thank you so much. Have a good one.
You too.
All right, we got Antoine Howell. All right, Miss Eustace, disposition 6, 23 CP 215140, Antoine Dante Howell, 129 days without indictment, $15,000 good bond as of February the 9th, 2023. Possession of firearm by a convicted felon. Pre-trial.
34 prior arrests, 8 misdemeanors, 2 FTAs, 1 probation violation, repeat offender, at least 5 felonies, nothing further.
All right. Go ahead, Miss Eustace.
Yes, Your Honor, my client is 36 years old. As you noted, he's got a $15,000 good bond since February the 9th, which he is unable to post. He's born and raised in Georgia, has family here. He did receive some MH treatment prior to this, and we are trying to follow up with that as well. What we would be asking would be a $5,000 bond. That way we can get him a program and get him through the bail project to that program to address some of the MH issues.
All right. Go ahead, Mr. Malcolm.
We'd request a $12,000 bond, please.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no further contact with Terrence Thomas. Let's see, it says stay away from 1193 Lee Street in Atlanta, Georgia. So do ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you'll be working. And Ms. Eustace, just come back in like 6 months, as long as there's no violations, we'll be glad to take that off. $5,000 good bond. Best of luck to you, sir. You can leave the booth.
Thank you, Judge.
Jakeem Forrester. All right, we got, this is position 5. We got 23 CP 215138, 129 days without indictment. There is a $500,000 good bond as of February the 9th, 2023 for reckless driving, driving improper lane change, aggravated assault, cruelty to children in the third, cruelty in the first, aggravated assault, terroristic threats and acts. Wait, oh, hold on a minute. Hold on, I left one off. I got another aggravated assault. Wait a minute. Hold on a second. I think I just, wait. Let me do this. I think there's a couple charges that are left off of. Hold on. Let me start over again. All right. Driving improper erratic lane changes, terroristic threats, felony, aggravated assault, cruelty in the first, cruelty in the third, and another ag assault and a reckless driving.
Arrest Nevada 1, California 1, Georgia 4, 1 misdemeanor, 1 FTA. Nothing further.
All right, go ahead, Ms. Eustace.
Yes, Your Honor. As you heard, my client does have some out-of-state history, and that's because his family is actually in Michigan. We would be asking for him to get permission to go live with his mother, and I do have a permanent address that I can place in the chat. If not Michigan, he is able to also go live with his father, who lives in Snellville. So depending on if Your Honor wants to keep him out of the state or make him stay in state, I do have options for both of those. He is 28 years old and has one 7-year-old child that he wishes to continue seeing with. When this incident occurred, it was actually during a bout of MH issues. Since then, he has been given medication and has been doing very well with it. He also had some resources outside of here to be able to continue doing such treatment, to be able to get that. His mother has been very involved, wanting him out and wanting to get him home so she can continue where he now has been stabilized. He does have a high school diploma and some college where he was attending and studying biology. We would be asking for a bond not to exceed $10,000, Your Honor.
All right, Mr. Malkin.
Your Honor, the state is very concerned for the safety of the victim and the victim's son. In this case, we have spoken with the victim, and the victim is opposed to bond. The victim has informed us that the defendant has tried to contact her by phone and by mail, and she is afraid for her and her son. Given that Mr. Forrester is a multi-state offender, does not have significant roots in the community, and has been in contact with the victim, the state requests that the bond remain the same. Thank you.
All right, so would you like for him to live in Snellville or go back to Michigan?
Are you asking me?
Yeah, she said he could either live in Snellville or go back to Michigan where his mom lives.
Well, if he's going to be getting out, we would prefer that he remain local, but we don't want him to have.
Well, I mean, if he gets a bond, he may have somebody post his bond. I'm just saying, if you
right.
Want. All right, no drugs unless prescribed, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, location you're going to be working in, a schedule. You have to supply that to the ankle monitoring company and to Miss Eustace. No further contact with Chase Forrester. No further contact with KEA Baldwin. No further driving unless your bond is modified. All right, and you're going to live at that. You must live at that Snellville address, but you got to stay out of Fulton County. Live in Snellville. The only reason you come back to Fulton County is court, see your lawyer. Period. Don't get gas, don't get snacks, don't get to stop at Chick-fil-A or anything like that, but you have to stay in Snellville. So I'll do 10,000, 15,000, 80,000, 80,000, 15,000, and 80,000. 10,000, 15,000, 80, 80, 15, and 80. You got that, Miss Tracy?
One more time.
10,000, 15,000, 80,000, 80,000, 15,000, and 80,000.
10, 15, 80, 80, 80, 15, 80.
10, 15, yeah, 80, 80, 80, yeah. 15 and 80.
Okay.
All right. Best of luck to you, sir. You can leave the booth. Folks and just so everybody knows, I've already put folks in the email to Miss Willis. I've got Lauren Tadamy.
And Your Honor, I'll be covering for Ms. Cole on that case.
All right, Lauren Tadamy. No, Lauren. All right, what about Dwayne High? Thank you, sir. All right, 22 CP 210430, 311 days without indictment. There's an $80,000 good bond as of 2/9/2023 on aggravated assault with a deadly weapon and possession of firearm during the commission of a felony. Free trial.
What was the last name? Dwayne
High. Yeah, 2.
6 prior arrests, 2014 ag assault. All of his arrests are for violence. Nothing further.
All right. Go ahead, Ms. Eustace.
Yes, Your Honor, my client's 29 years old and a lifelong resident of Georgia. I've already spoken to him about a stay away and a no contact, and that is completely okay with him. That is actually something that he's completely wanting to do. He does have 4 children, 2 of which live with him, and he is the sole provider for. He will be returning to his mother's house, which is an Atlanta address, where he will be residing with her and his children as well. He's been gainfully employed for 2 years before this arrest, working as a UPS loader. His usual work hours are somewhere between 10 p.m. and 4 a.m. doing the overnight shift. He's gotten as far as the 12th grade, but is wanting to get into a GED program upon his release. We would be asking for a bond not to exceed $15,000, Your Honor. And we are okay with an ankle monitor. I have informed him of that. However, because of his work schedule and the UPS loading, he would ask for some flexibility on that curfew.
All right. Go ahead, Mr. Malkin.
Thank you. Mr. High is alleged to have shot somebody. He's got all violent arrests. The state requests that the bond remain the same. The state believes that he poses a significant risk of committing new crimes, danger to the community, danger to the victim. Thank you.
All right. 311 days without indictment once again. So no drugs unless prescribed, no alcohol, no weapons, no further contact with Shanta, Shanta Clark, and John Allen. Stay away from 540 Norfolk Street, Northwest in Atlanta, Georgia. You're gonna have ankle monitor paid for by the county. It's a 24-hour curfew, sir. Where'd you go? But you can court, lawyer, medical, and employment. Sir, I know that your schedule, 5 South, booth 3. Mr. High. Mr. High. So it's a 24-hour curfew, but I know you work different shifts. So as long as you give your shift that you're working to the ankle monitoring company and to Miss Eustace, then that's fine. If something happens and you decide to work late, you'll have a number for the ankle monitoring company. So just call and let them know, okay? All right. So we'll do 40,000 count 1, 10,000 count 2. Best of luck to you, sir. You can leave the booth. His name's already on my list. Brian Payne. All right, 14, Bostic, 23, CP 216113. Brian Payne, 92 days without indictment. No bond as of February the 10th. Aggravated assault, possession of firearm by a convicted felon, possession of firearm during the attempt or commission of a felony. Pre-trial.
14 prior arrests, 1 probation violation. Think he has a hold in Jonesboro for an FTA in 2016, 1 felony for entering auto, open case 21 CP 198297, theft by receiving firearm by, open case 21 CR 0041517E, simple battery and family violence. Nothing further.
All right, go ahead, Mr. Rhodes.
Thank you, Judge. Mr. Payne is 26 years old. We do have an address for him. I believe the jail doesn't have one listed, but he will be able to live with his mother in Riverdale. And we have spoken with his mother about that. He is from Georgia. He's been living in Georgia his whole life. He has 2 children as well, at age 5 and 6 years old. He'd of course like to go out and see his family again and take care of his children. He's a graduate from Creekside High School and has been working as a fleet manager for the Bird Scooter Company, if you've happened to have seen those around. He's been doing that for the past 5 years. Judge, as it stands, he doesn't have a lot of money to afford for bond. Right now, he is, of course, entitled to a bond, being in jail for 91 days without indictment. Judge, we would ask for bond to be set at no higher than $7,000 in total.
All right. Go ahead, Mr. Malcolm.
All right. The state requests the same bond for Mr. Payne that Mr. Hyde, the previous person, had prior to today, which was $80,000.
All right. Let's see. No drugs unless prescribed, no alcohol, no weapons. Stay away from 6595 Woodford Road. No further contact with Winford, W-I-N-F-O-R-D, Spare, S-P-A-R-E. You can have ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. And his address is Riverdale. That's Clayton County, I think, right?
Yes.
Clayton County, sir? Stay out of Fulton County unless you're here for court or to see your lawyer. Don't get gas. Don't get a flat tire. Stay out of Fulton County. Come straight to the courthouse, see your lawyer, or go to court. Other than that, stay out of Fulton County. So I got, let's see, 20,000, 10,000, and 10,000. Best of luck to you, sir. Let's see. Now we've got, is Shanti Brooks. All right, Mark. Don't say they could have stayed where they were. All right, Shanti Brooks, 22 CP 209955. Shanti Adele Brooks, 320 days without indictment. There's an $8,000 good bond as of January the 26th, 2023. Aggravated assault. Free trial.
Shanti Brooks, arrest in Florida and Michigan, 5 in Georgia. First offender on 2018 for financial transaction card fraud. FTA in 2019, 1 arrest for probation violation. Nothing further.
All right. Go ahead, Ms. Correa.
Thank you, Your Honor. As you correctly noted, she has now been in custody for 329 days without indictment. Her last hearing, which was back in September, the state announced that they still had not had any victim contact. In this case, we've already had the preliminary hearing. Improbable cause was found, so at this point there is nothing to do but wait for an indictment on this case, should that indictment ever happen. Ms. Brooks is 36 years old. She's resided in Atlanta since 2011. The address reflected at Odyssey is a good address for her. That is where she resides with a roommate. Her 3 daughters are in the Metro Atlanta area, as is her grandchild. And she has been in connection with different churches in the area. At this time, given that we're nearing 1 year without indictment and any victim contact is still uncertain, I'm asking the court to consider setting a $1,000 bond for Ms. Brooks. Thank you.
Go ahead, Mr. Malcolm.
What is her current bond, please? I didn't catch it.
8,000.
So 8. Okay. The state would request a $4,000 bond. Thank you.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Lawrence Johnson. Stay away from 375 Auburn Avenue Northeast in Atlanta. You can have ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. And previously, I had put inmates treatment. So in the event you need inmates treatment, that'll be fine also. $4,000 good bond. Best of luck to you, ma'am.
Judge, I don't mean to interrupt you, but for the interpreter, since it doesn't look like that's gonna happen.
As interpreter, you can
Well,
leave.
actually, we've been waiting on them. Ms.
Have
Robinson.
you got in touch with booth 2 to get them there? Because
Yeah, he's not in there. That's the only thing.
So
We put them all 3 in there and then we reset it and nobody is in there.
I can try to reach out to Cobb to see if they can get him back in the booth with Lieutenant. I'm not sure that let me reach out to Cobb and see if they can get him back in the booth.
that's
Okay,
true.
no
Some
problem.
of them may have left, but Mr. Cho, I'm sorry if the deputy's already left. I guess you may have to just, sorry.
I can ask Lieutenant and see if that's possible, and then I can come back and give you a response.
I'll reach out to Cobb right now.
Thank you guys so much. I really appreciate it.
All right. Let's see.
All right.
Amira Madian. Is that right, ma'am? All right. So we got 195 days without indictment. 22 CP 213578. Hindering apprehension or punishment of a criminal. Aggravated assault and aggravated battery. 195 days without indictment. There's a $20,000 good bond as of February the 10th, 2023. Pre-trial.
Only prior arrest.
All right, go ahead, Ms. Correa.
Thank you, Your Honor. Ms. Madigan was originally booked in only on the hindering the apprehension charge. It was at her preliminary hearing that Judge Dallas determined that there was sufficient probable cause to add the aggravated assault and the aggravated battery as party to a crime, since she was present for the incident that led to the underlying hindering the apprehension. It was in that preliminary hearing that we actually uncovered the name of the alleged person for the hindering the apprehension charge. And while that person is actually in custody, that person is not in custody on these charges and has yet to be arrested on these charges for this offense. So Ms. Madigan has now been in custody for 195 days. She turned 19 years old. She's been in the Metro Atlanta area since she was in the 5th grade. The address reflected in Odyssey is a good address with her. That is where she lives with her father. Her father works 12-hour shifts at Grady Hospital in janitorial and maintenance there. At the time of her arrest, she was working as a family caregiver to help provide her father's support. So given that he would be gone from the home for such extensive amounts of time during the day. At the time of her arrest, she actually did meet the criteria for an unsecured judicial release, but of course the addition of these charges do disqualify her from that. At this point, given that the alleged co-defendant in this case has not been apprehended for this specific incident, and that this case remains unindicted, despite that there has been this preliminary hearing where his name was read out to the court. I'm asking Your Honor to consider reducing this bond. I'm asking for this bond to not exceed $10,000 total. Thank you, Judge.
All right, Mr. Malkin.
Your Honor, our office has spoken with the victim in this case. Our victim does not have an opinion on bond and is not in fear of the defendant, so the state would agree with the defense's request.
All right, so let's see. All right, no drugs unless prescribed, no alcohol, no weapons. No further contact with Markel, Markel Knight, or the family of Markel Knight. I'm sorry, I have a judge calling me. Can everyone stand by for 1 second?
Yes, Judge, we can absolutely stand by for 1 second. That is a great time frame for us to go ahead and make sure we have liked this video if you're just clocking in for your shift now. If you're just joining us, we are watching Judge Alex Manning, who is out of Fulton County, Georgia. She is a judge who is hearing bond hearings. These are for people that have been arrested for a crime. Hold on. I'm going to play this while I'm doing that part because we don't want to have to wait after. These people have been arrested for a crime, but they are not indicted yet. And so there's a big difference there. And what that means in the state of Georgia is that after 90 days in incarceration, you are entitled to a monetary bond, even if at the first bond you were determined to not get one. Yay, Sean Wexler in the house. Wow, my friend. Thank you so much for coming by. I'm so glad that you're here. Let me pop on the screen. Where am I? There I am. Thank you so much. I appreciate you. We're having a bit of an ADD day, but thank you very much. Make sure you clock in for your shift. Anyways, so what I was saying is that here in Georgia, after 9 days, regardless if there is a determination of no bond, after 90 days, there's now a new right, basically, which kicks in to entitle them to a redetermination of bond. And so that's exactly what the judge is doing here. She is working overtime and night court. I'm just going to finish telling them about how hard you work. In order to actually make these things happen. It's funded through a project called the ORCA project, which is the funding that you'll hear her talk about for ankle monitors and different things. This this is a backlog within this system, quite big, but they are working at it as best they can. I have to say that I used to watch these pretty religiously when Judge Manning was on, and the state has improved their attitude, I would say, but not greatly. But remember, there used to be some that just were sucky. They just sucked. Anyways, let's continue with Judge Manning. She's going to finish this up. Thank you again, Sean Wexler. Appreciate you for becoming a member. I'm sorry if I'm breaking up. I will fix it. Let's go back.
Back with alleged co-defendant Jodarius, Jodarius Carr, Carr, 500 count 1, 2000 and 2000. 500 count 1 and 2000, 2000. Best of luck to you, ma'am. Thank you, South Annex.
Thank you, Judge.
Antoine Reeves. Antoine Reeves, sorry. All right, there we go. All right, it's 11, Bostic, 202 days without indictment. 22 CP 213394, Antoine Reeves, aggravated assault. There's a $15,000 good bond as of February the 7th. Pre-trial. Bostic, you're on mute. Bostic, you're on mute.
I know. I thought I had to sneeze.
Well, that's a bless you.
3 prior arrests, 2 open misdemeanors, 22 CR 00237C battery, 22 CR 004566C criminal trespass and obstruction.
All right, go ahead, Mr. Anderson.
Thank you, Your Honor. Mr. Reeves is 18 years old. He's a lifelong Atlanta resident, and his whole family is here. He has been in jail 202 days, so over 6 months with no preliminary hearing, no indictment for just the 1 count of aggravated assault. His 2 prior cycles are both misdemeanors. He was living at the incident address, but he can stay with his father in Cobb County. I don't have a specific address, but I have spoken with the father. His father was trying to make the current $15,000 bond, but is just not able to. And Mr. Reeves is on SSA disability. Because of the length of time, the inability to pay the $15,000. Mr. Reeves would of course request a UJR while acknowledging that pretrial has not recommended him for that. We would request no more than $5,000 so we can try to get the bail project to help get him out.
All right, go ahead, Mr. Malkin.
All right. We thought that the victim would be on Zoom. I don't see him, but anyway, the victim has told us that he is not afraid of Mr. Reeves and is okay with bond, but nonetheless, the state is requesting a $10,000 bond. Stay away, no contact.
No drugs unless prescribed, no alcohol, no weapons. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment, schedule, the exact location you'll be working. No further contact with Antonio Reeves. Stay away from 445 Cleveland Avenue. And stay out of Cobb County, stay out of Cobb County. No, stay out of Fulton County unless you're for court or to see your lawyer. No gas, no flat tire, no snacks. From my understanding, that's his brother. So, Mr. Anderson, you know this, and he'll know this. If their parents are alive and something happens to one of their parents, I'm not going to consider it a violation if, let's say, God forbid, a parent gets sick and they both have to go to the hospital. But stay away from your brother, okay, sir, unless an absolute emergency. If something like that happens, reach out to Mr. Anderson so he can get an order from me allowing you to go see that sick parent or what have you if your brother's there, okay? $10,000 good bond. Best of luck to you, sir. And I've already put that name in my email. All right, Mikhail Ramsey. Mr. Ramsey, position 4, Bostic, 22 CP 209104. 361 days without indictment. There is a $240,000 good bond as of February the 9th, 361 days without indictment. Armed robbery, ag assault, possession of a firearm by a convicted felon, possession of a firearm during the commission of a felony, and armed robbery. Pre-trial.
5 prior arrests. Took time served. Dang it. On 22 SC 184580, March the 22nd of this year. On probation 17 SC 159027 for aggravated assault with the intent to rob, criminal attempted armed robbery. Sentence 9/6/17, 1 year confinement, 7 years probation. Nothing further.
All right. Go ahead, Ms. Fiacco.
Thank you, Your Honor. On behalf of Mr. Ramsey, as the court said, he's been in custody for 361 days. He was arrested May 16th, 2022. So we are 5 days away from marking Mr. Ramsey's year at 901 Rice Street. There has been no indictment. I don't foresee one in the future anytime soon, given the state's movement with this case. Probable cause was found on September 22nd, 2022. That's over 7 months ago. And the state has done nothing since then. The state could have had that officer go upstairs and testify to the grand jury that day, but they didn't. They've continued to slow walk this case so that Mr. Ramsey continues to sit in jail with a bond he cannot afford. It is a $240,000 good bond. Mr. Ramsey cannot even come close to beginning to post that bond. I have filed a demand for a constitutional speedy trial on behalf of Mr. Ramsey. That was filed on April 21st, 2023. We are continuing to invoke that right. He does have a constitutional right to a speedy trial, and we will be jumping up and down and waving our arms and demanding that every time we are before the court. Mr. Ramsey is 32 years old. He does live here in Atlanta. I just submitted a change of address form to the clerk's office tonight during court, so they should have good updated address for him. Mr. Ramsey is a high school graduate and did attend some college. Prior to his arrest, he was working for a UPS warehouse, and he does anticipate that he could return to that job if he were to bond out. As you heard from pretrial, Mr. Ramsey did resolve his other pending case here in Fulton County. So this is the only matter that remains that's holding him in custody. Again, he has $240,000 good bond. We are asking for $5,000 per charge. So that would be a total of $30,000 good. That's the request from the defense.
Right. Mr. Balkin.
Given that Mr. Ramsey is on probation for aggravated assault and attempted armed robbery, and he's currently charged with armed robbery, the state requests that the bond remain the same. Thank you.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Felicia Shedrick, Shedrick, and Shontavia, Shontavia Knowles, Nalls. Stay away from 2296 Cascade Road in Atlanta, Georgia. And previously, Ms. Fiacco must reside at 296 West Cedar Lane. Is that still where he'll be able to reside?
I had the street number wrong.
Okay. Is it 296, sir?
No, but I could put it in the chat. Just with how public these hearings have become,
Okay,
I'm
so-
happy to put it in the chat.
All right, well, you have to just tell the clerk because I have to.
Sure.
All right. Yeah. All right. Let's see. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're working. 20,000 on each count. Best of luck to you, sir. And I guess we don't have any choice, Miss Fiacco. Do that or stay at the courthouse with it wide open and let people in. And I don't think that's going to happen. So let's see. Boom. Best of luck to you, sir. You can leave the booth. DeAndre Norris. Thank you, Miss Fiacco. Is that your only one?
Yes, Your Honor. Once I put Mr. Ramsey's address in the chat, may I be excused?
Yes, ma'am. Have a good evening.
Thank you.
DeAndre Norris. All right, we got position 20, Bostic, 222 days without indictment. DeAndre Norris, possession of marijuana with intent to distribute, possession of firearm during the commission of a felony, and possession of a firearm by a convicted felon. $19,000 good bond as of January the 19th. Pre-trial. Second.
What number?
20, DeAndre Norris.
15 prior arrests, open case 23 CP 217295, aggravated battery, probation 21 SC 178276, entering auto sentence 12622, 18 months confinement, 3 years, 6 months probation, 16 SC 144929, aggravated assault on a police officer's 4 counts, sentence 10-3-17, 3 years confinement, 7 years probation, nothing further.
All right. Go ahead, Ms. Safarasi.
I'm sorry, Your Honor, what case is this?
DeAndre Norris.
Your Honor, he's a conflict for my office. I don't represent him.
Okay, so, well, I mean, nobody tells me I have to go.
I'm sorry, Your Honor, I didn't even know he was on the calendar because we submitted that conflict request a long time ago. There was a jail incident case.
So, yeah, did the public defender not get a copy of this calendar?
I did, Your Honor, but I thought he was already with the conflicts office. That is my apologies.
Right. That's all right, Mr. Norris. We're gonna have to bring you back on here. You got to get us on a conflict defender before we can address bond. Okay?
Your Honor, I will reach out to conflict to make sure they know about this case, so he doesn't.
But it says on here that he had made it, but I don't know if they came off of it. Sir, did Freedom Rings post your bond? Yeah. I mean, well, it's on there, so unless something else holding you, unless they came off.
There was a jail incident case, Your Honor, which was the reason for the conflict, and so I think could be one of the other cases that's also holding him.
Okay. All right. Thank you, sir. We'll see you in 2 weeks. All right. Anything else for the interpreter, Miss Mabry Collins?
Yes, sir. Yes, ma'am.
That's all right. How are we doing? Because we don't have Cobb back.
Well, if we don't have Cobb, do they want to still meet up?
Yeah, Lieutenant Coughlin, I'm not sure
because the interpreter keeps asking, and I don't know what's going on with Cobb.
There's no staff member at Cobb County.
Okay.
Okay, well then.
All right, there you go. You can leave, Madam Interpreter. Mr. Cho, I guess, do you need her contact info so that you can reach out to her when you need to talk to your client?
I'm going to go through Miss Robinson, if that's okay with Miss Robinson.
Well, I mean, I don't know. To get the number?
I
mean,
think there has to be some kind of payment.
I think you talked with Tanja Richardson about.
No, for Orca, you go directly through us. Tanja doesn't handle.
Okay.
For Orca.
But I mean, so he's got to go through you to get interpreted when he meets with his client?
I'm not sure the process. Phoenix is on. Maybe she can weigh in, or her Tanika, what the process would be. But I just know that for the exotic language, other than Spanish, they would go through us. One of them may be able to weigh in and tell the process of how they would like for it to work.
All right. Well, she can leave though, right?
Correct. The interpreter can leave.
All right. Thank you, Madam Interpreter.
Thank you so very much. Appreciate that.
All right.
Bye.
Jarius Anderson. All right. Let's see. It's position 12, Bostic 22, CP 213393. 201 days without indictment. There is a $31,000 good bond as of February the 7th on hijacking a motor vehicle, aggravated assault, and battery. Pre-trial.
12 prior arrests, 1 felony, 2 misdemeanors, 1 being a DUI, 1 probation violation, 1 FTA. Nothing further.
All right. Go ahead, Mr. Anderson.
Thank you, Your Honor. Mr. Anderson, and I believe there's a Scrivener's error on his paperwork. It's actually Jairus. The I and the R are reversed. He's 37 years old. He's lived in Georgia his entire life, along with his whole family. He lives with his wife and 7-year-old daughter in McDonough. He has 3 other adult children, has an associate's degree in electrical engineering, and has worked as an electrician. As the court noted, he's been in jail 201 days without an indictment. He has issues with PTSD and anxiety, so I'm sure jail is a difficult experience. His probable cause order was entered on February 7th. So that was 93 days ago. He's been sitting there an additional 3 months with probable cause found, no indictment, no moving forward on this case. And that was also the last time his bond was set. And he's just not able to make the current $31,000 bond. As far as the factors in his case, he has strong ties here with his family, so there's no risk of flight, and he wants to get to court to get this sorted out and tell his side of what happened. He does not know the alleged victim, and I believe the officer testified at the probable cause hearing that they don't know each other, so there's no threat.
Excuse me, Kevin Anderson. I'd like to say something if you just give me a moment, please and thank you. Hold on, please. There's a good question in the chat. And, sometimes different courts use different terminologies and it's hard to sort of track what is what. But the question that we had was from Jerry, and it's asking, what is a good bond? Now, I've wondered that myself, and I've done a little research onto it, and it's a little bit difficult to ascertain exactly because, like I said, each court uses different terminology differently. However, what I can understand is that a good bond means that it is a bond that includes both a monetary amount and a requirement for good behavior of the person. So it's likely a bond that was, or it's likely a crime that involved maybe an assaultive behavior or some sort of violent act. And yeah, I think that's what a good bond is. Maybe I'm wrong. Like a PR bond is called that because that stands for personal recognizance. And that means that you are being released on your own recognizance, or an OR bond. You sometimes hear it called own recognizance. And so those are different than a good bond. So it's not like good means that it's a better bond. I think it really references the fact that there's an expectation and a known requirement within the bond conditions that requires good behavior. So yeah, I think I'm right on that. But you never know. We can learn every day. Twizzlers. I could eat Twizzlers. I definitely can eat a few of those. Reasonable for the defense and prosecutor can agree on. I don't know if that has to do with it though, because they don't agree always. That's called a consent agreement or a consented bond amount, I believe. Tupac says they call it OR there. And again, remember, I'm Canadian and things are very different here. We don't even have the same bond and bail system whatsoever. It's completely different. So, what I think the other thing to remember is that when the judge, when they often, like, these people have been in jail for a very long time without being indicted by the government. And so the average person doesn't really think that this happens. Even when you commit heinous crimes, we don't think that it happens without due process and expedition of justice. But some of these people are in here for very, very minute crimes. And I think that it is something that, like the judge, you'll hear her reference, oh, I'm going to send an email. That is the people on the list that she saw that night that have been in jail too long and need the office to be looking into it. And Judge Manning is great for that. The reality is that judges are timekeepers. They are schedulers and they are train rollers. They have to keep things going the same way. And so one of the main jobs that you'll hear, like when you get watching court a lot, what you hear judges do all the time is scheduling. They're deferring, they're putting a continuance, they're putting it out for 60 days, this, that, the other. Well, all of that is umbrellaed under case management. And the judge, their role pre-trial is not always as a decider of fact, but as a case management person to keep an eye and make sure that these things don't get piled up like they do. Now, the problem is that I think COVID had an impact, and there's just many different reasons for this. But ideally, a judge knows what's on their docket that's stale and is on that, because, and so does a prosecutor. So these are quite unique bond hearings because they are like people that are in jail. And again, jail is for people that are not convicted yet or under 2 years. I think, anyways, regardless, these people are all innocent, absolutely innocent until proven guilty. And regardless of what the crimes are alleged to have been, they are lucky to be in front of Judge Manning because she cares and sees the issue with having people in front of her like that. Anyways, let's continue on and we will see what we finish off with here. I'm trying to remember. I was thinking about something else, but I forget now. So let's just keep going.
To her or risk of witness intimidation. As far as prior felony convictions, I believe those are all, or that one was more than 10 years old. No violent convictions within the last 10 years. So again, basically just because of the length of time that he's been sitting in here and his inability to make the bond, we would ask for it basically to be cut in half, 10,000, 5,000, and 500.
All right. Go ahead, Mr. Malcolm.
All right. I thought that the victim was going to be on the Zoom. She may have been on the Zoom before Monet Lewis. I don't know if she's still on, but at any rate, the
I see
victim.
There's someone on the Zoom with that name.
Miss Lewis,
Oh.
if you
Okay.
hold
Miss
on.
Lewis.
Miss Lewis, if you want to say something, you're going to have to turn your camera on.
Oh, give me 1 second. I'm trying to figure this out. There we go. Hello, how are you?
If you want to raise your right hand, do you swear affirm testimony you're about to give is truth, whole truth, nothing but the truth?
Yes.
All right, go ahead, Mr. Malcolm.
Right. Good evening, Ms. Lewis. Would you please tell the judge why you are opposed to bond being lowered in this case?
I personally feel like because him and I do not know each other whatsoever, we've never seen each other. I've never seen this man before a day in my life. Because the attack was so violent and I have so many scars across my body from this, I feel like that because this happened to somebody you don't know, I feel like it's possible to happen against anybody else.
Okay. You feel like he is a danger to the community if he would be released?
I believe he's a huge threat to the community.
Okay. Based on what he did to you, his assault on you? Okay. All right. Thank you very much.
All right. Thank you very much, Miss Lewis. No, I'm going to add some conditions here. So when I add conditions, I have to lower it a little bit because I'm making changes. He going to still live in McDonough, Mr. Anderson?
I believe so, yes.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Monet, M-O-N-A-E Lewis. Stay out of Fulton County, sir, unless you're here for court or to see your lawyer. Don't stop for gas, don't get snacks, don't get a flat tire. Do not come into Fulton County. Stay away from 815 Sidney Marcus Boulevard. And that's also in Fulton County, so you shouldn't have a problem with that. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, attorney visits, meaning lawyer and medical. You can leave for employment as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. But it's not going to be in Fulton County, so you stay down there in Henry County. 19,000, 10,000, and 1,000. 19,000, 10,000, and 1,000. Best of luck to you, sir. Ms. Lewis, I dropped it by 1,000 because I added some conditions. Thank you, Ms. Lewis. Have a good evening. David Miller.
Maybe
You can lead the booth, sir.
Your Honor.
Yes, sir. Have a good evening.
Thank you, you too.
All right, let's see. Mr. Miller. Hold on 1 second. So we got position 2526. I think it's a few cases there, Bostic. 22 CP 206-539, David Miller, 464 days without indictment. There's $104,000 good bond as of December the 6th on armed robbery, aggravated assault with intent to rob, possession of a knife or a firearm during the commission of a felony. 26 is 22 CP 206-241, 464 days without indictment. There is a $122,000 good bond as of December the 6th, armed robbery, aggravated assault with intent to rob, sexual battery, theft by taking, possession of a knife or a firearm during the commission of or attempt to commit certain felonies. 27 is 22 CP 206-537. 464 days without indictment. There's a $105,000 good bond as of December the 6th on armed
460 something days without indictment. I mean, again, I'm Canadian, but in the States, that whole presumption of innocence, like the problem here is this, right? You don't see anybody very often on these Zoom calls with private lawyers because private lawyers get people out of jail. Now, how many chances do you give a career criminal? Jerry, how many chances at charging them with a crime is up to the police. However, once they initiate that process, the presumption of the right to be presumed innocent and to have counsel defend you is there no matter what your past is. And so unfortunately, while I get what you're saying and the sentiment around it, what that really needs to be dealt with in is sentencing and people that dealing with repeat offenders on their sentencing, not at their pretrial detainment, I think. Now, I'm not saying 3 strikes is a good situation either. That's not something that I talk about. But I'll tell you, in the city that I live in, we have an extreme, I don't, well, whatever. There's a lot of theft at the moment. And they don't ever keep anybody in jail. So there are people that have done like 52 thefts this year and are released immediately after being caught. That I don't really think is very smart. Like there's this happy medium of like, hey, you messed up and that's not cool and this is our community and we don't want that happening here. However, it has to be balanced with the fact that oftentimes when people are incarcerated over and over again, the recidivism rates are there because of like fees and costs that are imposed that are impossible for some people to pay in the end. And again, sometimes you think about it, the fees and costs that people are brought in front of a judge for, the judge and everybody on the screen, it costs more than all of that for that 20 minutes, you know? That 20 minutes of time on the screen. But that's not what we look at. We're not looking at how the kids, or how, I always say kids because we often do juveniles, but how the person is best to succeed. We're looking at how do we feel better to make sure that this person's punished, because we are good people. We do the right thing and it's hard. So when people do the wrong thing, it's natural to want to make them pay a little bit, but you have to actually, if you step back from that and think about more broadly what the impacts of that are on the society, you're better off if you actually don't do that for petty crimes. When when you're dealing with serious R words and murder, unaliving, all that kind of stuff is serious. I think the problem is that here's the reality. If you took drugs out of the system, you would probably have a lot more time to deal with a lot of other things. But in order to do that, you have to legalize, and not just legalize, but like provide good quality drugs for people to use recreationally at a high price, because once you do that, the average person who wants to just use them and will pay that will go ahead and buy them. And then the people that, and then you sort of take away this like black market winning because you can get good drugs for this. Like, it just makes so much sense. But it will take somebody saying we're wrong, and that's just hard to admit. Anyways, let's continue on, finish this up. And yeah, sometimes you have to make deals so they hold all involved accountable. Also, I think what frustrates people oftentimes is like, you can't really compare apples to orange, like apples to apples for cases, even though you think you can. Even a case that seems very similar isn't, because what the evidence that the state has, what the, who the cops were, all of that actually makes a really, really big difference. And so each case is extremely unique in what the actual likelihood of a conviction is. And so while it's unfortunate to realize, it's not as simple as saying, like, we can never make deals on these types of cases and we can make deals on these ones, because it just isn't easy to apply the law that way. That well. What's interesting in Canada, where I've said it like 15 times tonight, where I'm from, there's something. So in sentencing, when a person is sentenced in Canada, they actually have something called the Gladue factors. That's spelled GLADIEUX. And basically, I'm going to sneeze. Okay, I sneezed. Basically, the Gladue factors are a requirement of the judge to very closely look at factors relating to Indigenous status of an offender, and to basically apply a view of colonization and impact on their life in the way that you sentence people. And the way this came about was after a case where it went all the way up to the Supreme Court of Canada, the Gladue case. I'll look it up. So well, I'll let Judge Manning finish here, and then I'll have a little blurb on it afterwards. But I find it very interesting because it is difficult to know all the different factors when you're sentencing people for crimes. And sometimes it feels like the sentencing part is the one we see the least of. We see a lot of preliminary hearings, a lot of negotiations, but we don't often see as much end result because of things going to plea deals or all that kind of stuff. And so I think that when we've seen somebody and we've watched the case, we sort of have an urge for justice in a way that we wish we could see, but it really doesn't always happen that way. Anyways, let's continue. I'll look for the references there. And I really appreciate all of you, by the way. In case nobody else told you today, I love you. And your butt looks great.
Robbery, aggravated assault with attempt to rob, and possession of a firearm during the commission of a felony. Preach, rah!
Mr. Miller, multi-state, Maryland, Virginia. 2 misdemeanors being simple battery and family violence 2010, battery 2014, 7 arrests for probation violation, schedule 3 in 2013, cocaine 2018, open case 22 CP Nope, those are the ones that's already on here. Or is it? Nope, 206, 537, armed robbery and aggravated assault.
That's number 27.
That's on here, never mind.
Okay.
That's it.
All right, go ahead, Mr. Morrell.
Yes, Your Honor. My client, he's just a couple of days short of being 60 years old, Your Honor. As indicated, he's been in custody for 464 days, Your Honor. His prelim happened on 8/11/2022. And at that time, John Turner, who's a deputy over in the state, said they were going to march his case over to the grand jury to have his case indicted because his prelim revealed that there was some weak information as to his involvement with this with the armed robberies, Your Honor. It is my client vehemently denies being a part of any of these cases, Your Honor. Even to this extent, when I spoke to the victims in these particular case, the victims are associated with corporations that include Walgreens, Hodgepodge, which is the store, and Dollar General, Your Honor. When I asked them if they were opposed to his release, Your Honor, the victims indicated that they were not opposed to his release, Your Honor. All they ask is that a stay away, that he's not allowed to be able to go back to their store, Your Honor. With that being indicated, Your Honor, my client does suffer prior to incarceration, Your Honor. He has been on a journey of trying to maintain a sober living, Your Honor. He has been in many different programs in his history, to include St. Jude's, which is an arm of Salvation Army, Your Honor, and other programs, Your Honor. He is likely to be receive some sort of drug treatment once his case is actually indicted. We've actually talked to Ms. Rewa Collier, who's over drug court, but she said she would entertain drug court options possibility once his case is indicted and another assigned prosecutor, ADA, would be assigned to the case. To that extent, Your Honor, he does have a valid address out of Georgia, Your Honor. Prior to his incarceration, he was staying at a rooming house, so he doesn't have that particular address, but he does have his support system here in Georgia. So if he was released, Your Honor, he will be staying with individuals inside of Fulton County, Your Honor. To that extent, what we're asking for on case number ending in 539, Your Honor, we're asking for the bond for armed robbery to be set at $10,000, the aggravated assault to be set at $5,000, and the possession of the firearm, we're asking for that to be $1,500. On the case that's ending in 241, we're asking for the armed robbery to be set at $10,000, the aggravated assault to be set at $10,000. We're asking for position 3 on that case, which is a misdemeanor. We're asking for that to be set at $3,000, Your Honor. We're also asking that the theft by taking, which is count 5, be converted to a UJR, and the count 6, which is the possession of a firearm, Your Honor, we're asking for that to be set at $2,000. Lastly, on case number ending in 537, we're asking for the armed robbery to be set at $10,000, the aggravated assault to be set at $10,000, and the possession of the firearm, we're asking for it to be split in half at $1,500.
All right, go ahead,
I'm
Mr.
sorry,
Malcolm.
$2,500.
Go ahead, Mr. Malcolm.
Your Honor, given the crime spree and these very serious charges, the state believes that the bonds are right where they ought to be. Thank you.
All right, so case ending in 6539. No drugs unless prescribed, no alcohol, no weapons, no further contact with Elena, ELENA, last name PIKHONAS. Stay away from 2893 Peachtree Drive in Atlanta, Georgia, and all Walgreens stores. Can have ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, place of employment, schedule, and the exact location you're going to be working. Is his address going to be in Fulton County where he's going to live?
Yes, Your Honor, he will be staying with the support system, Your Honor.
All right, 40,000, 40,000, and 4,000. Position number 26, and I've already placed this name in all 3 cases in an email to Ms. Willis. It's no drugs unless prescribed, no alcohol, no weapons. Stay away from 1 Moreland Avenue. That's Hodgepodge in Atlanta, Georgia. No further contact with Crystal, KNAPIK. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, employment, and medical. as long as you supply the name of your employer, proof of employment schedule, and the exact location that you will be working, provided to the ankle monitoring company and to Mr. Morrell. No drugs unless prescribed, no alcohol, no weapons. We got 40, 40, 10, 3, and 4. Position ending in 06537. No drugs unless prescribed, no alcohol, no weapons. No further contact with Terry Stripling, STRIPLLING. Stay away from 807 Cascade Avenue and all Dollar General stores. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, a schedule, and the exact location you're going to be working. 40,000, 40,000, and 4,000. Best of luck to you, sir. You can leave the booth.
Your Honor, if you could just put in the order as a condition, abide by any drug treatment if necessary.
Oh, yes, and apply by any drug program or any program Mr. Morrell gets you into. Is that the only 3 cases he has, or do I need to put another one on there?
No, he only has 3, Your Honor.
All right, thank you. Best of luck to you, sir. Zachary Anderson. Zachary Anderson. What about Lauren Tadamy? All right. Position 10, 22 CP 212668, 228 days without indictment, $82,000 good bond as of February the 7th. Burglary in the first degree, aggravated assault, simple assault, obstructing or hindering persons making emergency 911 call. Pre-trial.
3 prior arrests in here. 1 Louisiana has numerous holds. Marietta, assault, McDonough, FTA of Canton, probation violation, 1 misdemeanor. Currently, PTI probation. Since it's 3/18/22 on schedule, 1 for 3 years, nothing further.
All right. Ms. Eustace, you handling this? Go ahead.
Yes, I'm covering for Ms. Cole today, Your Honor.
Okay.
This client has been in for 228 days without an indictment, and by my count has an $82,000 bond right now. It's been over 3 months since his last bond reduction. I believe it was around the time in January when he had his prelim. 25 years old and born and raised in Georgia. His father and his sister support him. He has lots of family here as well. He does have his address on intake, which is the correct address where he'll be living at with his father. Or he will also be able to live at his sister's address in Lithonia. We can update the address once he's released and we see exactly which one of those is a better fit for him with his employment. He studied for 3 years at Southern University and was working on his business administration degree. His father owns 2 businesses and the client will actually be able to work with him there. And it has been confirmed with his father that he will have employment with him. There's 2 holds. One is a probation violation. And we would be asking at this time for $5,000 on each felony and UJR on the misdemeanors.
All right. Mr. Malkin, go ahead. Oh, you're on mute, Mr. Malkin.
I'm sorry.
Okay.
The state would request a $20,000 bond for him with an ankle monitor.
All right, so let's see. So that's 9,000, 9,000, 1,000, and 1,000. 9,000, 9,000, 1,000, 1,000. No drugs unless prescribed, no alcohol, no weapons. No further contact with Robert Fick, F-I-C-K, or Hayden, H-A-Y-D-E-N, Rucker, R-U-C-K-E-R. Stay away from 465 Robinson Avenue, Southeast. No drugs unless prescribed, no alcohol, no weapons. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, placement, employment schedule, and the exact location you're going to be working. Supply an address where you're going to be living. Neither are in Fulton County, so stay out of Fulton County unless you're here for court or to see your lawyer. 9,000, 9,000, 1,000, 1,000. Best of luck to you, sir. You can leave the booth.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am.
Thank
you.
What
Ms. Tracy?
What case were we on?
That was Lauren Tademy, T-A-D-E-M-Y, position 10.
Okay. Can I get a bond fee?
9911.
Okay, thank you.
All right, sure. Zachary Anderson. I'm not real sure.
Excuse me, Judge. I just talked with the Tower deputy on 7th South, and he's indicated that Zachary Anderson got tired of waiting. He was previously in the booth and does not want to participate.
Okay, well, I'm sorry to keep him tied up. Mr. Cho, your client is tired of waiting.
Oh, Judge, he has a UJR on this case. Anyways, Miss Fiacco worked very hard, got him into
I don't know what. Well, I don't see it. When was it changed to a UJR? Did you get changed?
There was an order for a pad
Oh, yeah, and I didn't know why he wasn't gone, but.
Oh, there was extenuating circumstances. I'd rather not be more detailed unless the court asks.
No, I got you. I'm not sure what to do if he's tired of waiting, so.
Do you want me to reset it for another date?
Mr. Cho?
That's fine. There's some other pending issues that are gonna have to be addressed anyways, it appears, so.
So how far out you want me to reset the case?
2 weeks. Did he have first appearance? Ms. Robbins, sorry, that wasn't at you. A week or two at your convenience.
Okay, I'll reset the case to another calendar.
Okay, thank you so much.
All right, so I'm not sure who this is in 3 North Booth 3. Because I'm on a lot of pieces of paper.
Is it possibly Kenterio Shields? Because that case is finished too.
It appears to be Antonio Butler. It appears to be according to my sheet.
Are you Antonio Butler?
Hey, Mr. Butler.
Is that who it is?
I tried to go see you today. Well, if he's here and he wants to participate.
I don't know. Is that what okay, hold on. What was up with Antonio Butler's case? Is that who that is? I don't know who it is.
Yes, Your Honor. He is the one that I mentioned to you at the beginning of the calendar. I had tried to go see him at the jail, and based on my conversation with the deputy, I was unsure if he was going to come to court today, but I mean, he's here.
All right. Let me see. So that is position 18, Bostic. It's 20 CP 191315, Antonio Butler. It's total of, we figured out earlier, 173 days without indictment. However, he was here 354 before, so it's a total of 527 days without indictment. $2,000 good bond as of November the 21st for criminal attempt to commit arson in the first degree and terroristic threats. $2,000 total. Pre-trial.
Just the 2 arrests.
All right, go ahead, Ms. Correa.
Thank you, Your Honor. So the bulk of my argument is in reference to the fact that the incident is now over 3 years old. This is stemming from something that happened on April the 4th, or no, April the 4th. April's the 4th month. On April the 20th in the year 2020. As I previously informed the court, he spent 354 days in custody, was allowed to leave. Since then, Mr. Butler had to handle a separate legal matter in Tennessee. At that juncture, Deputy District Attorney Faye Rosenbaum did file an extradition order for Mr. Butler to come to Fulton County, which is how he came back here and has now waited an additional 173 days for indictment. At this time, Your Honor, I'm not sure what the holdup is on this case, especially given that's, a preliminary hearing happened back on December 2nd, 2020. So at this point, Your Honor, I would ask for you to reduce this bond even further, and I would ask Deputy Attorney Malkin if he could, take a look at this case, given how far removed we are, and the financial implications of having extradited Mr. Butler and then not indict him for 173 days. Thank you.
All right, Mr. Malkin.
Well, there is not much room to reduce it further. It's apparently at $2,000 now, and I guess it can be lowered to $1,500, and with the usual conditions. Ms. Correa Jameson, you may want to contact Kenneth Hutcherson if you've not already reached out to him. He is over the entire case intake division, and maybe he could get things moving for your client.
He likes to not read my emails, so.
Oh, sorry.
I put it on the email to Miss Willis, and
thank you, Judge.
I'll put it on there. Okay, so we'll do no drugs unless prescribed, no alcohol, no weapons. Stay away from 1723 Lakewood Avenue Southwest. Stay away from all Family Dollar. And he doesn't have an address where he'll be living.
Not at this time, just due to the length of his incarcerations.
All right, so just must provide an address where he'll be living. So we'll do about 750 per count.
Sounds good, Judge.
All right. Best of luck to you, sir. $750 per count, okay? Thank you, sir. Anything else we need to take up? I don't think so.
Judge, I believe that there was a Joe London on the calendar.
Been indicted. Was indicted today.
Convenient. Thanks.
Yeah, that is convenient, isn't it, Judge? Just conveniently indicted on the day that I was supposed to be there. Anyways, guys, we're not done. Don't worry. We're not done at all because we go late here. What I am grabbing right now is the next clip that we're going to watch, which is thanks to our lovely friend. That is the way I see it, who is always lurking in the chat, which we love to see and enjoy immensely. Oh, that's not the right email, but this is right here. Give me one moment.
No, I don't have nothing with her, so
Pause, Judge Middleton, we need you. And then we're gonna try out our new judge that we have today, okay? And like I said, she's new. We're gonna have to see how she does. If she doesn't make the cut, she doesn't make the cut. That's just the way it goes, all right? Let us see how to make that bigger. Once again, if somebody, one of the mods, could drop the link in the chat for That Is the Way I See It, please. That is a channel you must subscribe to. A great friend of my channel.
all ties. With her? No, I don't have nothing with her, so I cut, all ties because the relationship was toxic. Well, that you're in large part responsible for that. Yes, sir. And as Debbie said, I've known you since I knew you before you had any ink. I'm in the process of getting them removed off my face. I'm not a big fan. I don't have an opinion one way about tattoos, but I'm not a fan of face tattoos. It says, I'm a criminal, don't hire me for a job. Absolutely. It's everybody's way of giving the finger to regular society. So it's your choice, but everywhere you go, that's the way you present. Now, with her? No, I don't have nothing with her, so I cut, all ties because the relationship was toxic. Well, that you're in large part responsible for that. Yes, sir. And as Debbie said, I've known you since I knew you before you had any ink. I'm in the process of getting them removed off my face. I'm not a big fan. I don't have an opinion one way about tattoos, but I'm not a fan of face tattoos. It says, I'm a criminal, don't hire me for a job. Absolutely. It's everybody's way of giving the finger to regular society. So it's your choice, but everywhere you go, that's the way you present. Now, with her? No, I don't have nothing with her, so I cut, all ties because the relationship was toxic. Well, that you're in large part responsible for that. Yes, sir.
Okay, it is replaying. I'm going crazy. I was like, wait, I've heard this part before. Judge Middleton doesn't usually ramble like this. It's just a shorter clip. I understand now. Thank you so much. I really appreciate all clips, and I am intrigued as to how you did that. give me one moment, folks. Well, we are going to check out a new judge together, and we're going to rank her using the extremely unofficial KCC kitchen ranking system. I have to agree a little bit with Judge Middleton about face tattoos. I have a method for dealing with kids that want to get tattoos, and this is free for anybody to use in their life. But the first factor is don't get pissed off about it. What you do is you go ahead and say, that's a great idea. I'll even pay for it to get designed. And then you get it designed, and then you go ahead and you're going to get like 1,000 tattoos made, the temporary ones, in the exact design that they want to get. And then you're going to wear that on wherever you want, all over. Get everybody in your entire life to be wearing this tattoo. And I'm pretty sure that they will be less interested for some weird reason in getting the tattoo. That's what I've heard. That's what I think. Anyways, let us go. We are going, maybe she's not new to some of you, but to me, I think she's new at the moment. Ma'am, I'm not ready for you yet. You need to wait, please, until everybody has made sure to hit the like and subscribe button, and I can introduce you properly. This is the Judge Shackelford. Judge Shackelford. And Judge Shackelford has quite the setup here. So let's get started. We're going to probably zip through parts of it because I think there's some dead time, but we'll see how we do. As always, thank you for being here. Let's learn together.
Please state your name.
Durham Ahmedi.
What type of case are you here for today, sir?
It has to do with ordinance, like for a rental property, the inspection, but the inspection just went out. They did the inspection last week.
Do you have a case number?
Yes. Let me see where 231 59126.
Dang, this judge has got billable hours on this call. She's just like, oh yeah, I was on stream all day. I was just such a hard day. Half of it is nothing. It says it's Taylor Court, the Honorable Victoria Shackelford. Come on, Victoria. Hurry up, please.
Okay. This is the People versus David Discanio.
Yes.
Does he have information?
Scott Smith on behalf of Mr. Discanio, and Mr. Discanio is present in court. To my right.
Can you tell me your name, sir?
David Discanio.
All right, thank you. So did you go over the Regional Treatment Court Program information with your client?
Yes, I received it online, Your Honor, and so I did go over that with him. I made him a copy of it.
It's gonna be a lot of work. Right? Okay. These are gonna be your bond conditions, sir. no alcohol or drugs. You're gonna randomly test on Navy. You're gonna have a scram tether for 90 days, followed by random PBT testing on Fuchsia. You're gonna attend 12-step meetings or some other meeting that's approved by the probation department 3 times a week, or as directed by probation. You're gonna enroll and complete treatment as directed. You'll report to probation. Yeah, we'll get you a copy of this. It's impossible to write this all
Yeah,
down.
it is.
Okay, yeah, it's too much. And sir, you're gonna go over this in more detail with Ms. Havner, so I don't expect everyone's gonna memorize this. All right. You're gonna meet with the probation department weekly. You're gonna report to drug status hearings as directed. Do we know which one he's coming to?
No, I'm gonna have the binders in front of them following this. I will establish it.
Okay, great. No driving unless you have a valid license. You can't enter areas known for drug use. You can't hang out with drug using peers. You cannot enter establishments where the primary purpose of the business is the sale or service of alcohol, no bars or liquor stores. You will get a temporary sponsor within 30 days and a permanent sponsor within 60. So you're going to get a consultation for Vivitrol, and you'll attend alumni and families against narcotics meetings. That's once a month while you're in orientation in phase 1. And are you going over this today with him? Or?
Yes, Judge, I have house arrest services here already, so you'll have a screen put up following this, and then I will meet with him and give him all the referrals and go over overall paperwork with him.
You want a copy of this just for your file, sir?
Yes, I do.
All right. Can you please make him a copy real quick? That's my copy. So
Okay.
He'll make you one.
All right, great.
All right, and welcome to the program. Is Monday the crazy day?
Yes, I was gonna try to
Do Thursday.
do Thursday at 3 or Friday at 8 a.m.
Okay, great.
Thank you.
We're all set.
Okay.
I'll see you soon, sir.
Thank you, Judge. Does he follow you down?
Yeah.
Okay. I'm gonna talk with him, just make sure he gets down there.
Is that Klein sworn in already?
Okay, I'm not necessarily feeling this, Judge. Oh, but that I remember.
Detective Mario Hinojosa, Taylor PD.
I did see part that I thought was good, so let's see if it picks up here.
We're muted. All right, this is the state of Michigan versus Arion Gage Marzell Klein. Officer, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record?
Detective Mario Hinojosa, Taylor PD.
And have you read the type complaint that was filed with the court?
Yes.
Is it true and accurate to the best of your knowledge and belief?
Yes.
Can you state the facts that support the issuance of the arrest warrant?
On May 9th, 2023, Miss Elsie Davis made a report to the Taylor Police front desk. She stated that her great-grandchildren, Arion Klein Jr., who was 3 months old, Autumn Klein, 3 years old, and Austin Klein, 6 years old, She babysits frequently, and the night prior on May 8th, 2023, the children were dropped off at her house to watch overnight. In the morning, the next morning on May 9th, at approximately 1100 hours, she was feeding Arian Jr., the 3-month-old. While feeding him, she observed a bruise that appeared to be red and swollen on the left side of his face near his ear. She then asked the other 2 children, Autumn and Austin, what had happened, and they claimed that their father, Mr. Arian Klein, had punched Arian Jr. in the face at their house on 15810 Beach Daily Road, trailer 366, the night prior, before they got dropped off at their great-grandmother's house. And then right after he struck Mr. Arian Jr., he then slapped Autumn and Austin one time in the face. Prior to that, there was a kids talk conducted yesterday as well, where they stated the same thing in the order of events, that Mr. Arian Klein did both of Autumn and Austin, as well as striking Arian Jr. in the face the night prior on May 8th.
Okay. Did you sign the complaint before you sent it over to the court?
Yes.
All right, let the record indicate that I find probable cause to believe that the accused committed the alleged offense and will therefore issue the warrant. Anything as to bond?
It's difficult. I know we have emergency placement for the children. CPS is in the works right now so that they can stay with the great-grandmother, with the mother being hospitalized at a mental institution as of right now. But probably just no contact with the kids.
Okay.
And then whatever the court recommends.
All right, thanks for logging in, Sergeant Detective. We're all set.
I'm sorry, Judge, Jeff Fanto for the record. Are the children at the grandmother's now?
Yes, they are. They are.
Okay. And I just, in terms of bond, in terms of whether he could go back to the home, that's why I was asking that question.
And it sounds like there's some intent for the kids to stay there and that CPS is working that out.
Yes, they have the safety plan. Ms. Davis, as of right now.
All right, thanks, Detective.
No problem. Have a good afternoon.
All right, we're ready, officer.
All right. We're gonna have Ms. Duval go first. Just don't touch the speaker, man.
Ma'am, can you hear me? Yeah. All right, this is the state of Michigan versus Ashley Lynn McDougal.
Good afternoon, Your Honor. Jeffrey Fant on behalf of Ms. McDougal. And for the limited purposes of arraignment, we'd waive formal reading and stand mute.
Are not guilty plea on her behalf. I should also indicate that I've signed the ex parte order preserving evidence.
Thank you.
I've signed the request for a court-appointed attorney. Ma'am, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to have a lawyer present during any future questioning and any future court hearings. If you cannot afford an attorney, the court will appoint one for you. You have 2 dates within the next 21 days. You have a probable cause conference 7 to 14 days from today's date that is currently set for, where are we? 11, for May 22nd of 2023. The next hearing is 5 to 7 days following that, and that will be a preliminary exam. At the exam, the prosecutor must prove that a crime was committed and probable cause exists to charge you with that crime. And that is currently set for May 31st of 2023, and that hearing will be in person at the 23rd District Court. As to bond,
Judge, obviously the allegations are serious. She has no history, no holds. And she lives with her brother in Allen Park.
yeah, this is a difficult case. These are very serious allegations, and it's my understanding that they may be getting worse. Right now, it is as we sit here at this moment, it's a 5-year felony. I recognize that she has no prior criminal history. I don't see anything indicating necessarily that she is a flight risk based on her lack of criminal history and lack of traffic history even. But I am concerned because of the seriousness of the charges. Ma'am, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crime while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with the family of David, Allen, Horizon. You're not to purchase or consume alcohol or illegal drugs. You cannot operate a motor vehicle without a valid license. Mr. Fango, can you approach this?
Zone B, Terror Police 1.
What is she thinking right now? Damn. I am number one. I wish the judge could see it. Why don't they understand me? Nobody does. They never do.
Copy, Mark.
All right, ma'am. For now, you're going to have a $25,000 cash or surety bond with a GPS tether and a scram tether. And that's my ruling. And you'll be back, and your attorney at your exam date can ask me to reevaluate bond after.
Damn. I was really hoping she was going to say, and that is the way I see it. But she didn't.
For the facts of the case.
Thank you, Your Honor.
Thank you.
Hang tight, I'll answer questions once I'm done with this. Copy 1. Step up here, sir.
Who was this?
Mr. Harrelson.
Harrelson?
Yep.
I'm sorry to interrupt. That is not Mr. Harrelson that I know.
Sir, can you hear me okay?
Yes, I can.
All right, this is the state of Michigan versus City of Taylor versus Darnell Harrelson.
Good afternoon, Your Honor. Jeffrey Fant on behalf of Mr. Harrelson. We'd waive formal reading, stand mute. Based upon a memorandum of understanding between House Counsel and the city prosecutors, Mr. Harrelson is going to plead guilty to the amended charges of a charge of failure to display a valid operator's license. Original charge would be dismissed. We request 30 days to pay. He has no history, and he has a civil infraction hold out of the 33rd.
Sir, do you understand everything your attorney just said?
Yes.
All right, and you understand that that reduction of failure to display is still a misdemeanor punishable by up to 90 days in jail and a fine of $100 plus court costs and statutory fees? I have to tell you the maximum, sir, by law. On a failure to display, it's up to 90 days plus a fine of a fine of 100 plus court costs and statutory fees. Do you understand that?
Yes.
Okay. And did you go over your constitutional rights with your attorney?
Yes.
And I'm holding up this advice of rights, sir. Did you understand the rights that you went over with your attorney?
Yes.
And did you give your attorney permission to sign your name on that advice of rights form?
Yes.
All right, Mr. Harrelson, you understand if you enter a plea guilty to the reduced charge that you'll be waiving the trial rights outlined on this form?
Say that one more time.
Sorry, I know I'm a fast talker. I'll talk louder though. You understand that if you enter a plea of guilty to the reduced count, that you're going to be waiving the rights on this form. There will be no trial of any kind if you plead guilty.
Yes. Okay.
All right. Has anyone forced you to get you to plea?
No.
Has anyone promised you anything other than the plea reduction to get you to plea?
No.
Are you pleading guilty for your own free will?
Yes.
You understand, sir, that if you're on probation or parole and you enter a plea of guilty, that it could be a violation of those conditions?
Yes.
Knowing all of that, to the charge of failure to display, how do you plead, sir?
Guilty.
All right, were you operating a motor vehicle in the city of Taylor on April 2nd, 2021?
Yes.
And while you were operating that motor vehicle, sir, was your license either suspended, revoked, or denied?
Suspended.
Okay. And did law enforcement, a police officer, ask you to see a valid license?
Yes.
And did you fail to display it?
Yes. At the time I didn't know my license was suspended.
Okay. Mr. Fanto, satisfied?
I am, Judge.
All right, I'm going to accept the plea as knowing and voluntarily given. Mr. Harrelson, that's going to be a $100 fine, $100 court cost, a state assessment of $50, and a crime victims' rights fee of $75. Those last two are mandated by the state of Michigan. That'll bring your total, sir, to $325. And I'm giving you a payment for, you want 30 days to pay?
Yes, please.
Yeah, Mr. Harrelson, if you cannot pay it off in the 30 days, just call the court and we will grant you more time. And that way you don't end up racking up more costs or a bench warrant, okay?
Okay.
All right, you're all set, sir.
Thank you, Judge.
Yep.
Next, we got Mr. McGoo.
Okay. Hello. This is the people versus Daniel McGoo.
Good afternoon, Your Honor. Jeffrey Fant on behalf of Mr. Magoo. For limited purposes of arraignment, we'd waive formal reading and stand mute.
All right, sir, can you hear me okay?
Great. Good morning, Your Honor. Good afternoon, Your Honor.
All right, good afternoon. All right, so I'm gonna enter a not guilty plea on your client's behalf. Sir, did you go over your constitutional rights outlined in this advice of rights form with your attorney?
I did.
Did you understand those rights?
I did.
And did you give your attorney permission to sign your name on this?
I did.
Okay. You have a right to remain silent. Anything you say orally or in writing can and will be used against you. You have a right to have a lawyer present during any future questioning in any future court hearings. If you cannot afford an attorney, the court will appoint one for you. And I have signed the request for a court-appointed attorney. You have 2 dates within the next 21 days. The first is your probable cause conference. That is currently set for May 22nd of 2023. Your next court date will be your preliminary exam, which is to occur 5 to 7 days after that probable cause conference. At that exam, the prosecutor must prove that a crime was committed and probable cause exists to charge you with that crime. And that is set for an in-person exam at the 23rd District Court on May 31st of 2023. As to bond.
Yeah, good to see you.
All right, Mr. Esteban.
Esteban, Judge, his last, the felony that the habitual two is involved is from 2016. He has no holds. And he is currently employed. The alleged victim in this matter does not reside with him at the Fellrath address. She lives in Lansing. And I have explained to him the necessity of not having any contact with her in any fashion. He's aware of that, fully understands that, and is prepared to certainly abide by that. I would ask for a personal bond in this matter.
You're a hothead, sir.
What was that?
You're a hothead, I said. Don't say anything back. Miss Mullen.
Man, I wish I hadn't messed up. I'm number 11. It sucks. What comes after 11? I can't remember.
Okay. Is your client employed?
He is, Judge.
It's a 10-year felony. I understand he doesn't have any holds, but I do see a pattern in his criminal history that's very concerning to me.
I would note if the court is referring to the a recent matter in Washington County that was dismissed, client advises that was dismissed for a very good reason and that the allegations were not True.
What about the 3 or 4 other dismissals for the exact same type of thing? I mean, that's the thing, it's not his criminal history. I mean, I see some that I really can't count, and then I see a bunch that I'm not supposed to count, but I'm also not blind. And I recognize that there's certainly a pattern of behavior here that's alarming.
Your Honor, ma'am.
Sir, anything you say can and will be used against you. Your attorney's indicated it's not in your best interest to speak.
Okay. We're going to need to just re-rack that because there's some weird undertone of breathing or laughter that's happening that I think is the person holding the iPad. Okay, here we go. I have to. You guys, I want you to listen very carefully. Just listen. It's minute. I think it starts right about here.
I see some that I really can't count, and then I see a bunch that I'm not supposed to count, but I'm also not blind. And I recognize that there's certainly a pattern of behavior here that's alarming.
Your Honor, ma'am.
Sir, anything you say can and will be used against you. Your attorney's indicated it's not in your best interest to speak.
Prayers do not go through glass, dude.
By what I see.
That is prayer.
History. You can have a $20,000 10% bond with a GPS tether. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no.
Oh my God. I thought what's happening? I was like, did he just leave the like dimension or something? But more real, like I really was hoping the judge was gonna see him just gone. But she's turned back. It looks like he's getting right back up at the right time. But this is hilarious.
Contact with Brooklyn Ostrander, and I want to be super clear on this. I want to be so clear that you cannot be confused, sir. You cannot call her, write her, or email her. You can't send her anything. You can't go to where she lives or works. You cannot have any contact of any kind. You cannot have someone else do any of these things for you either, except your attorney. You cannot send a text message, instant message, email, tweet, or any other form of communication, or contact her through a listserv, Facebook, Twitter, or any other social networking site. You should not inquire or comment about her on social media. If you have her programmed in your cell phone or electronic device or computer as a buddy or a friend on any social networking site, you need to delete her name and contact information. Sending her a blank or empty message is considered to be contact, since I am instructing you to make it so that cannot happen. If the communication comes from you, the court will consider it contact. It will not be a defense that you accidentally contacted her. If you go to a store or restaurant or party, for example, and she is there, you must leave immediately. If she contacts you, do not reply. This is an order of the court. The person named as the victim in this case cannot change, alter, or amend this order in any way. She can't change it. Only a judge can. If she were to invite you over or ask you to meet her somewhere or contact you for any reason, you cannot violate the no contact order. If you do, you will go to jail. If the order needs to be changed in the future, I will hold a hearing where both sides are present. Do you understand?
I understand fully, Your Honor. I'm really sorry about that.
Well, don't tell me that. I just want to make sure you understand. All right, then we're all set, sir. We'll see you back here on the 22nd of May.
Thank you, Judge.
All right, thank you.
Hang on, man.
Okay. I have been tested my hearing, my ears, and I have exceptional hearing. Like the audiologist who did my test, I have a chart somewhere, I'll pull it up. But I have very, very good hearing. And so sometimes I hear things that I don't think everybody can hear, but I don't think we could hear him laughing like that, but not clearly talking or moving around. And so to me, I feel like the laughter was coming from close to the iPad and not through the door. And then the other thing that just came to mind, there's absolutely no evidence, but the type of laughter it reminded me of and his face, it was like maybe they knew the guy that was arrested and it's a small town and he's got a real bad thing, you know, for some reason the judge knows him or whatever, but by sight only. And so he switched spots with his buddy who was behind the glass there. And so he's like, laughing, watching him pretend to be him and get in trouble for him. That's what I sort of imagined. Anyways. We are pretty much done with her. I'm sorry. Her voice is piercing, but I don't know that I'm that into it. What did I say we were doing next? Somebody's got to remind me because I thought I had something to look at. Let me just put something up on the screen for you guys so that you are not bored here. Just one moment, please. I actually really liked her explanation though of what not to do. She was really clear. Like delete her out of your phone. I love that instruction. That should be Wordle, you're right, hon. That is exactly right. Cachette, thank you very much. And what was the other what we're gonna do actually is no, we're not watching Cocaine Bear. Yeah, I'm putting it on in just a moment. What I need though that my brain isn't working today. We're gonna watch this video together. Well, actually, I think yeah, we're gonna watch this one. I want to watch it again. I'm gonna. It's just how we do. Okay. That can start. This guy does a really good explanation of how to get out of jail as well. So for people wondering about like, how do I get out of jail? Like what are these people talking about? This is a really good explanation of this. So this is a video I posted earlier. We're going to go through 4 cases, in fact, very quickly from varying degrees of severity. And we are going to also be playing some Wordle here as I set it up. So just give me one momento as me and Larry Beaver get things handling in the background. I will get this playing. I'm pretty proud of this video because I really liked it, but let me know what you guys think.
Your rights and your options on how to get out of jail. Now, you're all charged with some type of a criminal offense based on the sworn statement of a law enforcement officer. That officer is swearing to enough facts that would lead a reasonable person to believe that you committed a criminal offense. That does not mean you've been found guilty. You're presumed innocent unless proven guilty. You'll have an opportunity to talk to a lawyer before making any decisions about how to handle your case. If you want a copy of the statement of the police officer that's being used as the basis for your charges, you can get that from your attorney or the clerk's office in the next few days. Now, You're all entitled to certain rights under the Constitution in any criminal case. I'm gonna go over your rights, then we'll talk about your options on how to get out of jail. And then I'm gonna call you each one by one and talk to you each about your individual situation. At that point, if you have any questions, go ahead and ask me and I'll do my best to answer your questions, okay? In any criminal case, you have the right to remain silent. You don't have to make any statements about your case. If you give up your right to remain silent, whatever you say can be used against you. You have the right to hire a lawyer to represent you. If you don't have the money to hire your own attorney, you can request a court-appointed lawyer. If the police or the prosecutor want to talk to you about the facts of your case, you don't have to talk to them about it if you don't want to. If you choose to talk to them, you can end the interview at any time, and you have the right to have a lawyer present during any discussion with the police or prosecutors about your case. You also have a right to a reasonable amount of time to talk with your lawyer before making any decisions about your case. If you're charged with a felony, you have the right to request an examining trial. That's not a full-blown trial. That's a preliminary hearing to argue that there's no probable cause, no reasonable basis to charge you with a crime. You could talk with your lawyer about whether that option makes sense in your case. If you're not a U.S. citizen, you need to be aware that a conviction of a criminal offense can affect your immigration status. And lastly, if you're not from the United States, you do have the right to request that we contact the embassy of your home country and let them know that you're here. Is there anybody here who's not from the United States and you want us to contact your home embassy? Anybody? No? All right. I know you all want to get out of jail. If you're able to get out of jail, you need to make sure you show up for all your court dates. If you don't, you'll be rearrested and be a lot more difficult for you to get out of jail once you're back here. So if you're able to get out of jail, don't throw away your paperwork. Pay attention to when you need to be at court. There are 4 ways to get out of jail. First way is to qualify for a personal bond. If you were to qualify for a personal bond, you'd be released for free based on your promise to come to all your court dates. Now, personal bonds are offered in instances where the case is not too serious and where we have a reasonable certainty that you'll come to court when you're supposed to and that you won't be a danger to others or society if we let you out of jail while your case is pending. So we'll look at the facts of your case, your criminal record, your references, your history of coming to court in the past. And when I call your name, I'll let you know where you stand on the personal bond. If you qualify, you'll be released in the next few hours. If you don't qualify, you have 3 other ways to get out of jail. Those 3 ways are you can hire a bail bondsman, you can hire a lawyer, or you can have someone come down to the jail with the full amount of the bond in cash. Now, if you a bail bondsman or a lawyer, it's between you and them how much they charge and what they can do for you. I can tell you that in Travis County, most bail bond companies tend to charge around 10% of the bond amount as their fee to get you out. So for example, if your bond amount's $5,000, bail bondsmen often charge you around $500 or more as their fee to get you out. Likewise, you can go through a lawyer. An attorney can come down here and try to convince me or one of the other judges to give you a personal bond that you weren't able to get on your own. A lawyer can advocate on your behalf based on the unique facts of your case and your situation and try to get you a personal bond. If you don't have the money to hire your own attorney, you can request a court-appointed attorney, and your court-appointed attorney can do the same thing and try to get you out of jail. Last way to get out is to pay the full amount of the bond in cash. If someone comes down to the jail with the full amount of the bond, not 10%, but the full amount in cash, cashier's check, or money order, then you'll be released. And as long as you come to all your court dates at the end of your case, you'll get your money back. Whereas if you go through a lawyer or a bail bondsman, whatever money you pay them, you generally won't get back. That's their fee to get you out of jail. So those are your 4 ways to get out. Qualify for a personal bond, hire a bail bondsman, hire a lawyer, pay the full cash bond. Regardless of which way you use, make sure you come to all your court dates or you will be rearrested. I'm going to call your names. I'm going to tell you what you're charged with and your bond amount. Then I'm going to ask you whether you want a court-appointed attorney or whether you want to hire your own lawyer. If you have any questions at that point, go ahead and ask me, and I'll do my best to answer your questions. If you want to know the punishment range of the charge that you're facing, just ask me and I'll tell you. All right? All right. Mardalena Adriana Gonzalez. Which one is Miss Gonzalez? Okay, Miss Gonzalez. Hold on, let me just read something real quick. Yeah. All right, Miss Gonzalez, do you have friends or family that can help bond you out? Speak up.
Probably not, I don't know why.
Probably not. All right, you're charged with a second-degree felony, fraudulent use or possession of identifying information. It's a second-degree felony for possession of a bunch of credit cards of other people. You're also charged with a state jail felony, burglary of a building, and a state jail felony, possession of controlled substance. And you said you don't have friends or family that can help bond you out, is that correct?
No.
And you're not working or anything?
No.
All right. Ms. Gonzalez, your bond amount on the second-degree felony is $7,500. The fraudulent use or possession of identifying information. Your bond amount on the burglary of a building charge is $5,000. Your bond amount on the possession of controlled substance charge is $1,000. Total amount of your bonds on 3 felonies is $13,500. Bail bond company will often charge around 10%, which will be around $1,300. You'll have an opportunity to use the phone to get a hold of your friends or family to try to bond out. You can also talk to your court-appointed attorney if you request one and see what they can do to help bond you out. They can come talk to me or one of the other judges about trying to get you out on a personal bond. I can tell you that based upon the facts of the case that I've read and all that, I'm not comfortable doing a personal bond at this point.
They're not facts, I didn't do anything. If driving is illegal, then that's.
I don't want you to talk about the facts of your case. I don't want you to talk about the facts of your case, but you can talk to your lawyer about your side of the story. Do you want a court-appointed attorney or do you want to hire your own lawyer?
Sure, court is fine.
Do you have any questions?
No.
Good luck. Daphne Lys or Lice? L-Y-S, Daphne? Who's Daphne? Raise your hand. Okay. My screen is freezing, and so sometimes I can't tell if you're responding. All right. How do you pronounce your last name?
Lise.
Lise. Okay. Miss Lise, you are charged with a Class B misdemeanor criminal trespass. Now, I don't show that you've been arrested before. Is that correct?
What happened?
All right, have you been? Is this your first time in trouble?
Yeah.
Is your first time?
Yeah.
You've never been in jail before? All right. Because, we ran a criminal record and didn't see anything. Where do you live right now? Do you live at the B Caves Road Street address?
Yeah.
Who do you live with?
I live around that area with family, with friends, pretty much.
All right. Well, you refused to interview for the personal bond. Why is that?
Because I pretty much I don't think I've been wrongly arrested because they found me on campus, which is the first time.
I don't want you to get it. Here's the thing. I don't want to talk about the facts of the case because that you need to discuss with your lawyer, and whatever you say can be used against you, and this is a recorded proceeding. So I don't want to get into the facts of the case, but what I'm asking is, I'm willing to consider a personal bond and let you out of jail for free, but you didn't interview. Why not?
No, I don't really, because it's pointless. And I think this is pretty much a way of the system to keep people inside the system in a cycle. And I don't want to be, there's a reason why I'm not in jail. I've never committed any crimes.
I think you are a little confused. You are in jail. He's offering to let you out without having to get into the quote unquote system that you're talking about. Oh dear. I certainly hope that let's just see what happens here. This is not a case of the judge trying to trick her, which is what I think she thinks is going on. The judge is literally trying to help her. He's like, you've never been in trouble before. I would let you go, but you've refused to speak with the intake officer. And now she says, yeah, because I don't want to be in your system. Well, sweetie, look at your outfit. You're already in the system.
I'm not in this system. I've been in this country for over 20 years. I live in New York, I live in California, and I've been gang stalked by a group of police officers, state troopers, because that I don't have a record, and they found out that I don't have a record. Now they are doing things that they are, whatever they can to put me. I don't want to go in a cycle. I don't want to be in anything with bonds. I just want to speak to an attorney and get out of here by myself because I did not commit a crime.
Okay, well, here's the thing, Miss Lee. I'm actually trying to get you out of the system.
How could you go to a campus that you're applying to? I am already in the system. My fingerprints is in the system. My pictures is in the system. There is a reason why I'm not in going into that cycle because my brother went to the same cycle and his life turned out to be the worst.
I get it.
Yeah.
I would like to let you out of jail so that you can show up for court on your own based on your promise to come to court and just deal with your lawyer on the outside. But I'll do a personal bond if you're willing to interview with him. But if
that's going to be what is a personal? I don't even know any of these. What is a personal?
Okay, so here's the deal. You got basically two choices here. All right. You can stay in jail and you'll get brought to court in a couple of days and your court-appointed lawyer will reach out to you in a couple of days and then you go to court and see if you could work the case out. Or I can let you out of jail in the next couple of hours based on your promise to just show up for court when you're supposed to and you talk to your lawyer in the meantime. So would you like to get out in the meantime or do you want to stay in jail for a couple of days? I'm willing to let you out.
What is the promise for me to show up to court? I mean, if I have court day, I'm going to show up to court day. So what is this whole thing? Are you going to lend me money? What?
So your bond, I'm setting your bond at $100. However, I'm willing to do a personal bond, which means you wouldn't have to pay the $100. As long as you show up for court, you wouldn't have to pay any money. So I would let you out. Now, if you didn't show up for court, then technically the county can sue you for $100. Okay, so just show up for court and you will never have to pay the bond amount. Do you want to do that?
Yeah.
You want to do that? Okay, I'm going to have the pretrial services office come interview you. Just sign the paperwork, and I'm going to let you out of jail. And besides showing, and your first court date's going to be written on your paperwork. It'll be in the next couple of weeks, and the only one condition you need to comply with is that you can't go on University of Texas property while the case is pending. Okay?
And the reason that I went to the university is because that when I received whatever they warning, I emailed the police department. They never replied back, and I had to fill by the application for school. I had to speak to people in the school, so I went to the school, and they ended up.
Let me stop you there. Let me stop you there. I can't talk to you about the facts of your case. What you're sharing with me is definitely something you should talk to your lawyer about. I'm simply concerned that you just make sure you show up for court. And right now there is an active criminal trespass warning on University of Texas property. So if you go back there, you're going to get rearrested. And then you end up seeing me again, and neither one of us wants that. So what I'm saying is, I'm going to let you out on a personal bond. Make sure you talk to your lawyer and try to resolve the case. You can still call the University of Texas, but you're not allowed to go on University of Texas property at this point unless you're escorted to a police officer. So I want to make sure.
On the 31st, I have to return. Yeah, on the 31st, I have to return some work from my application, and I have to drop it off. So do I go to the police department and give it to them to drop it off?
You could do that, or you can mail it. You can do that, or you can mail it, or you can call and ask for permission Well, what I'm saying is right now there's an active criminal trespass warning, and so if you go on UT property, then you can be arrested. And so, and that's whether this case is pending or not. That you have that active criminal trespass warning. Normally, criminal trespass warnings last for a year. Now, you can discuss that with the University of Texas, and if you want to try to get them to withdraw the warning, they have the discretion to do that.
Okay.
Okay. All right.
Yeah.
Do you want a court-appointed attorney to help you out?
For now, yes.
Okay.
I want to be an attorney for the court.
All right. I'm gonna have I'm gonna have the personal bond people come to your cell and interview you, and you'll just need to sign the paperwork promising you coming to court. Doesn't mean you're admitting guilt to anything. You're just promising that if I let you out of jail today, you'll show up for your court dates, okay? All right. All right, good luck.
Thank you.
Man, he saved her there. He really talked her around. I thought that was really well done. Good job, Judge. What the heck is going on down in Travis County? Let's watch the rest of this.
All right, Falana York. It'll be a little bit. All right,
Good morning.
about 10 minutes. All right, Miss York, you are charged with a third-degree felony intoxication assault for allegedly driving while intoxicated and in the process causing serious bodily injury to another. Couple of questions for you. I know you're already out on bond on a DWI charge as it is. It's still pending. Do you have an attorney that you've been consulting with on that case?
Well, this has been going on for 3 years. I just got a new attorney like a month ago. I've seen him one time since.
Well, who's your lawyer?
But yeah, I do. Huh?
Who's your lawyer? Who is your lawyer?
I forgot his name.
All right. Okay, Miss
Gilbert something. I forgot.
What's that?
You dropped out. There was no question. I couldn't hear a question.
Oh, I'm sorry. I was just trying to figure out if you knew your lawyer's name.
Oh no, it's Gilbert something, but no, because that was my first time seeing him in my last court case.
Okay. All right. Do you have friends or family that can help bond you out?
No, I don't. Both of my parents are dead. I don't have anybody except for myself.
Do you have money saved up to help bond you out?
No, I don't.
Okay. And I showed that you have been unemployed for a week. What were you doing before that?
I was working at Goodwill as a cashier. And
is that what you were doing, $1,600 a month?
Huh?
We showed that you get $1,600 a month. Is that from Goodwill or?
That's what I was getting from Goodwill, yes.
All right.
Yes,
But you're no longer working there.
Correct. And they cut me off like at how the pay period is. Like, I'm going to get this that. They let me work that day. And then that's when they're like, oh, well, we're doing something, changing some kind of policy. And, you know, they had to let me go or whatever. But I have 5 kids. I live at the city of Austin property. I don't have any money. I mean, you know.
How old are your kids?
7, 6, 4. 1 is 16. The 7-year-old and the 6-year-old don't live with me, but the other 2 do. But I still have to pay for the 7 and the 6-year-old.
Is someone else caring for them right now, though?
Yes.
Okay. But you don't have family that can help bond you out?
No, there's nobody except for I have a 30-year-old sister who has my kids and her kids, and she's married, and that's it. Like I said, my parents are dead. My grandmother is 86 years old, and I don't have any other family, period, that I can name.
Okay.
Oh, I have an aunt that's like 86. She's right under my grandmother, but I don't have it.
All right. All right. Miss York, I'm setting your bond at $8,500. It would have been a lot higher under the circumstances because of the injuries involved here, the alleged injuries. I'm setting your bond at $8,500. You can try to go through a bail bondsman. They often charge around 10%, which would be around, in this case, around $850. But you're gonna have to go through a bail bondsman or a lawyer to bond out.
Can I ask you a question?
Go ahead.
Is it because a pedestrian got hurt?
That's correct. The allegation is that I don't want you to talk about the facts of the case, and I don't mean to.
I'm not. I'm asking because in 3 years, I've never missed court. I've never not done anything that they told me to do. And 3 years is a long time to never miss court, never do anything against
I noticed that, and I actually.
That's why I asked you that.
Yeah, I noticed that, and I took that into consideration.
I hadn't even drove a car in 3 weeks until I got that car like 2 weeks. Oh, sorry.
All right, your bond's $8,500. Bail bondsman may charge you $850, or it's up to you to find the cheapest bondsman you can find. If you do postpone and get out of jail, Miss York, you have a couple of conditions you need to comply with. Number one, you're required to report to a supervision officer and be subject to random drug testing. When you get out, you'll have a piece of paper telling you the name and number of the person you need to contact within 24 hours of your release, and you need to report in whenever they require. And again, you'll be subject to random drug testing. Second of all, you're required to be screened for drug counseling. You'll have a separate piece of paper telling you when and where to go to do that screening. And you need to do the screening and follow any recommendations of classes or counseling that they require you to go to. All right.
Does that mean that they're going to take me off of my legal medication that I need for my mental disorders? That medicine was not like I bought it off the street.
I'm not ordering that you not take your meds. I'm simply ordering that you be subject to random drug testing. As long as the drug test, as long as it tests for legal drugs that you're prescribed, you should be fine. But I will tell you this though, Miss York, both this case and your pending case involve allegations of being under the influence of drugs, perhaps even prescription drugs such as Xanax or Adderall and things like that, and methadone allegedly. And the reason why I'm bringing that up is because even if it's legally prescribed drugs, you cannot get behind the wheel if you don't have the normal use of your faculties, even if it's legal drugs or just like alcohol. Alcohol is legal, but that doesn't mean you can drive it under the influence of it. And the same thing with drugs. So what I'm telling you, Miss York, is even if you can, I'm not prohibiting you from taking any prescribed medications, but you cannot get behind the wheel if it's influencing you in any way, and you don't have normal use of your faculties. Do you understand that?
I get that. Yeah, I get that.
Not under any circumstances. You need to get a ride from somebody else. Okay, I'm serious, because this is a serious case. Now, I'm not going to require the ignition interlock device under the circumstances because the allegation doesn't involve any alcohol, and so that wouldn't accomplish anything.
I don't have a car anymore, but I'm not being funny, but I don't have a car anymore, but I understand what you're saying, sir.
Do you want a court-appointed attorney or do you want to hire your own lawyer?
No, I can't afford one. I need a court-appointed.
Do you want a court-appointed? All right, let me just look up. So I just want to read something on your last case just to confirm something. Hold on just a second. Almost done. All right, Miss York, do you have any questions? All right, good luck. Lastly, Taylor Bradley. Miss Bradley, You are charged with a felony out of Hayes County for murder. This is an indicted case. This is an indicted case out of Hayes County. I won't go into the facts of the case. I'm familiar with the basic allegations in the indictment. Your bond has been set at $100,000 cash or surety. That means you cannot get a personal bond. It has to be the full $100,000 in cash or a bail bondsman. And a bail bondsman will often charge around 10%, which would be $10,000. And that's actually kind of low for a murder case, to say the least. However, based upon the particular allegations in this case and based upon the recommendations of the powers that be in Hayes County who are investigating the case, your bond is being set at $100,000 cash or surety. Again, a bail bondsman maybe want to do it for 10%, which would be $10,000. It's up to you to find the cheapest bondsman you can find and make your own arrangements with them. If you get out of jail, Mrs. Bradley, you need to make sure you show up for all of your court dates or you will be rearrested. Do you understand that?
Yes, sir.
One of the conditions of your release, if you do postpone and get out of jail, well, actually, I'm not going to put that condition about drug testing because I don't know whether Hayes County has that, and this is a Hayes County case. So, do you want a court-appointed attorney or do you want to hire your own lawyer? Court-appointed? All right, any questions?
The bond can't be lowered at all.
It can be. Your attorney can ask for a bond reduction hearing to address that before the district judge in Hayes County. Under these circumstances, I do think that that's an appropriate bond amount, but that's certainly something that can be litigated with the DA's office and your attorney present, and to kind of drill down deep into all the factors involved on whether or not it's appropriate to lower it. Okay, that's certainly something your attorney can look into. Okay. All right. All right. Good luck.
I'm not gonna disconnect it. I'm just gonna mute it and stop the video.
All right.
Going to post 4.
Well, that escalated quickly from, man, shucks, what did we start with? We started with the lady who thought she was getting sucked into the system and he was offering her a personal bond, to the multiple DUI drunk lady with the broken arm. And then whatever happened with that situation there and that poor girl, but who supposedly has unalived somebody, which is obviously not cool at all. Wow. Let me know in the comments below what you thought about that video and about the judge. I thought he was super great. He handled each of those cases really well. Anyways, thanks again for coming by the kitchen. I appreciate you. I hope you have a wonderful day, and I'll talk to you soon. Bye. I'm not actually going anywhere. That was previous kitchen. We're not done yet. So I got my spreadsheet out. Let's take a look at that quickly while we've got it. What I did was I went and I found the county list. What the county name was, and then how many judges they had in each of those counties. And then I sorted it based upon that, which the most to the least. So there are, in fact, 160 counties in Georgia that have magistrates, and within those 160 counties, there is a total of 544 judges. So I'm not going anywhere. But you can see, well, one of those judges, let's just be real though, one of those judges was like covering 3 of them, so I think that's more like 541. So Fulton County is the top one, then DeKalb, then Gwinnett, which I haven't really seen stuff from Gwinnett. And then Cobb County, Cherokee, Henry, Bartow, Clayton, Forsyth. Yeah, I went through them all. Went through them all, guys. Did that myself last night. Now, what do we want to do next? I have a detention docket that we could watch. It might be a bit of a rerun, but it might not be, so we can try it. If you, I think that's probably the best one that we can do. There's a total of 159 counties in Georgia. Is that what I said? Oh, 160. I said 160, but I didn't count the I was wrong. You're right. There's 159 because there was the first line is my labeling, which says county name and number of judges. So that's actually correct. There is 159. Thank you for fact checking me on that. You are correct. As you can see here, there is 160 lines that I had, but one of those is for the title. Thank you very much, CRD. Excellent. Now we are at it's coming, guys. I have so many things I want to do on streams, but they get very, very busy, and I understand that, and it's not for everybody, but it's for like 20 of you or 24 of you, and that's really who I care about. So, if this isn't your thing, I post regular videos where I don't like talk and interrupt and put.
Okay, so this is a detention docket for the 323rd District Court.
Judge Kim, dude, I'm so sick of you interrupting me. So rude. Anyways, also, now you need to ask why I did that. Can anybody guess why I did that? Also, Steve in Rosen. Did you listen to that song? Because I wanted to put in the chat my rewrite of the intro. The reason I did it is because I theorized that protective order hearings are something that we enjoy watching, and Georgia already broadcasts some of them. So suffice it to say, the odds are decent that maybe other counties do too. And so I thought it would be a good way to research which counties to look at their county websites to determine their TPO processes. That's the truth.
For Monday, December 7th, 2020, in compliance with the Texas Supreme Court Emergency Order number 29 related to coronavirus, we're not conducting in-person proceedings, but we are using an alternative. Specifically, we're using Zoom. But to comply with the Texas Open Courts Act, we are broadcasting these proceedings on YouTube for the public to observe public court proceedings. No portion of this detention hearing may be copied, broadcast, or published. Violations of this order are punishable with contempt of court of up to 6 months in the Tarrant County Jail and a $500 fine. I'd like to remind everyone this is a court proceeding, so we do expect everyone to behave appropriately as if they were in court. That means your cameras need to be on. You do not need to be in bed, laying down, or in a laboratory. please keep all bright lights behind you out of the picture so we can still see your face. Any kind of moving objects like ceiling fans or moving backgrounds if you're in a car should not be part of this. And then, as well as I would say, domesticated animals. Yep. So, all right. Now, if you're an officer of the court, I understand if you need to turn off the camera. Like Ms. Tillman, if you've got other things to do, I understand. Officers of the court obviously are excused from this. So Sabrina Webster, please turn on your camera. Ms. Hawthorne, the blinking Christmas lights are a distraction. Please remove those from the screen. I'm sorry? Christmas lights. Yeah. Ms. Hawthorne, this is your second warning to remove the blinking Christmas lights from the screen. Ms. Webster, you need to remain still. I do not want a moving background. All right, so we'll go ahead and start with Hussein Amusawi. Is that you, Hussein?
Yes, sir.
Okay, I'm Judge Kim. This is a detention hearing. I'm making a decision to keep you here. What do you see if I keep you here? You have to see a judge every 10 days while you're here. You have the right to remain silent. And you have a right to an attorney. And we have appointed Mr. Graham as your attorney. Mr. Graham, are you here? Okay, so we're going to ask Mr. Lofton to step in for Mr. Graham.
Good morning.
Good morning. Do we have a parent here for Mr. Amusawi?
Yes, Your Honor, they're in the lobby, so they should be.
There we are.
Their way.
Whoever's there with the, thank you.
There you go, Judge. Sorry.
Oh, okay, thank you. All right, Mr. Amusawi, I'm Judge Kim. This is a detention. See, I already went over that with you. All right, so you're 15 years old. You've never been here before. Police were dispatched to your home on Saturday. When they got there, they met with your mom and aunt. They heard a male voice in the background yelling. They met with you to calm you down. And then they found out that you had asked for money. When your mom said no, you got verbally, then physically aggressive, grabbed a knife, held it in front of them, threatened to cut them both. They feared for their safety. At one point, you grabbed a lighter and a bottle of lighter fluid and threatened to burn down the home. All right, well, parents, do y'all speak English, Mom?
My name is Claire Wally. I'm his aunt, and this is Mom. She speaks English, but not really good.
Okay, I understand. What language do y'all normally speak?
Kurdish and Arabic.
Arabic? Okay. So then, are you the victim in this case? Were you at the home when this happened?
No, sir, I wasn't there.
You were not. Okay. So is there any other place that I can release?
I wasn't there, but I can. If you want to release him to me, I will be. I can take him.
Okay. So I guess my question is, where did this come from? With him pulling out a knife and threatening to burn down the home? I mean, does Hussein have all kinds of behavior problems we don't know about?
Hussein has depression. He has been seeing doctor and he's taken his medication. He is moody, but he's a pretty good, we've all been a teenager. He is a teenager and, but he never done this before, we were all surprised, because of what happened. But like I said, he does take depression. He does have depression and takes the depression medication too.
Oh, so he must want help.
Okay, he does take depression medicine?
Yes, sir.
Your Honor, I have one thing to add. When I read the report, I asked detention to go ahead and do a drug test, but I ran the report before the results were back, and he was negative on an 8-panel urine screening.
Okay. So then, Aunt, when's the last time you saw a doctor?
3 weeks ago, sir. But he has therapy every week.
Loud out there.
What is he diagnosed with?
Depression.
Just depression, okay.
الدكتورة قالت لي انت
لا لا يصير بالتغيير بس دكتورة قالت تقريبا شوار موجود يعني.
He's been seeing the doctor for almost like 4 months right now.
Sure.
Yeah.
And you're not worried about your safety if I release him to you?
Honestly, no. Not really, no, sir.
Where's his father?
Dad, he's in Iraq.
He's in Iraq, all right.
Yeah.
And do you live alone? Are you married?
I'm a single mom, sir.
Single mom, all right. How old are the children in your home?
I have a 14-year-old, sir.
Okay. And you're not worried about his safety after this?
No, sir. I mean, if you cannot release him to mom, I can get him.
Well, I'm not going to put him back in the home where he just pulled a knife out.
Okay.
So I'm looking for a reasonable alternative.
Yes, sir.
But you were telling me you're not worried about the safety of you or your son.
I can I can put my son over and my sister.
Okay.
Yeah. We are a pretty big family. We have 4 brothers and 5 sisters, mom, and we all have our own places. Yes, sir.
That's fine. Does he have a history of running away?
The history no run away.
مرة طلع برا بس هو يرجع ورا الساعة ساعتين يجري.
She said he went out once, but after an hour or 2 hours, he came home. So
When's the last time that happened?
آخر مرة كي بيجته. Like 3 months ago, sir.
Okay. How many times has this happened?
كم مرة صار هذا الشيء؟ Twice.
When was the time before then?
قبل ذاك كيبي قبل سنة قبل يعني كلف أكيبي.
كم دفعة يمكن سمر بيمكن.
Summer, she says, so she doesn't know exactly the time between the first time that it happened and the second time that it happened. Sir.
What about school? How's he going to go to school?
He's online school, sir. They do Zoom.
Okay.
Yes, sir.
All right. Okay. I'm going to go and release him to you, Aunt. I'm going to trust you to make your best decision for you and your son. All right. But if he's a behavior problem there, then just let us know. We'll bring him back here. Okay?
Sir, God bless. I really appreciate it.
All right. Thank you.
Yes,
All right,
sir.
Ms. Hawthorne, I'm going to ask you, keep the bright light away from the back of you because we can't see you because of that. All right? This is your last warning. Well, your window's still alight. I don't think you understand how this works. All right. So, Estras Altamirano, Mr. Marquez, are you here?
Thank you so much. Thank you.
Mr. Marquez is not here? All right. I'm assuming he's level 1-0. Alan Baza-Vilvazo.
Judge, yes, be advised, Mr. Altamirano is level 1-0.
Okay, thank you. All right, Alan, I'm Judge Kim. This is a detention hearing. You've been here for 10 days, so I'm reviewing your case, deciding whether to keep you here or release you. If I keep you here, you need to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Your attorney, Mr. Green, is here. All right, so you're level 1 outstanding. This is stemming from an aggravated, so Ms. Aguirre, is he currently on supervision then? Or his probation expired?
It's expired, Your Honor.
Okay. All right, so this is police responder shooting call on the victim, shot twice in the chest. Victim said he confronted you a couple times over the last couple weeks for playing music. Oh, that's right, this is neighbors, and then he came back and you had a gun and you shot him. So, Alan, I'm not comfortable releasing the community. Kids that have a gun and use the gun are the ones that give me the most concern. So I'm going to go ahead and keep you detained. I thank you that you're level 1. That's something that your attorney thanks you as well, because that's a factor in your case and how your case is resolved. Thank you, Alan. Haley Carlock.
I got a question.
I'm sorry?
I got a question. Well, it's a statement.
Okay, now I don't want to hear a statement. Your attorney doesn't want you to tell me a statement.
No, sir.
If it's a question, I don't mind answering the question for you. Yes, sir.
What's the chances of most likely getting on EM next time?
It depends on all kinds of.
Hold on, hold on. First of all, again, it's so rare that they actually frickin' get the question right. He said, I'm going to ask a statement, but then did he switch it up and ask a question? This is so crazy.
The factors, but what I have to consider is whether you're likely to run from court or appear in court, and if you're a danger to the community to others. When people shoot other people, that is a point where it's just, I mean, it takes a lot to convince me that it's safe to release you back in the community. All right, this is a really big deal, Alan. You may not think it's a big deal. It's a really big deal.
My charge is pending though.
Yes, exactly. Your charges are pending, and my concern is whether it is safe to release you to the community or not while you have pending charges. This is not like an adult system where you're entitled to bond. This is one of those, I'm making a decision whether it's safe to release a kid that's accused of shooting somebody twice in the chest or not. You may not think this is a big deal. It's a really big deal. This is really serious.
I'm asking you.
I'm sorry?
But I know it's a big deal. I'm just asking you.
Your Honor, I filed my trial motions and we'll be ready to go when the jury trials could begin again.
Okay, thank you, Mr. Green. Kaylee Carlock. What do you say?
I couldn't hear him.
Who is in detention? Who's the security control officer with Alan? Who's the security control officer that was with Alan?
Yes, sir. I'm right here.
What did he say when he was standing up?
Sir, he said, man, this is bullshit.
That's what I thought he said. All right, let's make a note of that. And give me his file back again. Just put a note there, don't release without district judge approval. All right. All right, thank you. Obviously, the good thing for you, Mr. Green, is nothing he says can be used against him in a trial.
Thank you, Your Honor. I appreciate that.
I mean, if there's a silver lining to all this, I guess that's it. All right. Kaylee Carlock. Ms. Carlock, are you here? Ms. Carlock, I'm Judge Kim. This is a attorney requested detention hearing. I'm deciding whether to release you or keep you here. If I keep you here, you have to see a judge every 10 days. You have the right to remain silent. You have a right to an attorney. Ms. Herrick is here as your attorney. All right, so Ms. Herrick, for what purpose did you request this?
Yes, Your Honor. She had a detention hearing last Tuesday, and you told her then that if she stayed on level 1 for 3 consecutive days, you would release her.
She's been on level 10 since December 3rd, so today I think is actually her 5th consecutive day on level 10. Yes, that should be released.
Okay, do we have a parent here?
Yes, Mom is on Zoom.
Yes.
Mom, are you? Oh, Ms. Gonzalez.
Her third day ended up being the weekend. So I had plans to release her today.
Okay. Ms. Gonzalez, you've been talking to your daughter?
Yes, sir.
You see a change?
Yes, I feel like she is changing.
Okay.
Down here.
So,
I knew that, but didn't figure out he was on the one.
all right, so Kaylee, I remember this one. So do you remember when I told you last time we saw each other that if I was to release you, it's going to be some conditions, like your mom has to have alarms on the door and the window, right?
Yes, sir.
And that you can't use your school-issued laptop or any kind of device that's not in plain view for everyone else to see. Do you remember that?
Yes, sir.
Are you willing to accept those conditions?
Yes.
Okay, Mom, do you have the devices for the alarms?
Yes, sir.
Okay, they're already installed?
Yes, I have an alarm on the house. We got the code and everything, so we'll.
Oh, you froze up on me. Okay. I think it's good enough. All right, Ms. Paxton, I'm gonna go sign the release order. Do we? Just think. Do you recommend an EM, Ms. Paxton?
With the alarms on the doors, I don't know if we need both.
That's what I'm asking you. What do you think? I just want your recommendation.
I would say no.
Okay. Okay. So we're gonna go and release her to your mom. Let us know if she has some problems. If she's giving you an attitude, let us know. I'm happy to bring her back. Okay? Oh, she's frozen. All right. Thank you, Kate. Hey, Katie, you understand? If you don't do what you're supposed to do, you're coming back here, right?
Yes, sir.
All right. Thank you.
Thank you.
Danny and Elliott. Thank you, Ms. Herrick. All right, Mr. Elliott, I'm Judge Kim. This is a detention hearing. You've been here for 10 days. I'm reviewing your case, deciding to release you or keep you here. If I keep you here, you see a judge every 10 days while you're here. You do have a right to remain silent, and you have a right to an attorney. So you have history out of Dallas, runaway, failed to ID. You've got current charges in Dallas, burglary of a motor vehicle, burglary of a building, criminal trespass with a pending court date. I think there's the one, Ms. Rodriguez, Dallas is waiting for us to decide what to do, right?
We're actually, Frank was going to see if he could work something out with the DA, but the family plans on moving back to Dallas.
Okay. All right. Well, Damon, here's the thing. You're here. You got pending cases. You're level 2. If you're not level 1, I'm not letting you go because you're not going to follow the rules at home. All right. So I'm going to detain you. Thank you.
Judge Kim.
Taylor Jeter.
Judge Kim.
Yes.
Real quick on Damian Elliott.
Yes, sir.
Judge, I'm not asking that he be released, but he has 2 doctor's appointments in the next 2 days. The only thing I would ask, if you would permit, is to let his mom take them instead of JPD.
Okay, doctor for what?
He doesn't have to go in shackles. He can just go with the EM if you permit.
Doctor for what?
He's got I think he has a psychiatric appointment.
Hold on a second. Damien, you need to sit up. This is court. Right? And Damien, if you're going to sit here and cry over this, you're the one that's causing yourself to be level 2. Either you behave and you get out of here, or you misbehave and you stay here. It's really up to you. All right, Mr. Adler. So psychiatric and what else?
I'm sorry, Judge. And then I think he has, I had it written down, I'm sorry. On Wednesday, I think he has.
An inhaler and a nebulizer that he needs to get.
Okay. And they're on what day? Tuesday and Wednesday?
Yes, Your Honor.
Okay, Mom, what time are the appointments?
His psychiatric appointment is at 9:30 tomorrow, and then his doctor's appointment is at 8:30 Wednesday.
Yeah, what cities are the appointments in?
They're both in Dallas.
Okay, Mom, I'm going to go ahead and release him to you on electron monitor now. You need to bring him back on Wednesday by 2 o'clock p.m., okay?
Okay.
That's for you to take him to a doctor. I need to make you aware that if he runs off in your custody, we will issue a warrant for you, and you will stay in custody until he can be found. Are you willing to accept this responsibility?
Yes.
Okay, we'll go ahead and do that. So he has to be back by 1400 hours on Wednesday afternoon, okay?
Thank you.
All right, thank you.
Thank you so much, Judge.
Thank you, Mr. Adler. Taylor Jeter.
Good morning, Judge.
Ms. Jeter. Come on, we got a lot of people today, detention. Thank you. Ms. Jeter, I'm Judge Kim. This is a detention hearing. You've been here for 10 days, so I'm reviewing your case, decide whether to keep you here, release you. If I keep you here, you'll see a judge 10 days later. You have the right to remain silent. You have a right to an attorney. Your attorney is Trent Lofton. All right,
Morning.
So, Judge, good morning, Trent. So, Judge Porter issued a warrant for you because you missed an appointment. You were brought over here You're skipping virtual meetings with your detention officer, not going to court order counseling, and mom did not appear either. Where's that noise coming from? Okay, and this is when the mom says she's not showing up to court, right?
That's correct, Your Honor, but I believe she did show up there today.
Okay, so mom, why'd you tell us that you don't care, you're not gonna show up to court?
Because I am tired of dealing with Taylor Jeter, to be honest.
That, mom, I need to let you know that is your responsibility, okay, as a parent. Whether you're tired of it or not, there are many times I'm a parent, as a parent, that I'm tired of dealing with my kid, but that doesn't change my responsibility.
And I understand that.
If you fail to show up at court when you're ordered to, we can issue a warrant for your arrest.
A warrant for what?
I'm sorry?
I'm sorry, can you repeat that?
I'm saying if you fail to show up to court when you're supposed to, we can issue a warrant for your arrest for not being here.
Issue a warrant for my arrest for not coming to court, but you won't issue a warrant for this kid's arrest for running away? I mean, seriously?
So, ma'am, there is no warrant for running away. And yes, I am serious. Your child is here. But the law says when a parent is instructed to bring a child back to our facility, they must bring them back and they must appear in court. That is the law, right? Runaways are not warrants. They're runaway reports that are filed through the police department, not through the courts, right? So at this point, Taylor, you have shown that if I release you back to your mother, that you're not going to follow the rules. And frankly, I don't think your mother provides you very good supervision. So I'm going to go and detain you. We have Aiden Hagel.
Thank you, Judge.
Thank you so much, Tupac. Oh my God. The attitude from that lady was epic. I think we could call it epic safely. Running away isn't illegal. However, being a runaway is not good in Texas. They're not good about that. Anyways, Discord is not difficult to use, as I say that after thinking I won't set my own up. I probably will end up setting my own up, but not quite yet because I'm still working on the videos and all that kind of stuff. But anyways, Discord is great in time served and looking at legal stuff. Discord, both of those I'm active in very often. And you can see me in there and feel free to message me. And you can easily get a hold of me in there. I can't figure out the link properly right now, Cha, to know where that takes you. But what I'm gonna do maybe this weekend is do a little Discord demo and a little sort of like explanation about the Discord stuff. But as always, you can ask in here as well. Like Discord is great for because it's not YouTube Daddy, and you know how YouTube Daddy is. He's so finicky. But I appreciate all of you guys being here and wanting to be in the Discord. I'm gonna have to put it on my list. Oh gosh, the dog scared me. List of things to do. Okay, let's keep watching this.
Mr. Hagel, I'm Judge Kim. This is a 10-day detention hearing. I'm deciding whether to release you or keep you here. If I keep you here, you see a judge every 10 days. You have the right to remain silent. You have a right to an attorney. Ms. Schumann is your attorney. How are you, Harmony? She was here. Harmony, are you? Okay, well, Mr. Lofton, I'm going to ask you to step in. All right, so Aiden, you were unsuccessfully discharged from Lake Granbury. You are level 2, so you know I'm not going to release you. And why are my things? Miss Burrell, why is Aiden, like, why am I thinking about him lately?
I'm sorry, I couldn't hear what.
Oh, what did he do recently?
He was discharged, unsuccessfully discharged from placement, and he's been in detention since that time.
Yeah, no, I feel like he did something either back there in detention or something happened.
Well, he's gotten into a verbal altercation and a physical altercation. I think you did his initial detention hearing when he was kicked out of placement.
Okay. All right. Well, Aiden, you're not level 1-0, so I'm not even considering releasing you. Thank you. Jeremy Hauser. Harmony didn't hear. I mean, she's logged in, but she didn't hear. All right, so, Mr. Hauser. Judge Kim, this is a detention hearing. When a kid's brought to our facility, you have to see a judge within 2 days. I have to decide to keep you or release you. If I keep you here, you see.
He's on his way. He's on his way.
So why isn't he ready?
He was ready. I'm trying to get out. The other staff's trying to get him out of his room. 1 second. Let me go check on it.
Wait, how do you say he was ready and they're trying to get him out of his room? Okay, we'll skip him. We'll go to the next one. Get him ready. DeAndre Henderson.
Okay, wow.
Here's DeAndre Henderson. Mr. Henderson, I'm Judge Kim. This is a detention hearing. Law says you've been here for 10 days, so I'm reviewing your case, decide whether to keep you or release you. If I keep you here, the law says you see the judge every 10 days while you're here. You have the right to make selling, you have a right to an attorney. We should warrant, there was a DTA issue because you ran away.
Sorry. I think, don't feel bad at all. I'm still learning. We're still learning about the chat Wordle and figuring out how to get it smooth. I swear to God, it was great the first night. And then I must have touched something. But anyways, he is very intense. Somebody asked what time it is. It is 12 midnight where I am on the West Coast. There's a lot of people in here that might be East Coast, 2 a.m. Central, I see. We don't sleep shame here. So if you don't feel like sleeping or you can't sleep, you can always come here and hang out with us. Or if you're working that graveyard shift, you can happily come and hang out with us as well. This whole hearing is like mood. Again, what happened there was Judge Kim. So for anybody that's new, these are from this one's from 2020, it looks like. So these are during the pandemic and in the 323rd District Court of Tarrant County, Texas. And Judge Kim is an elected judge where he has been elected in an election, and he is in office until 2026. And he, yeah, I live in the past. That's actually true. Both because I like to watch old court that I used to love watching live, and because I live in the West Coast. And I live in Canada, by the way, so all of my knowledge is acquired via YouTube. That is the way I see it. YouTube Daddy, don't tell me you don't know him. Come on now. Come on now. Anyways, Jacqueline, have a wonderful evening. We will see you soon. I hope you have a great sleep tonight. Oh, med check. Sorry, thank you, Cha. We also do med checks because a lot of us take meds and forget, like me. We're gonna re-rack that a little bit because what Judge Kim did here, lovely to hear that. Walkie or wacky? What do you prefer? Wacky or walkie? Judge Kim, unfortunately, in my opinion, my kitchen opinion. Also, I am going to turn off the game and restart it so that we can try and make it work properly. But Judge Kim, in my opinion, what happens is he gets caught up in the moment of being on Zoom court, and he exacerbates situations that he could, as the de facto leader in the courtroom, which is where we're watching right now. He is supposed to set the tone. He is supposed to set the example of behavior for everybody. And yes, I have. That's the way I see it. I can't understand it properly, but I have seen that. Anyway, okay, wacky. Wacky. But so in my opinion, I think that that is a failure of his, and maybe he chooses to do it, maybe he doesn't. I don't know. But my um feeling on it is that if he wasn't so realizing that he was putting on a show, and you have to keep in mind, these, when they originally aired, chat was open and they watched it. So it was obvious sometimes when you realize, like, oh, this guy's watching this. And some judges do watch the chat, some judges don't, some leave it on for a little bit, some don't. I love a chat. I love a chat. I love a chat. I love it. But I don't really like to see the judges being triggered or trolled. Like, to me, that's like, huh? Like, I really prefer it when they pretend like we're not really there. Like, there's one viewer. That's my ideal judge. When they're like, nobody's watching. What? Let's do this. And then we're watching. But he escalates situations that don't need to be escalated. And like I've said many times before, my dad was a juvenile juvenile corrections officer in a maximum security facility, and also intensive support supervision provider for kids that were recently released and at a likelihood to reoffend. And so when you realize that he's dealt with situations before, like the aftermath of seeing this judge is not just the turmoil on that child, it actually is problematic for the entire facility in a negative way. And again, you would really hope that the person that's overseeing this entire operation would be mature enough to see that. And unfortunately, I think that he often got caught up in the people just like us who are appalled at some of these crimes that these people are accused of. But just again, it's like when I see police that resort to violence very quickly in situations where, yes, it might be more difficult to de-escalate something, but guess what? That's what you got to do. Like, I am great at de-escalating situations. I've played the video on here before where I de-escalated the guy on the bus. I just it's hard to realize when somebody's gone to school, gone to all the work to get into this position, and then all of a sudden, like, the tone that he sets for all these people, like, none of these people are enjoying their day usually, and we see them a lot. And I've seen judges dealing with horrible stuff too, but the people that work around them are still happy and feel supported and cared about. Judge Kim just reamed out in front of coworkers, kids that are in detention, lawyers, everybody, somebody for being slightly late. And again, he's sitting there like, wow, why aren't they absolutely perfectly prepared for this stage show that I am trying to put on here? I don't want any dead time. Like, this is what I think is the main issue, is that he wanted to put on a very good show, and it has been a great show. I mean, we've been watching it for months, but and I watched it originally. I don't think it was done all in his best intentions. Anyways. Okay, let's continue on with this. I will restart the Wordle. What I'm going to tell everybody, if you're going to play the Wordle, please make sure that you zoom live to the most forward part of the live that you can, because how Wordle, the game, works is you guess things in the chat. You have to use a command in order to guess it. And I wonder if maybe I should eventually make the command something more difficult, like really long, that would be difficult to type in unless you really wanted to do the guess. You know what I mean? Anyways. I don't know about Discord bots as much. I am in, there you are. And where did you say you're from, Ray? Nice to meet you, sliding into the Discord. Like I said, I'm from Canada, so I am always learning.
He was ready. I'm trying to get out. The other staff's trying to get him out of his room. 1 second. Let me go check on it.
Wait, how do you say he was ready and they're trying to get him out of his room? Okay, we'll skip him. We'll go to the next one. Get him ready. Keandre Henderson. Here's Keandre Henderson. Mr. Henderson, I'm Judge Kim. This is a detention hearing. Law says you've been here for 10 days, so I'm reviewing your case, decide whether to keep you or release you. If I keep you here, the law says you see the judge every 10 days while you're here. You have the right to make telling, you have a right to an attorney. We should warrant, there was a DTA issue because you ran away, and
Judge, we have court on Thursday.
okay. Yeah, Kendrick, I'm glad you're level 1-0. Here's the problem is that you ran away before, so I'm just worried if I let you go now, you're not going to show up for court. Fortunately, court is just this week. All right, do we have a parent here?
Yes, Nikita Henderson.
Oh, there we are. Okay. So, Kendrick, this is just kind of a consequence of your decision. You have to remember that. Even though something's happened in the past, it can still come back and get you later on. So, we'll see you in court on Thursday, and then hopefully your case gets resolved then, okay? Thank you, sir.
Judge.
So are we ready for Jeremy Hauser now? Nope.
He's here, Your Honor.
All right, Mr. Hauser, I'm Judge Kim. Jeremy, why weren't you coming out of your room?
What'd you say?
Why weren't you coming out of your room?
Oh, because they had just told me to get dressed and stuff. Like, they literally just told me to get all my stuff on, and I didn't know what was going on.
Well, let me get to the bottom of that.
Your Honor,
Yes?
I would like to request that we move this to the end of the docket. Jeremy's caseworker, Jamar Gorman, is not here yet.
Caseworker for what?
For Jeremy, for the permanency specialist.
Okay, can I ask who you are?
I'm his mother.
Your mother. So, what's the status then right now? Is he in conservatorship of the department?
We have joint managing conservatorship.
Okay. Okay. I mean, they know what time it is. They can show up on time if they need to. All right. But y'all are here. We're not resolving anything final. This is just a detention hearing on deciding whether to keep them here or to release them. So, Jeremy, you do have a right to remain silent. You have a right to an attorney. Let's see. So you are a biological mother or foster mother?
No, I'm biological mother.
Biological.
So on December 1st, OCOK said that you were run away from your foster home. They told you to return back for a new placement. Then we got another call from OCOK saying you ran away again and you missed out on your placement opportunity. Finally, a couple hours later, So you're supposed to go to emergency shelter. They said that you ran away again. What happened to the drug test? Did he not give us a sample?
They never asked for one.
All right, so who's here from detention? All right, Mr. Miller, why are we not getting a sample from him on a return trip? Mr. Miller?
Your Honor, they were supposed to drug test him when they brought him in.
And did they request a sample? Did the note show they requested a sample?
I did not see one.
Okay. Well,
Your Honor, there is a note in there that says unable to provide sample. So that's as much as information I can give you.
All right, well, then Jeremy, if you're refusing to give a sample, I'm kind of assuming that you're positive for everything.
No, Judge Kim, Your Honor, they never asked me for a sample, but I will tell you that I will be dirty for THC, and that is it.
So this deal, if you don't get a sample from him, then what I want to do is I want to do a hair follicle test, and he'll remain in custody until the results of the test come back. All right. And so I will make a decision, and I'll probably
do your analysis real quick.
Yeah, hair analysis, hair sample. It's too long. It's been too long for your analysis, so I'm not going to trust that anymore. So it takes about 2 weeks. So we're going to go ahead and get a hair sample, and then submit that to a lab for testing. It takes about 2 weeks to get the results back. So you'll sit here until we get the results back.
Your Honor.
Yes.
May I please just say something? So I don't feel like I should be at fault for that. They didn't ask me. They never asked me to do a urine analysis, never asked me to do a urine sample, any of that. All they did was ask me if I would come dirty. And yes, I would come dirty for THC.
They are telling me that they did ask and you didn't get a sample. So whoever did the intake, they're the ones saying that. And so that's what I'm going off of.
Did they say that I refused to do it, or did they say they were unable to do it?
They're unable to get a sample. And what my standing order says is that they have to get, if a kid comes back to Kimbo a second time, they're supposed to take a urine sample on entry. And so if they didn't get the sample, then I'm just going to get a hair follicle test. So this is just the consequence of you running away, right? You just have things, I mean, that's the thing. You run away and you know things are going to happen. It's not good. So you made that decision. Now there's a consequence of that decision.
Your Honor, okay, I'm not even going to try to explain myself or anything, because this is it's getting old for me too. I'm tired of people telling me that, oh, you're going to live here, you're going to live here, you're going to live here, and it just doesn't happen. And then y'all expect me just to be okay with it and just be able to stop my feelings and stuff. I'm not even trying to blame anything. It's my fault for running away.
Who's y'all?
No, CPS.
I'm not CPS.
I know, but they just keep telling me I'm going to live with people, and they want me to be okay with it whenever they say that I'm not going to live with them anymore.
That's them. That's not
fair.
y'all. You just said y'all expect me to.
Okay, I'm sorry. CPS.
Okay.
CPS keeps telling me that I'm going to live places, and they say, oh, never mind. You're not going to live there anymore. Right. And they just expect me to be okay with that.
And this is an issue that you need to talk to your attorney ad litem about and help you resolve that for the judge in your court. This is strictly a juvenile matter. Right now, I'm here on the juvenile issue, and on the juvenile issue, if you don't get that drug sample, that gives me concern. And part of this process is the fact that when you're running away, you understand there's consequences. You knew that good things aren't going to happen by running away. And you probably didn't expect this to happen.
Can I do a urine sample, please?
No, because it's too late for that. Urine samples
I just
are only
came
good for
into custody 2 days ago.
Yes, and if you used cocaine 3 days ago,
I don't use cocaine. I told you what I was going to come dirty for. I was going to come dirty for THC. I've never done anything else in my life. Drug test me every time I came here.
And we'll find out.
Anything besides THC.
And we'll find out. That's the thing is I don't know if you have or haven't. All right. So this is a consequence. Good decisions come from experience. Experience comes from bad decisions. You made a couple of really bad decisions.
A couple. All I did was run away.
And that's a bad decision. You're not supposed to run away.
This isn't fair though. How is that my fault for them not asking me to do a urine sample?
How is it your fault that you ran away?
How is that my fault?
Stop. You know what? Stop making yourself the victim. You're not the victim. Don't sit down.
Don't walk away. Don't walk away. Sit down.
Oh, bro, I'm not making myself a victim. They never asked me to do a urine sample. How am I making myself a victim? They never asked me.
So now it's just making it even harder for me to release you, even if your hair follicle test comes back clean. Because it tells me if you're going to walk out on me, then you're going to walk out of a placement too.
I haven't even been on my medication for so long, and they're expecting me just to be okay with everything. They're just expecting me to be all right.
Stop making yourself a victim.
Since I've been here.
Why are you victimizing yourself? Every opportunity you have.
I'm not victim. Okay, if you want me to take responsibility for everything I've done, I ran away. Okay, you're right. I did smoke weed. You're right. I did smoke THC. That's all I did, though. I never did anything else.
You just stood up here and walk out on me.
Or them not asking me to do a drug test, and then I get held for that. That is not my fault.
You're walking out on me. Look, it all sounds
I did walk out.
If you didn't run away, then you wouldn't even be here in the first place. You were trying to find somebody else to blame for every one of your perceived misfortunes. What you're forgetting is it's your own bad decisions that put you in these situations. One day you'll wake up and realize you're not the victim. Don't be a victim. Own it. Say, I screwed up. I made a mistake.
Yeah, I did mess up. All right. But that...
So this is the consequence. But you're not...
Okay, but this... All right, yes, sir.
What did you say?
I say yes, sir.
So, yeah, just realize there's certain consequence things. You own up to it, you man up, and then get it past you. All right? So, we'll wait for the drug test, and then, Yeah, Mr. Miller, just let me know what the drug test is. I'll make a decision after that. All right?
Yes, Your Honor.
All right. Thank you, sir.
Thank you, Your Honor.
Destiny Kenny. Destiny, are you here? Destiny. Is that you, Destiny?
I'm here.
Okay, Destiny. I'm Judge Kim. This is a detention hearing. Been here for 10 days, so I'm reviewing your case, decide whether to keep you or release you. If I keep you here, you see a judge every 10 days. You have the right to remain silent. You have a right to an attorney. Ms. Hamrick is your attorney. Ms. Hamrick, are you here?
Your Honor, I believe I'm Ms. Locaney's attorney.
You're absolutely right, Ms. Cameron. Ms. Craven, I'm sorry. I went out of order on that last one.
Oh.
Okay. All right, it's good to see you. All right, Destiny. So you're brought in for injury to child. Oh, this is, well, the elderly lady walking behind you where you hit her, she fell down. Okay, she's level 1 outstanding. Do we have a parent here?
Yes, I'm here.
Okay. All right, so Ms. Blair?
Yes, sir.
So the victim's difficulty speaking, is that a result of the head injury or is that something was before?
I believe both. On the police report, I think with her pushing him down, I believe it made it worse.
Okay. Yeah, and now his health is actually taking a downturn since he's released from the hospital.
Yes.
Destiny, I'm just gonna let you know, if this person dies because of the head injury, you're looking at a manslaughter charge, okay? So just so you know that this could get worse. I don't know if you believe in prayer, but it may be the appropriate time to pray for this person. All right. Ms. Blair, do we know, was it a neighbor or was it just a stranger situation?
I believe the victim lived around their neighborhood. It wasn't like they didn't know the victim or anything.
All right, Destiny, you're behaving in here now. And you have been. You've been level 1-0 since December 1st. All right, so I appreciate that. I'm going to go ahead and release you on electronic monitor. But, Mom, you have to understand, my releasing her, she needs to enroll in at-home school online. She is not allowed to leave the house because here's the thing, I don't like the people she's hanging out with. I know there were some other kids here. So she has very strict rules. This is unless it's medical or church or religious activity, she can't leave the home. She's stuck there.
Yes,
okay, Mom?
Yes, Your Honor. Thank you.
All right. So you have to understand I'm serious about this one. I do not want her hanging out with these girls that got her here in the first place. You have any questions for me, Mom?
No, thank you, Your Honor.
You're welcome. Destiny, do you have any questions for me?
Oh,
Okay, you're not gonna mess with me, right?
no.
You just stay at home, okay?
Yes, that's
And
all
you
right.
need to no contact. No contact means no online, social media, Instagram, none of that with any of the girls that you were arrested with, okay?
Okay, thank you.
Okay, thank you.
Thank you, Judge.
Amanda Modisette. Amanda Modisette. Okay, last time, Amanda Modisette.
She's coming, Judge.
Okay. Amanda, I'm Judge Kim. This is a detention hearing. I'm deciding whether to keep you here or release you. If I keep you here, you'll see a judge 10 days later. Violet McCoy is your attorney. I don't think she's here, so Mr. Lofton is stepping in.
Good morning.
Brought in November for assault, bodily injury. At a group home. They gave you medication. You threw the medication cup off the balcony, and you kicked the worker. So, I thought I had ordered CPS to pick up this child. No? Is anybody from the department here?
No. Yes, sir, I'm here.
Okay. Didn't I order y'all to pick up this child before?
No, sir, I wasn't aware of that.
All right. Well, she's level 1-0. She has been. It seems like her behavior's getting better. Y'all have a place for her to go right now?
Yes, sir, she can return to her placement that she left from.
Okay. All right. So, Amanda, I'm going to go ahead and release you back to the department. They're going to take you back to the same placement. You have to understand that you are level 1-0. That tells me you know how to behave. So, I'm expecting you to behave at the placement. If you don't, then you're going to end up back here. You understand?
Yes, sir.
And I know as bad as you don't like the placement, you still prefer it to be at the placement than here, don't you?
Yeah.
Well, hold on, you paused. Would you rather be at Kimbo or your placement?
Yeah. No. I'd rather be at the placement.
Okay, I thought so. So you understand how you can come back here is you need to be a level 1-0 at the placement. Do you understand?
Yes, sir.
Okay. Hopefully I won't see you again. Thank you, Amanda.
Question, Your Honor.
Yes.
This is Cynthia Smith, her placement. Is she able to be released to the placement, or does OCOK or the CPS needs to?
Or the what?
Does CPS or OCOK need to pick her up, or can the placement pick her up?
Well, the department, if you want to make the placement as an agent to come pick her up, and that's fine. Either one.
Okay.
I want to give her a chance. She's here. Hopefully she learned her lesson, right?
Yes, sir.
Okay, so hopefully she learned her lesson, Amanda, and so we can take the skills that she learned here, and hopefully they translate back at placement. Okay, so however she gets there, it doesn't bother me. All right, thank you. Katarina Neal.
She's coming in, Your Honor.
All right. All right, Ms. Neal, I'm Judge Kim. This is a detention hearing. I'm deciding whether to keep you or release you. If I keep you here, you have to see me every 10 days. Ray Hall is your attorney, and you have the right to remain silent. All right, so she was, I guess, on probation. She was a couple days before probation expires, and referred for a man laying in the street bleeding. Oh, this is the one where we just released the girl, right?
Yes, Judge.
So she's 17 years old. Level 1-0 for about 8 days now. All right, do we have a parent here? Okay, you're Katarina's parents. Are you mom and dad?
Yes.
Okay. Well, have you been able to talk to Katarina while she's been here?
Yeah, she calls, like everything.
What have you noticed different about her?
Attitude has changed. I think she understands the severity of her actions.
Right.
Even before this happened, she was doing a lot better. She started working. She was doing better in school. And she just got mixed up in the wrong crowd.
Right. Wrong crowd.
Right.
I think we all agree with that one, right?
Yes.
All right. So what I'm going to do Kateria, it's a question for you. I'm willing to release you on electronic monitor to go back home, but that is on the condition that you're not to leave the house until I change my mind. That means you can only leave the house to go to the doctor or to church or synagogue or whatever, all right? Otherwise, you need to enroll in online school and stay at home. You cannot go outside. You cannot be on social media. You cannot contact any of the girls that you're accused of being in an incident with about the old man. You understand? So would you rather stay here or would you rather go home on the conditions that I set up?
I would rather go home.
Okay, but you understand, I'll bring you back here if you violate that EM, right?
Yes, sir.
Okay, well, we'll give you a chance. Thank you, Kateria. Louis Parker.
Thanks, Judge.
Yes, ma'am.
Her job was waiting on her to come back. I wondered, would it be a possibility for her to go back to work?
Not at this point.
Okay.
Well, let me ask you this. Mom, Dad, do you need her income for your...
No.
Okay, then no, not at this point. Kateria, you kind of lost that privilege.
Hi, Felicia. This is Andrea Lucia calling with Harris County. We should be arriving around 1 o'clock.
Okay, Ms. Guerrero, can you put
That's
yourself on?
our resident, Kiana.
I like Felicia so much. Okay, all right. So Kateria, you kind of gave up that privilege by being caught up in all this. And so at this point, the answer is no. We're gonna wait about 30 days and then I'll make a decision, okay?
Thank you.
Thank you. Louis Parker.
Honor.
All right, Mr. Parker.
Yes,
Glad
sir.
you're back.
Yes, sir.
Detention hearing, so you guys see me within 2 days. Decide whether to hold you or release you. How was the time with your dad?
It was great.
Great. Okay. How about time with your mom?
Sure.
Your Honor, I was having car trouble and I didn't get a chance to pick him up, and it kind of upsetted me. And due to the COVID-19, I didn't trust the Uber drivers or the Lyft drivers, so it was hard for me to get him yesterday. So I didn't get a chance to get him.
All right. So Parker, for Louis, I'm gonna feel bad for your mom having lost that opportunity with her car problems. So we'll make it up next Sunday. Okay?
Yes, sir.
So this coming Sunday, as long as you're level 1-0, which I know you will be, then we will make that time up and get you your. I think I had but 4 hours for mom. Is that right?
11 a.m. to 6 p.m. is what?
11 to 6. Okay, I extended it out. And we give him a UA when he came back, Ms. Thomas?
Yes, Your Honor.
It was clean, right?
Yes.
Okay. And where are we on the fitness restoration?
I am actually waiting on a response from Dr. Foreigner. I emailed her. He is coming up on the 90 days.
Okay, good.
Yes.
All right. So, Louis, I'm going to go ahead and detain you now, but this Saturday I will give you that timeout with your mom. Okay?
Yes, sir. Thank you, sir.
Sunday. I'm sorry, it'll be this Sunday. It'll be the same set number of hours. Okay?
Yes, sir.
All right. Thank you.
Thank you, Your Honor.
Thanks, Judge. Thank you, Judge.
Thank you. Terrence Tucker. All right, Mr. Tucker, I'm Judge Kim. This is a 10-day hearing. You have the right to an attorney. You have the right to remain silent. Okay, this is stolen car, Rosedale. Driver got out, began to run. And this is his 1, 2, 3. This is his third stolen car and second evading arrest. Okay, Terrence. Kind of getting checked out on you. It's like every time you come here, you're not learning a lesson. So I'm just not confident that if I let you go, you're not going to steal another car or run from the police again. So I'm going to go ahead and detain you. All right, thank you, Terrence. Rick, you promise.
Your Honor, may I be excused?
Yes, thank you, Mr. Youngblood.
Yes, sir.
Mr. Promise?
Sir.
All right, All right, Mr. Promise, I'm Judge Kim. This is a detention hearing, deciding whether to keep you or release you. If I keep you, you'll see a judge in 10 days. Your attorney, Ms. Tillman, is here, and you do have a right to remain silent. Promise, you're level 1 outstanding. You're currently on supervision for, okay. Let's see. Fourth, you're on probation for felony. In November, police were dispatched for robbery. The vehicle was missing, so they called OnStar, located the vehicle. There was a chase. And while evading, they threw a AK out the window. And there's a felony stop. You were her stepson. Okay. So Ricky, you're on probation for a serious felony offense. You know how I feel about kids and guns. And so I'm concerned if I release you back in the community that you're a danger to yourself and others. So I'm going to go and detain you. Let's see. Lead us where we're going to do in person. Jekiah Smith.
Your Honor, may I be excused?
Yes, thank you, sir. Jekiah Smith. Where's Smith?
Right here, sir.
Okay. Mr. Smith, this is a 10-day hearing. I'm deciding whether to keep you here or to release you. If I keep you, you have to see a judge every 10 days. You have the right to remain silent. You have a right to an attorney. Mr. Adjudication is your attorney. You are level 2, so you're not level 1-0, so I'm going to go ahead and detain you. Thank you, Mr. Smith. Juan Soto.
Thank you, Judge.
Thank you, Mr. Adjudication. Sometimes it's pretty simple.
quick.
Yes, Your Honor.
I'm sorry?
Good morning, Your Honor.
That was pretty quick.
Yeah, well, you gave me a very quick decision. All right, Mr. Soto, I'm Judge Kim. This is a detention hearing. When a kid's brought to our facility, you have to see a judge within 2 days. I have to decide to keep you or release you. If I keep you here, law says you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. We have appointed Mr. Adler as your attorney. All right, Juan, you're 15 years old. You turned yourself in on December 5th because I issued a warrant for you on November 3rd. So you had a theft of firearm case. From July. You got picked up for another theft of firearm case in August. And then now you're skipping court, or you're on the run. And you're smoking weed while you're on probation. And cut off your EM. So, Juan, I'm glad you turned yourself in, but at this point, you're on the run for a month while smoking weed on probation and cutting off your EM. So, I'm just concerned if I release you, you'll just smoke more weed and cut off your EM again. So, I'm going to go ahead and detain you for now. Thank you, Mr. Soto.
Dismissed.
Thank you, Ms. Reyes.
Have a good day, Judge.
Iba a hablar el señor Reyes, ¿no? Pues le...
Okay. DeQuaylen Spencer. All right, Mr. Spencer, I'm Judge Kim. This is a detention hearing. Law says when a kid's brought in, you have to see a judge within 2 days. You have the right to remain silent. You have a right to an attorney. If I keep you here, you have to see a judge every 10 days while you're here. So you were... All right, Arlington PD brought you in, saying on the 8th of November, they were dispatched. You had a warrant for ag assault out of Fort Worth. When they got there, you had some weed in your pocket. According to the warrant, back in May, there's a shooting. They found the victim in the parking lot. He shot in the leg, which caused a tear in his femoral artery. He had to have his leg amputated. The victim said he was drunk when he went to the apartments with friends. Not sure really what happened. But witnesses were there, and they were arguing with the victim, trying to fight him. The young black male got out, approached with an AK. Then he shot one time into the ground and then shot the victim in the leg. And witness identified the shooter as Q. And yeah. All right, so we have a kid with a gun with a shooting. And then now, as soon as you get here, it turns out that you're starting fights with other kids in our detention facility. Do we have a parent here?
No, ma'am, or no, sir, I'm sorry. She had an appointment, so she couldn't.
Okay. Yeah, so Quaylen, I'm going to warn you that you are approaching 17 years old. And if you keep this behavior up when you're 17, I'm just going to house you downtown in the adult jail. All right, so, but I'm not letting you out, not under these circumstances. All right, so next we have Davion Stevenson. All right, Mr. Stevenson, I'm Judge Kim. This is a detention hearing. I'm deciding whether to keep you here or hold you for another 10 days. You have the right to remain silent. You have a right to an attorney, who is Mr. Graham, who I don't think is here. So Mr. Lofton is going to substitute in.
Good morning.
Good morning. So you are level 1 outstanding right now. You were, see, there's a charge of aggravated robbery, Sycamore Point. It said 2 black males wearing dark clothes approached them, brandished a handgun, took their car. Vehicle was spotted by real time. And surveillance cameras showed Davion taking the driver's seat. Davion had a backpack. They stopped the car. So in the backpack, they found a BB gun made to look like a real gun and a magazine to a real gun. And you're on probation for assault on public servant and stealing a car. You have an adjudication disposition hearing set in 10 days. Have Davion? Tell you what, I'm just not happy with kids with guns, stolen cars, all that. So I'm just concerned if I release you, that you're going to end up shooting somebody or getting shot yourself. So I'm going to go and detain you. But you'll have court next week, so we'll see you then.
Sir.
So, Vonquez Thomas.
Yes, sir.
All right, Mr. Thomas, I'm Judge Kim. This is a detention hearing. I'm deciding whether to keep you here or release you. If I keep you here, you have to see a judge every 10 days. You have the right to remain silent. You have a right to an attorney. Ms. Mills is your attorney. Hello, Ms. Mills.
Sorry. Hello. How are you?
Okay, so Vonquez, you're on probation for unlawfully carrying a weapon, possession of weed, and then now,
Judge.
Probation for 1 year. You were in TCAP. November, you submit to half of the substance abuse assessment. You showed up late and say you didn't need the drug treatment. And you were only there because the probation officer made him do it. So here's the thing. It's like, it's not the probation officer making you do it. It's me making you do it. It's the judge making you do it. Where did the evading come from, Ms. Campos?
The circumstances surrounding the evading arrest is that Arlington PD were called to a shooting in progress call. When they arrived at 2210 Elmwood, apartment number 514, there were 2 black males and a Hispanic male that were there and fled toward the pool area of the apartment complex. And that's where the kids were detained. One thing I wanted to make mention is that one of the persons that Vonquez was with during this offense is Tyrone Hall. He was ordered by Judge Terry not to associate with Tyrone Hall when he was placed on probation on August the 31st. And then the only other thing I wanted to mention, and he's currently on probation for unlawful carrying of a weapon, which happened to have been a firearm.
Mm-hmm. And we give him a drug testing is positive.
Yes, and I did talk with the campus, considering what happened with his drug assessment. They're willing to put him in inpatient, but they want for him to be in detention for 14 days.
Yeah, I'm not giving inpatient for weed. The problem isn't the weed. The problem is Marquez is running around people that are on probation, refusing to do the conditions that I ordered Ms. Campos for you to for him to comply with, and that he's smoking pot. And so he's basically done everything wrong. Let's start a placement search for something behavioral. That's the problem. I mean, I don't think the campus is going to do anything for him at this point, because all he's going to do is hang out with other kids that he's ordered not to hang out with if we send him to campus. So, I mean, I'm more open to a placement search to remove him from the community short term. But I think that's all we can do. All right. All right, Devonquez, you make mistake after mistake, but eventually everyone gets tired of your mistakes. So I'm going to go and detain you, and we're going to start a placement search. Decide if there's a facility that's better, more appropriate for you to go to help you with just your bad decisions. Thank you. Terry Young.
Thank you, Judge.
Yes, Mr. Young, I'm Judge Kim. This is a 10-day hearing. Deciding if I want to keep you here, release you. If I keep you here, you'll see a judge in 10 days. You have the right to remain silent. You have a right to an attorney. And Mr. Pearson, I believe, is here.
Present, Your Honor.
All right, so we released you, but we're taking regular urine samples to watch your levels go down, but then they spiked up. And so you are on probation for aggravated robbery. So, man, every time we give you...
Whoa. We got a beaver sighting.
So you're on a 5-year determined sentence probation. We're set December 10th at 9:30 in the morning for to find out whether you, or make a decision whether you violate your probation or not. All right, Mr. Young, so I'm going to go ahead and detain you, and we will see you on, what is it, the 10th? We'll see you on, I guess, Wednesday. Yes, sir. You have a question for me?
No, I don't got no questions.
Okay, thank you, sir. Okay, at this point, under Section 5408 of the Texas Family Code, court proceedings are presumed to be open to the public unless there's good cause finding that they should not be. However, when a child is under 14 years old, there is a presumption that the court proceedings should be closed to the public unless the court finds good cause to open the proceedings. The remainder of our children today are under 14 years old, so I'm going to discontinue the YouTube broadcast of this proceeding.
From the respondent, Your Honor.
We were publicly broadcasting. So if everyone can wait 20 seconds for the tape delay to stop.
Yes, thank you. If you could go ahead and wait 20 seconds for me to figure out what to put on the screen next, because I'm not tired yet. Let's take a look at business Larry Beaver. This is Larry Beaver, the businessman. He differs from his brother, who is not a businessman. Is this a scarf though? Or I think he's business beaver, but because he's sort of limited because of beaver life, he can't do much more. Cachette, you're asking what to get your mom for Mother's Day? Pay a bill for her. Hire a cleaner to come for 3 sessions. Taking them out for brunch is pretty good. Are you over 21 though, Ray? Because maybe my math isn't good. We also have with us, this is our bingo card. So when we have pretrial bingo, we should put Larry Beaver on this chart, really. You can, Ray. That's nice to do. Honestly, I'll tell you something. I'm a mom, and there's just a few things that if they won't tell you what to get, you can sort of do anyways. But it really depends on where you are at and what you're willing to spend. So you just have to say how much you're able to do, and then that's what you can do. Um, I really enjoy weird online stuff. So for me, what I hope to get on Mother's Day would be like a subscription to one of my favorite YouTube channels that I really enjoy being in their secret mythical society, or, many different things. There's lots of different things that parents and people like, but it's hard to get to know it exactly. However, if you give me a vague thing about what they're interested in, I can almost always come up with something because of the way my brain works. Hey, Ray, just so you know, I want to explain something to you because you're new here. I have something called aphantasia in my brain, which means that I have no visual imagery in my head. And I never have. And I honestly thought that people were sort of like when people would say things like, picture this or imagine that, like imagining is different because I can imagine very much, but there's never a picture. And so my brain just works quite differently. I don't know how the connections are made, but they're always made. And so if you tell me like one thing, my brain just automatically like does all these synapses. Let me find another episode that we possibly haven't watched. Bingo bees. I know, and so here's the crazy part. I only found out that I had aphantasia this year. And so my entire life, I have been going through life the way that I do. And it's sometimes hard to explain, and it gets harder when I like try and understand it myself because I'm like, I really couldn't comprehend that there are pictures in your mind. However, what I have come to realize is that it means that I have the ability to sort of see in my mind or be creative or use my imagination as easily with my eyes open or closed. There's no benefit to sort of concentrating or closing your eyes and trying to see, like nothing ever happens. So, um, it's always black when I think. There's never anything in my head visually. No, I don't see any words. I know how to spell all the words, but I don't see any of it. I just know the words. I don't see anything. Like my daughter, when I think of my daughter, I don't see her face. I know what she looks like, but I could describe her to you, but in reality, I'm thinking of her right now, and the what I feel is a feeling of like love or a combination of all my feelings about a person, and not anything visual at all. There's a number of people in the chat that also have this condition. I don't know if Gracie is still here as well. I also don't dream. But I used to attribute that to the THC that I smoke, but now I realize that it is probably the aphantasia as well. So, what I find really interesting is that I have ADHD as well, and ADHD and very poor driving is really correlated a lot, but I have always had a really good driving record, and I've realized what that is because I mean, like, it's a little hard for me to even comprehend that you actually can see things if you close your eyes or daydream, like, like I'm always watching the road and paying attention and like analyzing the situations going on in front of me. Like there's never ever visual thought ever bothering my mind. It's always what I see. And so learning that that is how my brain works was really interesting. And it also made sense why, like, I always wondered in school, I'm like, I'm a pretty smart person, but I didn't do very well. And studying to me was always very odd. I was always like, what? But now it makes sense. Like, y'all can just pull up shit in your mind and look at it again. Like, oh, yeah. But I'm just, yeah, you can, like, ADHD very often hinders people's driving. And it's one of the reasons why I was like, why, and the research shows that people with ADHD always overestimate their abilities of driving. However, I actually have a clean driving record in my past. Like it's not something I just say. Like I'm actually, knock on wood, a good driver and like responsible, and I pay attention always, just always. And so for me, like I guess that's good. I guess it makes sense why teachers like used to, it would always, I would be like, why do they want you to close your eyes all the time in school? Like, like, why does that make people concentrate more? It never worked. And then the other thing that always never worked is meditation. So people be like, picture yourself on a beach, and I'd like close my eyes and it's black. And I'm like, I wonder if people, why wouldn't they just say picture a black room? Like to me, it was so obvious, but then it turns out y'all are seeing stuff when your eyes are closed. Also, I have no trouble sleeping. I can sleep immediately, never. So I like it. It's how my brain works. No comment, CRD. I also like driving, but um I do a lot of counting in my head uh as I do things. But you have to remember, like, I guess a lot of people, I'm saying you have to remember, people, like, I suppose you maybe organize yourself visually in your head. I really have no clue. Uh, there's nothing like that in my mind. So everything that I have to remember is either completely remembered with no vision or image in my head, but I recognize images extremely well. And I always recognize a face. Like once I've seen somebody's face in person and talked to them, I will always recognize them forever. Forever. But I will never ever be able to describe them. But when I see them, I will know, yes, that's the person I've seen or not. And so I think like my brain sort of just learned, because your visual imagery center develops very young. And obviously without it developing, you compensate in a different way. What was really intriguing to me is to find out that some people actually have no internal monologue or voice in their head. And to me, like, that's all I got. Like, if I didn't have that, we would be shooting absolute blanks here. So, um, also my daughter sees the pictures in her head. I've asked her about it. Uh, and have a friend who's a teacher. No, no, no. So, Cachette, if you say picture a stoplight in my head, up until I figured out that I had aphantasia, I would picture a stoplight in my head, which to me would mean like already as soon as you said stoplight, my brain is just sort of like ready for the next input of information. So I'm trying to figure out why you're asking me to think of that, what kind of stoplight you want me to think about. None of it is visual at all. I'm mostly just waiting for the next input. And then when I realize that I don't have visual imagery, what I think you can there's people, I guess, have varying degrees of visual imagery. What I have is absolutely nothing. Like there's black. Every time I close my eyes is black, and every time there, as hard as I think, it's black. But what that means is when you say picture a stoplight, I can do the same picturing task as much as my brain can with my eyes open or closed, talking or not. My brain is always going. Like picture of a stoplight on a sunny day means absolutely nothing to me. No. There's no I'm not I know what a stoplight is. I know what a sunny day is. But there's nothing in my head. So when you ask somebody, like if you're trying to diagnose or tell if somebody has this, what my friend who's a teacher realized, because she has it as well, is when she has classes of about 30 kids, she'll start to do a visualization exercise. And she'll say, go through the whole exercise just like she normally does. And then at the very end, she asks the question in a way that makes sense to somebody with aphantasia. So she'll say, okay, and how many of you didn't see any colors or weren't, like if somebody says picture green, I'm able to see green. I mean, there's no green. There's no green. There's no color, but I know what green is. Um, and I know what green things are, and I can describe things very well. I'm a great writer and I'm a great storyteller. And I think that's because I have no visual imagery. I have a lot of verbal imagery that I use. So I can paint sort of pictures with words, but not accurate pictures. I'm much better at like seeing a bigger picture and then making it easier to understand necessarily. So here's the thing also, in your brain, apparently, like, I guess some people can actually hear music again, little gifs all the time. No, like, I, yeah, I mean, I have memories, but they are tied to other sensations. So something that is like really triggering to me would be like smell. So, like a smell will take me back to a place. And that's the other thing I was going to say. So, apparently people hear music in their head, like the actual music. And I hear me singing music in my voice. And apparently other people don't have that. They can hear the song again. Just like you could replay like visual imagery, you have auditory um sort of recallability, and I don't have that same ability apparently. And again, it's why I don't have the most attachment to music. The songs I am attached to and enjoy always have been introduced to me by a person. And every time I hear that song, I think of that person, that situation, that thing, but I don't see any of it. And what else I found out is that people that think like me tend to gravitate towards each other. And so uh, I did this, realized that I was different a little bit and started asking everybody around me and found a bunch of different people around me that had the same sort of thing. And in fact, those people thought I was a little bit crazy for thinking that people could see pictures in their head. Like literally, I had a few family members be like, um, yeah, I think you're taking it a little too literally that there's pictures in their head. And I was like, I know it sounds crazy because if you can right now think of any sort of like saying that references visually recalling something in your brain, there's so many different phrases and things that I thought were completely euphemistic, and apparently okay, let's get this last one going.
Good morning. This is the detention docket for the 323rd District Court for Monday, February 1st, 2021. Complies with the Texas Supreme Court Emergency Order number 33. We are not conducting in-person proceedings. However, we're holding these hearings through Zoom. Comply with the Texas Open Courts Act. We are broadcasting these proceedings on YouTube so the public can have meaningful access to what occurs inside a public courtroom. No portion of this court hearing may be copied, recorded, or published. Violations of this order are punishable by contempt of court of up to 6 months in the Tarrant County Jail and up to a $500 fine. We want to remind everyone that this is a court hearing, so people are expected to behave appropriately for court. So please do not be laying down, using the lavatory, taking showers, consuming alcohol, or having domesticated animals cross the screen. People are expected to behave appropriately. Please have your cameras on, and please do not have bright lights behind your face, as that shadows out your face. All right, we're going to start with Tyler Blankenship. Tyler Blankenship. All right, Mr. Blankenship, I'm Judge Kim. This is a detention hearing. Law says when a child's brought in, you have to see a judge within 2 days. I have to decide whether to keep you here, release you. If I keep you here, you have to see a judge every 10 days while you're here. You do have a right to remain silent. You have a right to an attorney. If you cannot afford an attorney, we will provide one for you. We've appointed Mr. Willett as your attorney for today. I've not seen Mr. Willett, so I'm going to ask Ms. Hopkins to go ahead and substitute. Ms. Hopkins, good morning.
Good morning, Your Honor.
All right, Tyler, let's see. You're 16 years old. First came in last June for theft of mail. Organized crime. You received probation for that in July of last year. Then you were arrested New Year's Eve for unauthorized use of a motor vehicle. And then you were let go. But there's an affidavit of non-prosecution, so we'll see what happens for you there. So then, this couple days ago, Arlington Police brought you in. According to the report, you were a passenger in a vehicle. That was a traffic accident. And witnesses said you got out of the vehicle to put your property and hid it behind a brick structure by the traffic control device at the northwest corner of the intersection. Police retrieved the property at a teal plastic bag with cartridges of THC oil. You admitted to trying to hide the property. So now you're in possession of manufacturing or delivery of controlled substance from 4 to 400 grams. So you're looking at a first-degree felony. So you're potentially looking at, if this is an adult case, 5 to 99 years in prison over this. So, well, we give you a drug test and you were positive for marijuana. So you have pending cases, you're smoking weed, and it looks like you're dealing THC. So I think the only way to keep you here is the only way to keep you from using controlled substances and breaking the law is to keep you here. Do you have a parent here for Tyler?
Your Honor, I sent Grandma the link. She wasn't feeling well this morning, but she said she was getting on. So no, sir, she's not on.
Okay. All right. Stephanie, I think we're probably going to just tell Mr. Willett that I want to do this motion modified disposition pretty quickly. All right. And we'll just try and find days for him. So, all right, Tyler, just to let you know, I don't think probation is really working out for you if this is all true. And so
Your Honor.
Hold on a second, if I can finish my sentence.
My bad.
We're going to have to address this issue, and we'll have a hearing pretty quickly on whether you violated your one or more terms of your probation. If you have, they have to decide whether to keep you on probation or to send you to THJD. All right, did you have a question for me?
Yeah, I did. Is there anything house arrest? I wasn't selling.
Hold on, that doesn't sound like a question. So do you have a question for me?
Could you put me on house arrest?
No, you're smoking weed while you're on probation.
I didn't cut off my ankle monitor last time. I started quitting weed.
So you want a cookie? I mean, you're telling me that like you violated some of your probation, but you didn't violate others, so you need to get rewarded?
No, I'm just
smoking weed while you're on probation.
I quit. I failed my drug test last week.
You quit when you came to Kimbo, right?
Mr. Blankenship.
Yeah, these aren't questions, Tyler. So decisions have consequences. Anyway, so I'm going to go ahead and detain you. Thank you, Mr. Blankenship.
Thank you, Your Honor.
Euless Goodwin. All right, Mr. Goodwin, I'm Judge Kim. This is a detention hearing. The law says when a kid's brought to our facility, you have to see a judge within 2 days. I need to decide whether to keep you here, release you. If I keep you, you'll see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. You're not affordable. We'll provide one for you. Mr. Berger is your attorney. Good morning, Mr. Berger.
Morning, Judge.
All right, Euless, let's see. Saturday you referred, or Friday you referred by Arlington for burglary of a building. On Friday about 7:45 at night, they were dispatched for a burglary call at a storage unit. When they found you and detained you, that the husband had restrained. I'm guessing the husband of the owner of the storage unit. Let's see. Victim said when they arrived to their storage unit, they saw a black male standing near the unit. Wife unlocked the unit, opened the door, saw 3 male suspects rushing out. Pushing the wife caused her to fall. Husband grabbed one of the suspects to restrain him. Victims say that 2 pairs of Air Jordans, 2 iPads, iPhone 4, iPhone 5, and a Fitbit were taken. Total value was $1,300. Police report said that while they're handcuffing you, a Fitbit fell and recovered, which she said belonged to her. Storage unit manager made the scene, reported to police that someone had also been inside her unit, but wasn't sure if anything was stolen. Ulyss told the police that he and his companions entered the storage unit through a cutout in the roof and said Ulyss did provide information of other suspects, but not their name or his. And you had a runaway report. He was on probation for criminal mischief and burglary of a vehicle. But he was clean on his UA. Do we have a parent here for Mr. Goodwin?
Yes.
Okay, where's the parent? In the parent room. All right. So how long had he been run away for?
Just for that evening, but he's ran away 4 times since October, one of which was overnight.
Hold on a second. Ms. Hawthorne, are you in a moving car?
Yes, sir. I'm not driving.
It doesn't matter if you're driving or not. I specifically said at the beginning, please do not be in a moving vehicle.
Okay.
You can't be in y'all pull over.
Okay.
I told you not to turn your camera off either. All right, so I'm sorry, Mom. So he had run away the day before?
It was that day that he ran away. He ran away after he was into a fight. It was said by the officer at the school that it was a gang fight. And so after the school sometime, he didn't get off the bus. He didn't come home. We never heard from him, and that's out of his norm.
So the first time he ran away?
No, he's ran away 4 times since October.
All right, so what are we going to, what can we do?
He has previous charges. He's been to this court before,
Sure.
previously for arson and other charges. The last time he ran away 2 weeks before this last Friday, he stole 3 of my handguns out of my house. It's believed, I can only say it's believed that the boys that he was with has 2 of the guns and he's hiding 1 of them.
He's a menace to society and us. He needs to be somewhere where he cannot be around anyone. He needs to be locked up. He's a menace.
Your Honor, can I interject, please?
Yes, Mr. Ligon.
We just now received a report, within the last couple of minutes, for theft of a firearm. That has not been, that's not included in the offense report. I haven't even read the details on it. That's how fresh it is, but we did just receive it.
Okay. So, Mom, those weapons are not recovered, correct?
They're not recovered.
Okay. All right. Well, Ulyss, I'm not going to, whenever there's a gun involved with a kid, you know that I always hold them. So I just need to be careful about releasing children so they don't have access to the same guns that they were involved with. So I'm going to let you know now, until those guns are recovered, I'm pretty much going to keep you here. So if you want to tell your attorney on how we can recover those guns, so I feel like it's somewhat safe to release you, that's a really good start. But until then, I'm not going to put you on the street so you can go get a gun and then use it. All right? Thank you, Ulyss.
Thank you, Judge.
Thank you.
Your Honor.
Bria Heron.
I want to walk up my lobby meeting with their chief.
Bria Heron. Bria Heron. Well, Ms. Thomas, please call the detention facility and ask why they haven't brought the child over here. Brian Hyder. Hi, Mr. Hyder, I'm Judge Kim. This is a detention hearing. The law says when a child's brought to our facility, you have to see a judge within 2 days. I have to decide whether to keep you here or release you. If I keep you here, the law says you have to see a judge every 10 days while you're here. You You have a right to remain silent. You have a right to an attorney. If you cannot afford one, we'll provide one for you. Mr. Daniels is your attorney. Ms. Thomas, you called detention?
Your Honor, there's two. It would be Deanne Thomas.
Oh,
That's
okay.
her.
Yes. Deanne, have you called detention?
I'm in the process of.
Okay. All right, so Mr. Hyder, good morning, Mr. Daniels.
Good morning, Judge. And I'm not sure, is that Mr. Hyder or is that Tybria Hebron?
Tybria is a female, so that should be Fox F Pod. Are you Mr. Hyder?
Yes, sir.
Okay. All right. Thank you.
Okay, so yesterday about 3 o'clock, Fort Worth was working the gun show. There was an off-duty officer or a detailed officer working the gun show. 3 individuals known to be gang members were at the show. The Cedar Hill officer said the suspects were walking around holding firearms. And Fort Worth PD was able to identify that they are members of the Jug Team gang. And Brian was identified as one of the gang members in possession of an AK-47 pistol and detained. And none were stolen. So we have a 16-year-old kid walking around a gun show with a pistol. You have pending aggravated robbery and aggravated assault with a deadly weapon charges out of Dallas County. We have a parent here. Mom, do y'all live in Dallas or Tarrant?
We live in Cedar Hill.
You live in Cedar Hill.
Never had any cases against him in Dallas at all. Never been in trouble. And
hold on a second, Ms. Brazel, are you here?
Yes, sir.
Okay, so does he have pending cases in Dallas?
I spoke to Dallas County this morning, and they received cases on the 6th of January this month for an aggravated robbery and an aggravated assault.
Okay, Mom. So I guess
not correct. On everything I love, on God himself. That's not correct. They pinned that on him.
Mom,
Videos.
Mom. Okay, both of you need to stop talking right now.
Okay. You asked me a question. I'm sorry.
Just because you don't know about it doesn't mean it's not happening. Trust me, there are plenty of things that happen in the court system that defendants and parents are unaware of until after the fact. So even though you may not know about it, that doesn't mean there's not a case pending against them, right? So
Why hasn't anyone called me? It's been almost 30 days.
they're not required to call you until certain points. They don't have to call you because there's an investigation.
Okay, so if that's the case, there should be a parent involved or someone called because he's not of age. Why hasn't anyone come to me?
Because that is not the law. The police are not required to call the parent if they're doing investigation.
Okay, so there was a robbery.
This is Dallas County. This is a
You've
Dallas
never been in trouble with
County.
Dallas County.
About Tarrant County. Right now, it's about your son having a gun.
A police officer sold him.
I'm sorry. I keep on talking when you're interrupting me. So go ahead.
Go ahead.
Well, I'm trying, but you insisting. So please finish your question or your
Go
statement.
ahead. I'm gonna keep my mouth shut.
Thank you. So just because there's a case pending, so there's evidently an aggravated robbery and aggravated assault deadly weapon cases out of Dallas County that your son is part of. I don't know if it's just a warrant. I don't know if it's an investigation. I don't know if somebody just named him, but somehow he is part of those cases. And so we verified that. So when you say, I swear to God, it's not happening, before you swear to God, I suggest there may just recognize there may be things that you're unaware of that the law allows you to be unaware of. Right? So at this point, Mr. Hyder, my policy is whenever there's a child brought in with a gun, that I detain the kid. I need to know where the gun came from. I need to know if it's.
Did you know where the gun came from?
I'm sorry. There I go talking while you're interrupting. Go ahead, Mom. No. Go ahead.
Can I talk?
This is probably not the time you want to talk because your mom's just going to interrupt you too.
Sarcastic.
Okay. So, Brian, at this point, I'm just going to go and detain you because I'm not comfortable releasing you into the community like you are a danger to the community or to yourself. All right? So, Mr. Hyder, if you have a question for me, I don't mind you asking me a question, but if you want to tell me something, your attorney, Mr. Daniels, does not want you to tell me anything. All right? So, do you have a question for me or do you want to tell me something?
Can't get like house arrest or nothing.
Oh, you can, but I'm not going to.
I swear to God, I didn't do nothing. I didn't know.
Okay, all right. So I'm just telling you, you got picked up with an AK-47 pistol in your hand. And you're telling
I was holding it for a friend at the gun show.
All right, again, that doesn't sound like a question. And what I'm telling you is a child under 18 years old cannot be in possession of a firearm. That means care, custody, or control. And it looks like you had care, custody, or control of a firearm. Okay? So that's the thing you Dallas kids don't understand. When you come to Tarrant County and you have a gun, I'm holding you because I need to be comfortable about releasing kids back into the community if you have access to firearms.
That was the only access I had.
That's enough.
Was at the gun shop. I'm not gonna hold another one.
Again, your attorney does not want you to be telling me these things, but that is enough. It doesn't matter if you do it once or 100 times. Once is enough. All right. So, all right. Thank you, Mr. Hyder.
Thank you, Your Honor.
Main key.
Okay.
Jermaine Key.
Just give me 1 second.
All right. I don't have to turn the camera off if the kid's right there. Like, it's the only time. Like, that's a valid excuse. I mean, if you bring it in with you. All right, Mr. Key, I'm Judge Kim. This is a detention hearing. When the kid's brought in, you have to see a judge within 2 days. I have to decide whether to keep you or release you. If I keep you, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. I'm going to go ahead and appoint, Ms. Taylor has been appointed as your attorney. Good morning, Ms. Taylor. Oh, for Mr. Hyder, make sure you put a note about mom and kid attitudes. Did you use that word? Okay.
Good morning. Sorry.
That's okay. Mr. Key, you're 14 years old. You've never been here before.
Suggest that he, if there's no place.
Back on Saturday, police were dispatched for domestic victim,
That way he could be in
mother and mother's boyfriend. Told police that
mental health.
on Friday, you were suspended for school for being in possession of Xanax. For punishment, mom disassembled your bed, made a pile on the floor to sleep on. I already like mom. She also took away electronics and nice shoes. Mom woke up, found Jermaine sleeping in the brother's bed, would not get up. She got a belt, spanked him, made him sleep back on the pallet. In the morning, she had to get up for breakfast and told him that she was going to cut his hair. He refused to let her cut his hair and cut his fingers on the scissors she was holding. Then went to the kitchen, grabbed a knife, and acted like he was going to cut somebody. Mother was able to get the knife away. Short time later, Jermaine and his mother got in a fight, and the two fell to the ground. He struck his mother in the head and elbow, causing pain, so he was brought here. All right, so mom, I just want to let you know, I'm also a judge that does CPS things, and by law, you're required to provide him a roof over his head, a set of clothes, and 2,000 calories a day. Nowhere in there did that say you're required to give him a bed. It doesn't say you have to give him nice shoes. It doesn't mean you have to let him have the hair the way he wants. Mom, you are perfectly within your rights, in my opinion, for what you did. All right, just want to let you know, I don't think you, from what I've seen, I don't think you did a single thing wrong. All right. With that being said, Jermaine, you're 14, you don't have a job, you don't pay bills, you don't pay for the internet, you don't pay for gas, groceries, you don't cook. You're just kind of mooching off your parents right now. If you're mooching off your parents with a bad attitude, that just makes your situation worse. So, mom, just my question, in your opinion, does he need a haircut?
I just wanted to humble him, you know.
I understand. But there's all kinds. So, mom, one thing you have to understand about me is I really respect parental rights and I respect parental decisions. And there are all kinds of things parents do that I would never do, but I respect the fact that they're making that decision. Okay? So I'm not second guessing you. Mm-hmm. I'm just, at this point, I need to figure out if it's okay to release Jermaine. I don't know if he actually pulled out the knife, how much you felt like that was an actual threat. It seemed like you were able to get the knife from him, so it probably wasn't that big of a threat.
Yes.
But I need to make sure that you and your family is safe if I was to release him.
Yeah.
He's 14 years old. He's never been here before. Mm-hmm. These are kind of kids I'm inclined to release to the parents whenever the parents are comfortable.
Yes. It's not who he is.
Right. So my first question for you is, do you feel like your home would be safe if I was to release Jermaine to you?
Yes, sir.
Okay. All right. Does he have a history of running away?
He does not.
Okay. What are his grades like?
His grades are good.
Okay.
A's and B's. He does well.
All right. So then here's my next question, Mom. Where did the Xanax come from?
According to the school, I mean, it was on his person. He's saying he got it from someone.
Okay.
And I mean, this is the first time that's ever happened. That's not his history. So I think he's following some kids that he probably shouldn't be.
Jermaine, Mom, I'm interrupting you. So Jermaine, you have to understand, your mom and I seem very similar, that we have very hard line rules and things are either black or white. And either you follow the rules or you don't follow the rules. It really becomes that simple. Okay? So if you don't like it, that's just unfortunate that you're born into this world with a mom who actually is active in your life and finds it important to give you the structure. So, well, Mom, I will tell you, normally in this type of situation, I would hold him here and detain him, make him get to level 1 outstanding before I would consider releasing him, okay? And level 1 outstanding here, there's your set of rules. If you break the rules, you lose points. If you break small rules, you lose small points. If you break big rules, you lose big points. And then if you do what you're supposed to do, you get to level 1 outstanding, and then that shows me he's able to follow the rules. It makes me comfortable to release him. Now, I am willing to release him to you early because I like the amount of structure you're giving, but I'm afraid that it's not going to impress upon him how important it is to follow the rules. Okay? And so I don't know how you feel about this. And to give you an example of the rules, there are certain things like we have a rule you lose points for failure to comply. So our detention staff tells them, get in line here, and he has an attitude. Or if they tell him to stay quiet, then he starts mouthing off. There's something called do not associate. So if he associates with other kids that he's instructed not to, he would lose points. These are all things that kind of go back and translate to home, right? When you tell him to clean up his room, he needs to clean up his room. If he needs to sit down for dinner, do the dishes, not hang out with the kids you don't like. These all fall into place, right? So, Mom, I want your opinion.
To be honest, this isn't what Jermaine is going through right now. Isn't who he is. And I think he's just going through some things right now.
Okay.
He's not a bad kid. He's not a bad person.
Okay.
And I think he should be okay to come home. We're gonna do some things different, and we're gonna get back on track.
All right. Would you like us to give him a drug test?
You could. I believe school did on Friday when they caught him, and he didn't have anything in his system, they said, but I'm okay with that.
All right, Mr. Carl, let's go ahead and give him a drug screen, just to see. Because if it's true that he's telling his mom that he just held it and never took it, then they'll show up as a negative, and that's a good thing, right? So that just gives you more information. So it's also one more reason why Jermaine should be more truthful to his mom. So, Jermaine, I'm going to ask you now. I mean, I'm just going to lay this out for you. Would you rather just go home now with your mom and at the risk of coming back if your mom tells us you're giving her problems? Or do you want to earn your way back, get to level 1 outstanding, and then prove to your mom that you can do it here and then go home and do it?
I could go home now.
I'm sorry, I don't understand you.
I said I could go home now.
All right. Now you understand, Jermaine, this is tough. You're 14, you're growing into a young man. Okay? I respect that, I appreciate that. But you understand you're still 14. And your mom still has the legal, moral, and ethical responsibilities to you, right? And so you gotta follow it. Like if your mom says your hair's gotta be cut, then your hair's gotta be cut. You understand? You don't have a say in that, right? Jermaine?
Yeah.
That's a question to you. Do you want to answer the question?
What was the question?
Okay. So you're 14 years old, and your mom has a legal, ethical, moral responsibility for your upbringing and to teach you how to grow into a young man. Okay? So she calls the shots. You're still 14. You're still a kid. At the end of the day, if your mom says, I'm cutting your hair, you understand she's cutting your hair, right?
Yeah.
That's a yes?
Yeah.
That's a yes?
Yes.
Mom, I'm changing my mind. His attitude
Yeah,
is just
maybe
not
he
right.
does need to stay.
Yeah,
His whole demeanor is
right. No, I
really
understand.
fine.
Mom, I really respect you. I admire you. But at this point, Jermaine's making decisions that he's trying to flex for me.
Yeah,
It's
he's
not,
got a little attitude going, so maybe he does need to stay.
yeah. So, Mom, even no matter what you said at this point, I would detain him. So, hey, Jermaine, you just made a bad situation worse. I was ready to send you home, but if you're gonna have this attitude, we'll see you in 10 days. If you're level 1 outstanding, I'll consider releasing you. Thank you, Jermaine.
Okay, Your Honor.
Thank you, Ms. Taylor. All right, Ms. Taylor. I was ready to.
We'll try again.
Defeat snatched from the jaws of victory.
I know. Thanks, Judge. May I be excused?
Yes, thank you, Ms. Taylor. Daniela Morales.
Your Honor, I don't see Foxpod logged into.
They're in the
call
waiting
yet.
room. I'm trying to figure out why they just tried to join now. All right, Foxpod. Foxpod, are you there?
Yes,
Okay, so my question is, where have y'all been?
sir.
Yes, where have y'all been?
We was
No,
trying
I'm talking to the security control.
we was trying to get on because we was just getting out of court with Judge Porter.
Can you call Judge Porter and see if he just let out? Okay. Y'all not have another computer? Y'all should have 3 computers back there.
We got another computer over here. Copy back console. Zach?
Who's on the radio there?
Mr. Johnny.
Okay. Hello, Mr. Johnny?
Mr. Johnny.
Mr. Johnny?
Yes. Yes, sir.
Okay, I'm trying to figure out, don't y'all have 3 computers back there?
No, I'm on the girls' part. We got one on H.
Can you turn your radio down? Because I can't hear you with the radio.
All right, we got one on H pod, one on the girls' pod, and one in the back. But I think they're not using the one in the back, so I'm gonna get it brought over.
Can you turn your radio off, please?
Yes, I did. Okay, so we got one in the back, one on H pod, and one over on F pod with the girls. We're gonna get the one from the back since they're not using it, brought over to F pod for the girls.
Right, so why didn't y'all do that 30 minutes ago?
Because they were using it in the back a minute ago.
They were using it back with who?
They had a kid with a 930 court going on.
So then what happened to the computer for F-Pod?
That's the one they're using now. It was on.
It was on.
Yeah.
But somebody just told me that this computer was being used for Judge Porter up until just right now.
Yes, the one computer they have over here.
So what about the one in the back?
That's what they're about to bring over now. They were using it for a 930 court, but they're bringing it now.
So they were using both computers for 930 court?
No, they were using this one for over here with the girls. The other one was being used in the back for 930, and then the one on
Right. So this computer here, we started at 10:30.
Yeah.
Why weren't y'all here?
We were here.
No, because I called.
Oh, they're saying they were.
Curran, and this computer wasn't even logged in.
They were in the wrong courtroom, they said. That's what they're telling me here.
How are they in the wrong courtroom? But we've been doing this every day for over a year, right?
Child that was on Judge Porter, and once we logged out, we was trying
Who is talking right now?
Jasmine.
Jasmine.
Jasmine, the child?
No, Jasmine, the staff. She was the one over here responsible for the court.
Okay, so we started at 10:30, and they went to the wrong link.
Judge Porter.
Okay, so this is what I'm trying to figure out. There's 2 computers back there, only one was in court.
Yes, but the normal practice is they keep one in the back for the kids that are 10 days general population. They keep one on the quarantine part, one on the system. For 3 different areas.
But one wasn't being used.
Sometimes 2 aren't being used.
Yeah, but today one wasn't being used. So why didn't they take this one over here?
Normal practice is not move it, they just do it because of the way that they're quarantined. So they normally leave one in the back general area, one in the quarantine, and they want to use. Because right now, like that female is still a small room, so they only have that one room for a female.
But when you know this kid still is a hearing going on with Judge Porter at 10:30, like, because they just joined the waiting room like 10:58, 10:57. So it's been 30 minutes. They're sitting there knowing that detention hearings are going on, that they leave a computer sitting around, right? Like, you see my problem with this?
That, I can't. I mean, I know they're big concerned is the moving of kids. They don't want to move the females to that general area.
Yeah, I mean, ultimately the alternative is if they don't want to move the females to that area, we have to go in person, right? I mean, really, the one thing that just torques me is for an agency that's in possession of a body, right, of a child, the child cannot do anything. You'll have to bring him to court, right? And that's one of my pet peeves that has been for day one. Like, it is, like, I will always get upset with JPD for not bringing the child. Like, you'll have to do that, right? Okay, so looking forward, how do we fix this? Why didn't we do that today, though?
We don't have any film. The thing is, they only have 3 laptops.
Well, why couldn't they bring that other laptop that's not being used to EchoPod? They don't want to move it because they know they'll have more detention hearings.
So say, for example, Parker was in the kitchen. You know, he's on that quarantine. Say if we had a large body, he had some more kids in the back. They wouldn't move the one from there to the other unit, especially if one kid has a knife in the room. And then they have a chance to work with the laptop like both. One way we try to have a spice ready to have more laptops into another area. Now, in that area, unlike the other units, it does have different rooms, so they could possibly have more than one cell at a time. But like the E, F, G, and H, there's only one room.
Okay, so then my question is, if we know, what time did the hearing in front of Judge Porter start?
I was in the parent court, I didn't tell you that.
So it went for an hour and a half?
They were pretty behind. Oh, wait, yes. Yes, it really did.
Okay.
Is it, that's fine.
So if you know it's contested modification, why are we tying up that room knowing detention hearing started in an hour? Like, this is what I can't figure out is how everyone here waiting for 30 minutes for this one child, and it's not her fault because she can't do anything. It's detention's fault. I mean, you have to point it out to where it is, right? And that has always been my biggest pet peeve. Sheriff, detention, police departments, whatever. It's if you're holding a person, like, that is your responsibility to bring them to court because they can't do it on their own, right? I mean, it's not fair to the child. Like, if they're showing late to court, that's, that own person's fault. And you get the consequences of the court knowing that you're late to court. If you're in custody, you don't have a choice. That's not fair to them. I don't know. I guess I'll email Jesus and figure out what we can do. But I mean, this can't, like, the other alternative for me as the court is just to do in person. Like, every single one is in person. And when Judge Whitley and Judge Evans and Nathan Hecht of the Supreme Court asked me, why are we doing this in person? I say, because JPD cannot bring the person to Zoom. And that is exactly the reason I'm going to give. It is our juvenile probation's fault because they cannot bring an inmate over onto a computer. They can't bring a computer to an inmate. And that's why we have to go in person. It's been a consistent pattern. Like, I don't know why H-Pod is fine. F-Pod is the one that consistently has problems every week. Right? We can't go a full week without a problem with Foxtrot. So, yeah, I'm not mad with you guys. I just can't figure out why H-Pod can get their act together and do it, but F-Pod can't. Right? They can't. I don't know if it's a staffing issue or a logistics issue, a facilities issue, but that's the one. If I know there's gonna be a problem, it's gonna be Foxtrot Pod. All right? Okay. All right, well, thank you. All right, so are you Daniela? Are you Daniela Morales?
Tabria Heron.
Okay, you're Tibria Hebron. Y'all missed Tibria. This is time for Daniela Morales.
Okay.
Can we bring Daniela Morales, please? You know what? We're going to do all the females in person. So just get them ready to come in person. We're going to do the males. If you're an attorney for any of the females, I'll have Zoom on and turn the camera around. All right, so we'll go Ashton Nichols. Is that male or female? Is Ashton Nichols? All right, Mr. Nichols, I'm Judge Kim. This is a detention hearing. The law says when a kid's brought to a facility, you have to see a judge within 2 days. I decide whether to keep you here or to release you. If I keep you here, you have to see a judge every 10 days while you're here. You have a right to silent, you have a right to an attorney, and we have appointed Mr. Green as your attorney.
Present, Your Honor.
Hello, Mr. Green. Mr. Nichols, let's see, you're 17 years old. You're on probation for possession of controlled substance, 1 to 4 grams of penalty group 2. You just went on probation in October. All right, so we issue a warrant for you in December because you're arrested for drug charges, adult drug charges. We issue a warrant for you, but you were released from jail because your friends posted bail. You did not return home after being released. We had no contact with you. We tried to reach you through email and cell phone, no response. You were not complying before your arrest on your probation. In November, you brought evidently a taser into your home and threatened to tase your dad.
Yes, sir.
And so Dad said that you told him that you really wanted to buy a gun, but unable to do so because you're under 18, so you bought a taser instead, saying that you need it for protection. And they're saying that your parents scheduled an appointment for drug assessment, a psychological evaluation. You refused to go, saying you didn't need it. You've been uncooperative at home, hostile, refusing to follow curfew or house rules. You were supposed to find a job as part of your probation, but you quit your job. And parents are saying that on social media, it looks like you're selling drugs. So, and you're positive for weed. Wait, no, did we not give him a drug test?
I'm going to take one today.
It's not your turn to talk. So, Mr. Tanya, Ms. Lide, did we give him a drug test?
They attempted, Your Honor, and staff indicated that he was not able to provide a sample.
Okay.
Came in.
All right. So, Ashley, I'm going to let you know when you refuse to provide a sample, and I just assume you're positive for everything. So, whether it's your heroin, your PCP habit, your fentanyl, whatever, you're just using all of it, so that's why you're hiding and not providing.
No, sir. I'm taking a test today.
The way I'm looking at it is, it seems like you're violating the terms of your probation. I'm going to go ahead and detain you since you're not.
May I say something, sir?
Mr. Nichols, I'd advise you not to talk when the judge is talking. Okay.
That doesn't work out for you. So, but the fact that you got arrested for a charge, you didn't call our probation officer to let them know that this is going on, and then you refuse to respond to contacts while you're on supervision. That's just absconding. So I feel like you're not going to appear for court. If we have further courts, I'm going to go and detain you. I'm also going to let you know that since you are 17 years old, it is at my discretion whether I keep you here at Kimbo or I send you downtown to the adult jail. If I keep you here, then I'm expecting you to be level 1 outstanding. If your level drops, I will send you downtown and you will sit there until our cases are finished. Just so you know, on a juvenile case, you cannot bond out. There is no bond for juvenile cases, so you will sit there until the case is done. Right now, I know you were trying to say something. If you have a question for me, I don't mind answering your question, but if you want to tell me something, I'm pretty sure your attorney does not want you to tell me anything, all right? So do you have a question for me?
Can I go ahead and not listen to my attorney and talk to you directly, sir?
Well, everyone has a right to ignore the advice of counsel, but I'm telling you, you probably don't do it. I'll also let you know that I'm not going to change my mind. So if you feel like you're going to talk me out of it, it's not going to happen.
Okay, I don't feel like I'm going to talk you out of it. I just want to explain to my PO and that my parents are listening. I just want to explain the situation better. I understand that I'm being detained. That's fine.
Okay. All right. So thank you, sir. Please get your behavior level up, and then we'll figure out what to do from here. One piece of advice is you may. Well, no, I'm sorry. I'm a judge now. I can't give legal advice. So
can I say something?
Yes, sir.
So. I was arrested for those charges in November, correct? And I was brought into Tarrant County Jail in Fort Worth, correct? And they released me, and they didn't tell me anything. And I was outside. It was around 10 p.m. I was outside. I called my parents 3 times on the jail phone, and it didn't answer. So I had someone else come pick me up, and I stayed the night with them. And then I was planning to go home, but based off of phone calls with my parents, I didn't feel welcome to go home, so I was afraid. So I wanted to prove to them that I could take care of this on my own. And so January 11th, I went to the DMV to go get a new license so that I could get a job. And I also knew going in there, if I had a warrant, I would be arrested that day, but I wasn't. I just want my parents to know that I didn't go home not to run from them, but I wanted to come back and prove to them that I was doing the right thing.
I understand. And while that may be very noble, when you're on probation, you have to stay in contact. And let your probation officer know if you ever change addresses. Right. So can I explain this? So well, you know this isn't your hearing, right? Like we're not going to decide what happens. I know. I just want my PO, my parents to understand. That's all. Okay. Well, I mean, I think they get the picture that you may have had at least noble intentions. Well, I was also like you're saying, like I didn't keep in contact because I had no phone. I had no way to contact anyone. They didn't tell me to contact anyone. They didn't tell me. They just threw me out on the street. All right, stop making yourself a victim on this one, Ashton. Okay. I'm not. No, I'm not trying to. So you're staying at a friend's house, and they don't have a phone. People paid money to a bail bondsman to get you out, and they don't have a phone. No one bailed me out. They didn't say I was bailed out. They just threw me on the street, sir. Now you're lying to me because when you sign. I'm not lying to you. Honest to God. I'm not lying to you. When you're in jail and somebody bails you out, you have to sign a piece of paper saying that you understand the conditions and that you have a court date. You have to stay in contact with the court. Like that's you signed. Okay. Well, can we please go look at the footage because that did not happen to me, sir. I promise you. On hand to God. Right hand to God. Like, I don't know why we look at the footage. Because I don't know either. Because you're missing the point here. I'm not lying to you, sir, and you're calling me a liar.
Mr. Nichols, I'd advise you not to be discussing this in this forum till we could talk, okay?
All right. All right. Thank you, Mr. Nichols. Thank you, Mr. Green.
Thank you, Judge.
Lewis Parker. Mr. Parker, how are you? This is a 10-day hearing. You know what it's like. I got to decide whether to keep you or release you. Your mom was here earlier, but she couldn't follow the rules. She kept on turning her camera off, and she was in a moving car. And on Zoom, I don't allow that to happen. Did you get time with your dad this weekend?
Yes, sir.
How was that?
It was good, sir.
Dad, everything worked out okay?
Yes, sir, it did.
I don't mean this negatively. I really don't. I wish you had been around more so you could see changes in your son, because I've seen changes, right? And I know it wasn't your choice. I'm not saying it's your fault. I'm just saying if I could go back in time, that's kind of one of those things that if I was a genie, I could just turn back, you know? I've had you around more. I think you and your son both feel that way. So, all right, well, I'm glad. Dad, you picked him up on time, got him back on time?
Always.
Always, okay. I'm just curious, Dad, like, so what if I was to release him? I mean, do you have a spot for him?
And honestly, I do not have one right now. And Monday I'll be starting truck driving school. It's Monday for sure this time. It's been a process trying to get enrolled, but this Monday coming up.
Okay. So
started from the bottom.
Okay.
And Judge, if I may, I think that they've got a spot for him in Mahia now.
Does he need to, or is he going to finish our localized treatment?
I think they had a problem. There was a gap in it, and he forgot what they had taught him. I believe now they're ready to take him at Mahia. They just need a negative COVID test.
And Your Honor, that progress report is probably on its way to you. I typed it Friday and turned it in electronically.
Okay. All right. Thank you, Ms. Thomas. All right, Parker. Well, I get to detain you for now, okay? But keep on doing the things that you're doing because you're doing the right things, okay?
Yes, sir.
All right. Thank you.
Thank you.
Thanks, Judge.
Thank you, Mr. Hall. Xander Walensky.
Good morning, Judge.
Good morning.
I believe one of his parents, his mother, is there in person, and his father is available via Zoom.
Right. Hey, so whoever's on Fox Pod, we're doing all the females in person today. Like, I know she's sitting there, but y'all should probably be lining up in this holdover next to the courtroom. Okay. Right, do we have there we go. We have Mom.
I'm here as well.
All right, hello, Dad. Hi, Xander. I'm Judge Kim. This is a detention hearing. You know how it works. When you come in, you have to see a judge within 2 days. I'm deciding whether to keep you in custody or release you. If I keep you here, you'll see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. And we have appointed Ms. Hopkins as your attorney. Good morning, Ms. Hopkins.
Good morning, Judge.
So, Xander, you've been here as a runaway 1, 2, 3, 4, 5, 6 times. And you are on probation for aggravated assault with a deadly weapon. It seems like you always refuse to give a drug sample until this time. You tested positive for weed. So you're on probation for a felony. You're using weed. Let's see. According to Dad, last week he saw you smoking weed on the back patio. Prior to that, just a few days, she reported that you had weed delivered to the house while they were home. So we issued a warrant for you. You turned yourself in without incident. You refused a drug test on Saturday, and then you finally submitted a sample on Sunday.
Go on.
Mr. Walensky.
So Ms. Gonzalez is requesting to be detained pending placement at TYRC's inpatient drug treatment program. Ms. Gonzalez, can you give me any kind of peer-reviewed study that shows that drug treatment works for marijuana use?
At this time, Your Honor, no, and I was waiting for you to ask that question. But our initial plan was to actually have him enter the FPP program, and he was actually supposed to, I believe, be enrolled today, this afternoon, with outpatient as another service to kind of help support his substance use or try to, hopefully decline that use. But in speaking with the parents, they felt that he needed to be placed in inpatient drug treatment rather than participate in those programs at the time because he's continued to use while on EM.
So ultimately, what do you want to do?
Well, I've spoken to the director at TYRC, and they do have a bed available for him. But as you know,
TYRC is for the drug treatment, though, right, Ms. Gonzalez?
That's correct. That's correct. And so, go ahead. I'm sorry.
Yeah, I'm sorry. But I'm using marijuana. That's just a choice. It's not. I see nothing that indicates it's an actual addiction that can be treated. So if he's just insisting on doing it, then TRC, like, there's no reason why we need to spend county resources on changing behavior that Mr. Walensky does not want to change. Right? So, like, y'all are gonna have to convince me on this one. Like, I'm not sure I'm gonna order him to TRC. Like, if there's another alternative, I'm all ears. But the sobriety rate for marijuana use, 1-year sobriety rate is gonna be 18%, right? Mr. Walensky, I see your hand raised, but I'm not sure. I mean, we're just kind of talking about what we're looking at potentially happening to you. But
Can I please just say one thing?
your attorney doesn't want you to say anything. If you have a question, I think she's okay with you asking me a question, but if you want to tell me something, she's not okay with that.
Your Honor, if I may.
Yes.
In regards to marijuana addiction and the treatment that he would receive, whether it is outpatient or inpatient, when it is a dual thing and includes individual counseling, that can get to the issue of why there is there.
And that, you were absolutely right, Ms. Hopkins.
We may be able to, the treatment is, it can help and it can lead to not using anymore. I'm currently trying to find a survey for you, but as you know, and additionally, Your Honor, if he was supposed to start that FPP program this afternoon, if he is here in detention, he will lose his spot for the FPP. And if he does that, then he's back at the bottom of the list and we're not doing anything to help this child. I would strongly encourage you, Your Honor, to consider releasing him so that he can start FPP this afternoon and or get into that treatment facility.
So, but Ms. Hopkins, you're absolutely correct, but when you do a dual focused treatment program for THC use, your 1-year sobriety rate jumps up to 28%. I mean, that's what else? You bat 28% in baseball, you don't make the Hall of Fame. I mean, you can't. That's
We're
how low
not
the numbers
here
are.
to make the Hall of Fame, Your Honor. We're here to help this individual get the treatment and help that he needs. I mean, that's why we started him on FPP. If the whole idea of this system is to assist the kid and not have him reoffend, then we have to get him treatment and we have to help him through that.
Mom, your hand is raised.
Yes, I'm sorry. Judge, can I say one thing about that TH deal? Because he was tested before. He's been in the hospital for using other drugs. The only reason he's not using drugs right now is because he's home. But he has used other drugs several times. Don't shake your head. That's not sure you know it.
Mama, I want to tell you, Mama, can I just say something?
No. That's not the time. Your attorney does not want you to talk.
Judge, can I say something?
Yes, Dad.
I believe the dad wants to.
Yeah, so I understand what the lawyer's saying. I disagree with what the lawyer's saying, and here's why. We bring Xander home. It's like it starts all over again, and it continues and continues. Xander needs to be taken out of that environment and put into an environment where he can actually have a clean, sober living, and also get help counseling, which is what the probation officer told me, in an inpatient type situation, out of the situation that he's in with his gangbanging friends and people who are smoking marijuana. You bring him home, it's going to start all over again. And that's what we're trying to stop. You can put an electric monitor on him. You can do whatever you want. When he's home, it's a whole different ballgame.
I mean, he even told
It's inpatient treatment away from everybody, away from his gang-banging friends, away from the people who are providing marijuana for him, completely out of the situation.
Dad, you understand, all the studies, I cannot find any studies that really treat marijuana use. right? It's a choice. It's not an addiction.
It's,
And so if that's the case, we send him to treatment, whether he succeeds or fails. When he gets out, if he hasn't chosen to quit using THC, he'll just go back to it.
and other drugs, and other drugs.
Yeah.
Other drugs are different. Other drugs, there's all kinds of peer-reviewed studies that show whether it's heroin, cocaine, methamphetamine. Like you can treat those. Marijuana is not an addiction; it's a choice.
But I believe he'll go on to the other drugs. I mean, being a principal and seeing these teenagers and not getting the help they need, they always ended up somewhere. I mean, I had three of my students.
Mom, you're preaching to the choir. Like I'm with. Like you're not convincing me of all this. This is stuff I already know and believe.
Can I say something?
Yes, sir.
Okay, so it was my understanding that going to an inpatient treatment, it wasn't just for marijuana usage. It was also counseling and trying to get to the root of the problem and fixing the root of the problem away from the situation that he is currently in when he's at home. In other words, away from the gangbangers, away from the people who are bringing him drugs, and getting counseling to an area where somebody can get to him and find out the root of the problem and fix it.
All right. So this, I've made my decision on Xander. What I'm going to do is, Ms. Hopkins, I understand an FPP may actually help with the behavioral issues that we're more concerned about. But back in September, he actually tested positive for methamphetamines when he came in here, right? And even though he's not positive right now, it's only weed. I don't know if he's not using other stuff while this is pending. So I want to wait. I want to detain him until I get the results of a hair follicle test, right? The street drugs really gets me nervous about this child, right? And so if he's clean, then I'm open to all kinds of ideas. But if he's dirty for hard drugs, we need to look at a placement. I mean, that's just, either we do this now or he's going to have to try and do this as an adult. Xander, if you have a question for me, I don't mind answering your question. But if you want to tell me something, your attorney does not want you to tell me. Right. So you have a question?
I just want to say one thing to my mom.
No, hold on. No. Your mom can call you on the phone. You can tell her directly, okay? This is not a chat room. All right. Thank you, Xander. All right. So at this point, these proceedings have been open to the public under Article 1, Section 13 of the Texas Constitution, which provides the public meaningful access to court proceedings. However, the Texas Family Code specifically states in 54.08C that when a child is under 14 years old, that the court proceedings should be closed to the public unless the court finds that the interests of the public or the interests of the child are better served by opening these proceedings to the public. Unable to make such a finding, I will now discontinue the live stream of this Zoom hearing to prevent public access.
Are we done, Judge?
It'll be a 20-second tape delay.
Judge, are we done with Xander?
Well, what we have is, let's see. Oh, no, this is a female. So, yes, I need Ms. Hopkins. Can you?
Oh, Judge Kim. You're a funny guy. That is the last of the hearings that we're going to watch for this evening. It is late / early / my leg's going to crack there one. Okay. My computer is just like begging me to leave it alone, but thank you so much, Cha. Thank you so much, Amy. Thank you so much, everybody who's been here tonight and who's shared with us or had a good time. I'm working on many things in my brain, but I don't see any of them. So, sort of hard to keep a list. I work best at night though. So I know I don't shame myself anymore for being up late. I super appreciate all of you guys and your like interaction and your encouragement. It really keeps me going and makes me want to do more and better and have more fun with you online and do cool things. But the reality is that we're coming close to the end of Judge Kimmy Kim, but not forever. I think what we're going to have to do is incorporate rewatching some of these over and over again, but like once a week or once every 2 weeks, maybe. You know what I mean? But what that means is that we're on the lookout for the next best thing. I have a number of ideas, but I also I'm always open to other ideas, obviously, is what I'm trying to say. So I will be in the Discord. I will put yeah, I'm just trying to it's hard for me because I love watching court all day long, just like most of you guys do. And I also want to record certain things and I want to, there's so much I want to do. If I had 10 computers, I still would probably want another one. But right now, I just want like a little bit of a different computer. Anyways, I'm not going to complain. What I'm going to do is learn how to do better. Probably a good start with not doing 7-hour live streams, except I love them. I love hanging out with you guys. That's the truth of the matter, is that I enjoy waking up, hanging out, going to bed, sleeping around all of you guys, Anyways, okay, listen. Tomorrow is Friday / today, right? It's Friday. So we have a number of things to do. I'm literally thinking about it in my head. I appreciate all of you that accept my ADD. I really do. I know I can be a lot sometimes. So when people say that to me sometimes, I often think to myself like, yeah, imagine 24/7. Did you send me one, Cha? Thank you so much. I also did the one, like your other one you sent me today was really, really good too. So good. I love, love, love that Travis County one. If again, I just need to get my computer situation sorted out and then ideally I could do Travis County regularly, like one day a week as well. I'm thinking about doing like Manning one day a week and then traffic court one day a week, lives in the evening. You know what I mean? Anyways, I will be looking at all of them. The great part about Discord is that it doesn't disappear as easily. So feel free to send me a message. And then if I don't respond, send me a message again. I'm forgetful sometimes, but well-meaning, and I get things done like a ninja really fast. So when I manage to do it, I get a lot done. And when I get a lot done, we go places. So, I'm going to work on my story of Judge Kim, which I think will be fun. I think we're going to do a members only coming up as well, but I haven't decided yet exactly. I'm thinking Sunday, but I don't know what people feel about that, but Sunday evening possibly. It would be a mandatory staff meeting, obviously, for kitchen members. So I have good expectations for the response. Search YouTube a crazy divorce case. You know, one day, Wacky, I really hope that my channel comes up when you search that. Dude, remember, we have that other lady's divorce coming up too. It's gonna pull out of the dark and haunt me too. But she's coming back. You know who I'm talking about. I don't want to say her name or else she'll just appear. But I'm on the lookout for that other court case that we are following up on. Yes. And I appreciate all of you. Um, yeah, it's been such a crazy evening, but I enjoy it as well. You thought what was a restaurant? McDonald's Saga? Oh, oh my God. Look how long that took me. Oh, sometimes processing in real time is so embarrassing. Okay. I don't want to do that, to be honest with you, for two reasons. I think it's been well covered at this point by a lot of people that have a good differing opinion on the subject and a number of channels. I believe it was Natalie that did it in conjunction with his wife or ex-wife and like really tried to like be respectful of that. So that situation is terrible by all means, but um yeah, I barely have patience for the divorce lady. Although remember we found out belatedly how long that case was and I was already in it. I that happens a lot as well. Um it's not that I'm not into divorces. I am into divorces. What I'm not into necessarily is like exploitative people taking advantage of kids, and that's not ideal for that situation. Also, I want to be known for, I don't know, something crazy adjective case. Not necessarily, it's like the day to day, every day court is crazy. That's why we watch it like we do. It is way, way more entertaining than like reality TV or anything you're going to get on TV. So, ideally, like I'm just learning and trying to figure out the best ways to curate the best courtrooms for us all so that we can enjoy them together the way that we want to. And part of that is I have to go back up and read. Um, Part of that is me just learning how to do it. What McDonald's? Oh, about your street name? Amy, is that what you're talking about? Here's the funny thing about that, which, so do you understand? Hold on one second. Let me just do one thing. Do you, what I'm talking about when I say people on like adult websites have that as their, I'm trying to find something funny to pull up here for you guys. But people have on their like if you don't want to be identified but you need to put in something in your profile, North Pole is like really, really great because nobody can actually know where you live. And so you're pretty anonymous. And I find it hilarious to think of you living in that actual town. And then what I think would be hilarious, because there's got to be a subset of people that are stupid enough to just show up in this town after like seeing on FetLife or whatever websites, like, oh, all these people live in the North Pole, I'm just gonna go on vacation up there. And then I just it would just be hilarious to me if your town had this like weird problem that they could never really pinpoint the cause of. like, oh, we do get this very odd influx of weirdos. And oh, Amy's like, no, no. She's talking about the McDonald divorce. Let me read back up. How far back up was it, Amy? Why don't you just type it again? That would be so much easier. If you don't mind. Well, and then she's saying, never mind. My brain is not working. Not many people, but lots of space. Oh, in Alaska. Well, that's probably good because if these guys were showing up on your doorstep, you probably would want a little bit of extra space. One day I'm going to do a members only with some funny videos that I've received or messages that I've received on different websites that are completely inappropriate and forward and out of control and just like unbelievable in a way. Also, um, yeah, and that's why I think it's so funny, Amy, because no, they would not be disappointed. Like these people are going to be the dumb de la dumb, the dumbest of the dumb guys because like if I saw North Pole in any chat anywhere, I don't ever think that their person is from the North Pole. So to me, it is beyond hilarious that some like, and that's why it's so comical for me to like, I don't picture it, but my brain imagines this like scenario where your town gets overrun by all these stupid, horny idiots who are too stupid to figure it out. Anyways, yeah, my brain is crazy. Your town is 1 mile long. I live on an island, which is long, much longer than that. But my town is not that long. Um, I don't even know what a mile is, guys, to be honest. That's the other thing. We don't we don't measure in that. So, but we have so much product integration that sometimes it's almost impossible to figure out what metric or what unit of measurement your device is in. Usually I just default on the side of like whichever is going to give me more credit. Like if I'm jogging and I'm like, oh, has that only been whatever? And I just go with whatever's further. Wait, Roberts, then Vancouver. Enjoy the gardening, wacky. Um, Vancouver is a great city. I haven't been there that much. It's weird, but I'm from Vancouver Island, and although it's extremely close on the map and just a ferry ride away, it is not a trip that I make very often at all, if ever really. So, um, it it's as foreign to me as it is to some of you, I would imagine, but I've been there a few times, but the island I've traveled quite a bit on, and it is very beautiful. There's lots of ocean and nature and rainforest. and mountains. But then there's all the like, cougars, but there's no snakes here that are poisonous. We have no poisonous snakes, which is one of the greatest parts about this island. No poisonous snakes. So, one of the things I love. I also love you guys. We do have bears. Yeah, we have bears. We have bears and we have cougars and we have beavers. We have wolves. We have. If you guys have ever watched the TV show Alone, 1.69 kilometers, 1.609 kilometers equals 1 mile. So that means, yeah. So it'll probably say on my whatever 1.6, and I'll be like, oh, I've done 1.6 miles because I'm a fucking liar to myself. So even though I'm probably well aware of that, conversion is going wrong. I choose to do it wrong for my own gain in my brain. We have some of the most unique, actually, hold on. We'll do one last little thing. I gotta be really careful though, because I do not want to get copyright struck at this hour. But, have you guys ever seen the television show Alone? It was on the History Network. And they've done a number of different seasons, but they were on, they went to different places, but for the most part, they were on Vancouver Island, where I live. And it is very dense. Let's see. What I'm going to do with this, oh, it's a minute long. Ugh, YouTube Daddy owns it. YouTube Daddy, I don't want to hurt. I don't want to make anybody mad. Can you just let the people watch this clip for 1 second?
We're at the northern tip of Vancouver Island. It's a very rugged coastline. It's very challenging in terms of the environment and the geography.
I don't want the music to get copyrighted either, but I'm just that landscape. So this is the northern tip of the island he's talking about, and I live on the southern tip of the island. So it's even like places, there's so much that not only I've never been, but anybody's ever been on this island. It's crazy.
Geography and just getting around from place to place. This vast landscape. In some areas you could walk for days and not see anyone else. I think that sort of sets us apart from many parts of the rest of the world. In the wintertime, a lot of wind, a lot of rain, nonstop. It's a test of your mind and your resilience to just sitting there looking at rain all day long. You really need to be prepared for those long winter months. You need to have some fear of dangerous animals to come across. There's the black bear, and there's cougar, and there's wolves. And sometimes you can get that sense that, geez, it feels like something or someone is watching me. Obviously, the first step is to get themselves set up with some form of shelter, especially in the environment that we're in with the wind and the rain.
So, although we're on the southern tip, we still get the wind and the rain very often too. So it's very, very, very wet. And Amy, I think it is sort of like the Inside Passage because the northern tip of Vancouver Island is where the cruise ships sometimes do go on the inside, which is I think called the Sunshine Coast of BC. And then I think maybe I'm wrong. But anyways, let's just finish watching the rest of this part. But this is like you can also see the coastline is also very, very rugged and rocky and sharp. And so it's very, very quickly very overwhelming. I was a Girl Guide and I did a lot of camping and outdoor stuff throughout my youth on the island, not realizing just quite how unique that was until I grew up and realized, like, oh, this is like really unique. This is what people really like.
The next immediate challenge is that sense of loneliness that you have and the tricks that your mind plays on you. Your mind does crazy things when you're all by yourself and it's very dark and it's very cold and it's wet and it's windy and you just want to be somewhere else. If you can't handle being there by yourself, you're not going to survive very long.
Last one, and then I'm going to bed, guys. Well, I'm not going to go to bed. I'll be a mess. I'm going to do, but this is the last one. Then we're off the tubes. My computer's like, I don't want to. You were gonna not.
Getting up early on Vancouver Island sure comes with great rewards. You don't want to miss the magic that happens here every day. This is a place you have to experience. It beckons you to get out there and encounter our wonders up close. Or, better yet, feel it beneath your feet. Just getting here is an experience that you will always remember. Especially the welcome committee that often comes and greets our guests. Vancouver Island is a great place to come together, to celebrate 20 years of love, or a birthday over a great meal, or even just a local brew down the street. It's a place for the curious and the brave, for the ones that want to get away from it all, and the ones that journeyed years of life together, or the bold ones who dare to do something they've never done before. Come and discover Vancouver Island. This is a place where you can dive right in. It's a place where you can get a front row seat to one of the most amazing wildlife encounters. Witness the beauty of our magical oceans, lakes, and rivers that are displayed throughout the island. Or play along miles and miles of fantastic beaches, or even find the love of your life. Come and book your adventure today.
Meet up in my hometown, guys. Y'all want to come? Does it look good? How did Nana decide to move here? Well, I know it sounds like I'm sort of full of myself, but I'm not actually kidding when I explain, like, it's the best place in Canada. If you do any amount of research, any amount of like realization, like, there's no winter in the sense of snow. There's no, um, for the most part, at like, and there's good weather, but it's not super hot. There's always ocean breeze. You've got surrounding ocean and beautiful skies all the time for the most part. You've got very, very clean air. Very, very clean air. And when you realize, like, a lot of cities, and I guess as in the US, a lot of cities are not very friendly to their inhabitants, but here, in a lot of parts of the city or in certain towns, like, you can really get along in an area in a nice way and live in a beautiful area without, like, downtown where I live, you can do walking distance and you don't even need a car. A lot of people say it's like a walking city or a biking city. It is and it isn't, but it is very much more trans hmm, transversable than other cities I've been to in the world. I've been to many cities. I've done lots of tours. I've not only gone on many walking tours, but I've created walking tours. And we do have a good town for that. But uh, it is a small town in some senses. That's the other thing, is like it's pretty small town feel. So, um, but there's like this big break at nighttime between like 10 and midnight. So like it's sort of dead. And then all of a sudden it turns into a university town, a party town at late at night. Because all the kids go to the bar and everyone goes to the bar really late here. You would never go to a bar like before 10 o'clock or 10:30 if you were going to go to a bar. Which to me nowadays is like ridiculous. I'm like, what the fuck? I want to get much more done before 10:30 at night. But anyways, okay, friends, I love you all. I hope you have a wonderful evening. I know I've been rambling. I gotta get going. I hope you have wonderful days, wonderful nights, wonderful dreams, wonderful sights. I will talk to you tomorrow, and I can't wait for what more we get to figure out together. Please leave 30 seconds for the tape delay. Kitchen is closed. Bye.